In this matter, my lords, the parties have taken back the file. They want to engage some senior advocate along with NOC, my lords.
ಏನಾಗಿದೆ?
It's similar to detention order under the Gunda Act.
ಕೆಳಗಡೆ ಇದು illegal detention.
Illegal.
ಗುಂಡಾ ಕೆಳಗಡೆ.
According to me, my lord, it's clearly covered by my lord's order. All the
How habeas corpus petition is maintainable?
ಇಲ್ಲ ಅದು ಇವರು ಒಂದು ಆರ್ಡರ್ ಮಾಡಿದ್ರು.
ರಿವರ್ಸ್ ಆಯ್ತು ಅದು ದೇವರಾಜ್ ಸಾಹೇಬರ ಜಡ್ಜ್ಮೆಂಟ್.
ಅವರು following the Supreme Court judgment. But the Supreme Court also, my lord, in 3 judge bench, my lord, in
ಯಾವತ್ತು ಮಾಡ್ತೀರಿ?
please.
Let's, I request this honorable court, kindly give me 2 weeks time, let's. In the meantime, let's.
3 weeks. Call after 3 weeks.
Please, let's. In the meantime,
At the request of counsel for the petitioner.
Oblate.
Two, SS Seliga.
Respondent.
ಏನು ಅವ್ರು ಯಾರು ಬಂದಿಲ್ವಾ?
SS Seliga.
ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡೋದ ನೋಡೋಣ.
Please.
ಕಾಂಟ್ರಾಕ್ಟ್ ಮುಗಿಸಿ ಬರ್ಕೊಂಡ್ಬಿಟ್ರೆ ಈಸಿ ಆಗುತ್ತೆ.
ಅಷ್ಟೇ ಬೇರೆ ಅವ್ರು ಬಂದ್ರು ಅವರೇ ಬರ್ಲಿದ್ರೆ ಮಾಡಬೇಕು.
3 ಹರೀಶ್ ಮೈಗು.
So,
Yes.
Fracture of both the bones of both the legs, my lord. Right leg and left leg. And apart from that, my lords, he has sustained C3, C4, C4, C5, C5, C6 cervical spine diffuse disc injury, my lords. My lords, may kindly turn to page number, my lords, para 20, page 23. My lords, the doctor PW2 has stated that 35% to the right lower limb and 35% to the left lower limb. And
Paragraph number
20. Please.
How much doctor has said total?
Doctor has stated, my lords, 35% to the right lower limb, 35% to the left lower limb, and 10% to the lumbar spine. Tribunal has taken 33% to the whole body. By taking the income at 10,000 per month.
ತಾವು ಯಾತ್ರಲ್ಲಿ ಎದುರು
ಯಾವ ಹೆಡ್ ನಿಮಗೆ ಕಡಿಮೆ?
My lords, may kindly see disability is on the lower side. Since
he is not treated doctor.
not treated. Yes, my lords, on the basis of injuries, my lords, may lumbar spine.
Yes sir.
Sir, Angli Melo.
Allah, lumbar spine, my lords, it is one of the major. Allah,
ಎಷ್ಟು ತಗೋಬೇಕು?
My lord, in fact, this is sufficiently awarded. ಇದು ಕಡಿಮೆ ಅಂತ ನಾನೇ ಹೇಳ್ತಿದ್ದೆ. Parents suffering has given.
ಅಲ್ಲ ಇದು ಡಿಸಬಿಲಿಟಿ.
Allah, my lord, is in fact it is on higher side, my lord, because when the treated doctor is available in the Belgaum itself.
Any explanation given why treated doctor was not examined? No explanation.
no. My lords, any one of the qualified medical practitioner, my lords, that is sufficient. My lords, even on the basis of
ಇನ್ಕಮ್
10,000 has been taken.
ಕರೆಕ್ಟಾ?
10,250 ಬರುತ್ತೆ.
10,250 ಆಗುತ್ತೆ.
Chart value.
How?
ಮಲ್ಟಿಪ್ಲೈಯರ್
16 is correct.
16.
And my lords, my submission is that my lords, tribunal ought to have added future prospectus.
ಅಲ್ಲ ಈ
Allah,
nature.
please let me submit. Both the bones of both the legs, my lords. I have
Amputated or fractured?
fracture. Both the bones of both the legs. Photographs is also produced at exhibit P11. And apart from that, lumbar spine. For lumbar spine, it cannot be 1/3. It is one of the major bone on whole entire body has stand, my lords. Please.
That version, we have to give discount to the version of the doctor because he is not a treated doctor.
Yes, I do admit.
And number 2, the stature of the doctor also. We will not say more than that.
Allah, at least, my lords, considering the nature of injuries, my lords ought to have considered functional disability. And even apex court, for 20% disability has taken.
How many days he was in?
11 days, my lord.
12 days. Vijaya Hospital, Belagavi, from 8/7/2017 to 19/7/2017.
Conveyancing attendance. ಇದೊಂದು ಸ್ವಲ್ಪ ಹೆಚ್ಚು ಮಾಡ್ಬೋದು, ಒಂದು 20,000. Loss of earning during the treatment period, into 4 months ತಗೋಬಹುದು. Into 4. Loss
Well-
of amenities ಒಂದು 10,000 ಹೆಚ್ಚು ಮಾಡಿ. 35% ಮಾಡ್ತೀವಿ.
ಅಲ್ಲ, ಲೆಟ್ ಮಿ ಸಬ್ಮಿಟ್. ಅಲ್ಲ, ಒಂದೇ ಒಂದು ಸೆಕೆಂಡ್ ಫೋಟೋಗ್ರಾಫ್ಸ್ ತೋರಿಸ್ಬಿಡ್ತೀನಿ ಸರ್.
ಫೋಟೋಗ್ರಾಫ್ ಇಂದ ಏನ್ ಗೊತ್ತಾಗ್ತದೆ?
ಅಲ್ಲ, at least kindly see my lords.
I will tell you, Mr. Maigor, he is not a treated doctor.
Yes, I do it.
Stock
But
doctor.
my lords, my.
Third one is, it creates a doubt, and we don't have any expertise in the field. Kind of a guesswork.
My lords has, my lords,
Note of it.
my lords ought to have come to the conclusion. My submission is that, my lords, the court has got a power to assess disability.
Reserve it. Reserve. Yes, next. Tomorrow, judgment tomorrow. Next.
Fourth, Manjunath G. Patil.
Claimant's appeal, a case of death, my lords. The two vehicles are involved, my lords. 70% on the insurance company, my lords, 30% on the deceased, my lords. So I have not pressed the 30%,
30.
70-30, my lords.
You are challenging the liability also?
No, my lords, I have not pressed that ground, my lords, I have made it.
Good.
And my lords, the deceased is aged about 25 years as per DL, my lords. As per DL,
25 years,
25, my lords.
DL.
And my lords, the income as taken by the Honorable Tribunal, my lords, 9,000, my lords. Since, my lords, he is a driver, my lords, that has been forthcoming in the exhibit P8, and also DL has not been produced, even in the mentioned in the DL numbers also in the exhibit P8, my lords.
Exhibit?
P8,
Copy of the police notice ಇದೆ.
police notice. Yes, other DL is a driver. At the time, two vehicles are involved, my lords. As on the, at the time of accident, he was driver.
Income, as per chart, what is it?
Under 8,750 Act.
ಮತ್ತೆ
9,000.
ಯಾವ year accident?
Accident took place in the 2016, but he is a driver, heavy transport vehicle.
ಎಲ್ಲಿದೆ? ಎವಿಡೆನ್ಸ್ ಬೇಕಲ್ಲ. ಡ್ರೈವರ್.
ಈ heavy transport vehicle license is.
ಪ್ರೊಡ್ಯೂಸ್ ಹಜರ್ ಮಾಡಿಲ್ಲ. ಯಾವ್ದ್ರಲ್ಲಿ? ನೋಟಿಸ್ ಅಲ್ಲಿ ಬಂದಿ. 2016 ಹೆವಿ ಇದ್ರೂ ಎಷ್ಟು ಬರುತ್ತೆ? ಯಾರು? Nobody is there? Who appears?
R.R. Mane.
ಮನೆಯವ್ರು ಹಿಸಿದಲ್ಲಿ ಬರ್ತಾರಾ? ಏನು? ಲಯಬಿಲಿಟಿ ಬಿಡ್ತಾರೆ. ಒಂದು ಇನ್ಕಮ್ ಒಂದೇನಾ?
Income, my lords.
ಮತ್ತೆ
And
age-
also multiplier is taken by the tribunal as is, my lords. 17 has been taken instead of 16, 15, 18, my lords.
ಎಲ್ಲಿದ್ದಾರೆ?
We need not wait for the respondent. We have to wait for the appellant. Only we have option is when appellant is absent, we can dismiss the appeal, but we can't decide the matter on merits. In absence of a respondent, we can run the show.
Counsel for the appellant.
We can't wait for them to come here.
He will not press the ground of appeal insofar as challenging the liability is concerned.
Since charge sheet filed also,
They said submission is placed on record. Insofar as entitlement compensation is concerned, the tribunal has assessed the income of the deceased, alwa?
Deceased.
9,000 per month, taking note of the fact that the deceased was a driver of heavy vehicle. It would be just and appropriate to assess notional income of the deceased at rupees 12,000 per month. Considering the age of the deceased, as per the
as per the PM report, 26, my lords.
report, 26,
Please,
tribunal has assessed the, considered the age as 26 years. 25 ಅಂತ ಹೇಳ್ತೀರಾ ಮತ್ತೆ?
as per DL, 25, my lords.
However, as per the driving license, his age is 25 years. Hence appropriate multiplier would be
18.
18. Hence the compensation is reassessed as under loss of dependency, 12,000 into 12
40
into multiplier ಎಷ್ಟು?
Multiplier 18, my lords, 40% future prospect.
Plus 40% future prospects are add ಮಾಡಬೇಕು. Deductions?
1/4, my lords. 1/4.
1/4. 3 ಜನ ಇದಾರಲ್ಲ?
Andra, respond number 6 also wife, my lords.
Respond number 6.
6. She is wife.
There are 4 dependents, claimant number 1, 2, 3 and respondent number 6, wife of the deceased. Hence appropriate deduction would be 1/4. Each of the Claimant and the respondent number 6 are entitled consortium at the rate of
40,000.
44,000 with 10% escalation. ಬರ್ಕೋಬೇಕು. 16,500, 16,500. The insurer is liable to 70% of the total compensation. Compensation amount carries interest at the rate of 6%. Case disposed of. ಮನೆ ಅವ್ರಿಗೆ ಹೇಳ್ತೀರಾ?
Please.
Please inform.
5 Manjunath Jadai.
It's a case of injury, my lords, aged about 14 years, my lords. As the doctor, treated doctor has assessed to the 81
14 years. 14 years.
14 years, my lords.
Master Mallikarjuna.
Please, the test.
My lords, it's not applicable Master Mallikarjuna case, my lords. It's a severe head injury, my lords. Kindly see the exhibit applicable 3, my lords.
Records ಬರಲಿ. All 40.
Records?
ಏನೋ ಒಂದು ರೀಸನಬಲ್ ಹೇಳ್ಕೊಂಡು ಮುಗಿಸಿ ಮತ್ತೆ 2 ವರ್ಷ 5 ವರ್ಷ
No, my
ಕೂಡ್ಸೋ
lords. It's a severe head injury.
Mallikarjuna ಅಂದ್ರೆ the percentage
Is
is
applied,
fixed.
Millard,
On that we have to-
ಫಿಕ್ಸ್ ಆಗಿದೆ.
To 4 lakhs, Millard, under the head disability and the loss of
ಹೌದು maximum ಕೊಡ್ಬೋದು.
maximum that.
ಎಷ್ಟು ಪರ್ಸೆಂಟ್ ಹೇಳಿದ್ದಾರೆ ಡಾಕ್ಟರ್?
81.46, my lord. 81.46.
30 ಪ್ಲಸ್ ಬೇಕಲ್ಲ? 30% ಅಬೌವ್ ಇದ್ರೆ
30% consider ಮಾಡಿದ್ದಾರೆ tribunal.
ಮಾಡಿದಾರಾ?
Please.
ಗೊತ್ತಾಯ್ತಲ್ಲ, ಅದಕ್ಕೆ ಹೆಚ್ಚು ನಾವು ಮಾಡಕ್ಕಾಗಲ್ಲಲ್ಲ.
My lords.
To 4 lakhs, Millard, if that is applied, that can be given. In addition to that, medical expenses, what is already awarded by MSCT.
ಎಷ್ಟು
And
ಮಾಡಿ?
that 12 lakh, 9 lakhs, 64,000 tribunal has awarded.
Kindly see PW3 statement, my lords, of the doctor, treated doctor. my
ಅಲ್ಲ
lords.
ಹೆಡ್ ಇಂಜುರಿ ಆದ್ರೆ ಮಲ್ಲಿಕಾರ್ಜುನ್ ಅಪ್ಲೈ ಆಗಲ್ಲ ಅನ್ಕೊಂಡು ಯಾವ್ದಾರ ಹೋಲ್ಡ್ ಮಾಡಿದೀಯಾ?
Yes, my lords.
ಯಾವ್ದು?
Kindly pass over my salary.
ಏನ್ ಪ್ರಿಪರೇಷನ್? ಎಲ್ಲ ರೆಡಿಯಾಗಿ ಬರ್ಬೇಕು. ಇದು ವಾರ್ ಆಫ್ ವಿಟ್ಸ್.
ಎಷ್ಟು ಫಾರ್ ಫೈನಲ್ ಇಯರ್?
After 3 weeks. Please.
6
ಇದು ಮುಗಿಸ್ಲಿಕ್ಕೆ ಒಂದು ಐದು.
ಅದೇ 5 ನಿಮಿಷ.
Andarpalli.
ಮಕ್ಕಳು.
Claimant's appeal for enhancement matter is case of injury matters. That's the fracture of slight malunited matters. The tribunal has taken the disability matters 5% to the whole body. Doctor has been assessed 35% to the particular limb and 15% to the whole body.
ಯಾವ ಡಾಕ್ಟರ್?
That's PW3 matters.
ಟ್ರೀಟೆಡ್
HR,
ಡಾಕ್ಟರ್?
treated doctor.
Non-treated,
ನಾಟ್ ಟ್ರೀಟೆಡ್.
not.
ಮತ್ತೆ ಏನ್ ಎಕ್ಸ್ಪ್ಲನೇಷನ್? ವೈ ಟ್ರೀಟೆಡ್ ಡಾಕ್ಟರ್ ವಾಸ್ ನಾಟ್ ಎಕ್ಸಾಮಿನ್ಡ್? ವೇರ್ ಇಸ್ ದಿ ಎಕ್ಸ್ಪ್ಲನೇಷನ್ ಆಫರ್ಡ್ ಫಾರ್ ದಟ್? Then doctor's evidence discount ಆಗ್ತದೆ. You have to give reason that doctor went abroad, doctor is no more. Some reason ಬೇಕಲ್ಲ. When there is such a doctor, why you did not examine him? That gives a lot of doubt.
Next, other than that,
Next is.
disability ಆದ್ಮೇಲೆ
Other
income is
matters.
correct?
Yes.
ಎಷ್ಟು?
Income is
Income
considered
9,000.
9,000.
Correct. ಹಾ.
As per the Khalsa, it is 8,750.
ಇರ್ಲಿ ಬಿಡಿ,
However, the
ನಿಮ್ದು
court
ಏನ-
below has considered 9,000.
ನಿಮ್ದು ಅಪೀಲ್ ಇಲ್ಲಲ್ಲ ಬಿಡಿ.
Hello?
ನಿಮ್ಮ ಅಪೀಲ್ ಇಲ್ಲಲ್ಲ ಬಿಡಿ.
Even then I have right to defend the case.
ಇರ್ಲಿ injured
And submit to the
ಎಷ್ಟು ಕೊಟ್ಟರೆ ಕಡಿಮೆ ಆಗತ್ತೆ ಬಿಡಿ, ಇರ್ಲಿ.
Pain and suffering 5,000.
My lord, another 25,000 under the head of pain and suffering.
Total 40,000,
Allah, sir. Okay. Under amenities, my lord.
30,000
Addition, my lord.
total. Total I am talking.
Okay.
ನೀವು ಹೇಳೋದಕ್ಕಿಂತ ಕಡಿಮೆ.
ನೋಡಿ 5,000
ಆಯ್ತು sir.
5,000 ಆಯ್ತು, 40,000 ನೋಡಿ ಕೇಳ್ಕೊಂಬಿಡಿ. ಮೆಡಿಕಲ್ expenses as it is, loss of amenities 30,000, loss of income during the treatment period
3 months ತಗೋಬೇಕು.
same as it is. Attendance charges, food, nourishment, transportation ಎಲ್ಲ
Another 10,000.
ಎಲ್ಲ ಸೇರಿ 15,000, ಮೂರು ಸೇರಿಬಿಟ್ಟು
Aye.
ಆಯ್ತಾ?
Aye. Under the,
8% disability.
my lord, under the head of loss of income during the laid-up period, 3 months, my lord, another 9,000 is to be added.
Added.
18,000 pound.
9 into 3.
As against, I have calculated 69,000, it is 79.
Loss of dependency, ಇದು sorry, loss of income due to disability, 9,000 into multiplier ಎಷ್ಟಿದೆ?
18 minutes.
18 into 12 into 8%. ಏನೇನು ಸರ್ ಹಿಂಗೆಲ್ಲ ಬರೆದು ಬಿಟ್ಟಿದ್ದೀನಿ. ಇದು 27,000 ಎಲ್ಲ ಬರೆದಿದ್ದೀನಿ, ಮೂರು ಸೇರಿ
With 6% interest.
6%.
6% interest.
Obliged.
7, Susai Empati.
Please, ma'am. There was a direction from the court to pay cost to legal service authority. By mistake, I have paid to library fund, ma'am. So it may kindly be accepted.
Learning counsel for the appellant submits that he has paid cost of rupees 3,000 to the
Library fund, advocates library fund.
Advocates Library Fund. Said submission is accepted.
There is delay of 2 days, ma'am. Notice may kind.
Held as per the order dated 27/6/2024 is held correct.
There is delay of 2 days in filing this appeal. It is pertaining to the civic communities. So we had relied on the judgment of this honorable court. And writ appeal is challenged before Supreme Court. Same is pending. So I request honorable court to delay, notice may kindly be issued.
There's one main.
Please.
Dispensation allowed for the time being. But accepting cost of dispensation allowed for the time being.
Please.
8, Narkupenu.
I appear for, my lord, the appellants in, there are, my lord, contempt petitions are there and also writ appeals are there. We have filed the writ appeals.
Writ appeals ಇದೆಯಾ? 8.4
ಕೆಳಗಡೆ ಇದೆ ನೋಡಿ ಸುಮ್ಮನೆ.
4.5.
8.4 ಇಂದ ಇದೆ. 8.4, 8.5 and then
ಕೂತ್ಕೊಳ್ಳಿ.
8.7.
Argue the appeal.
My lord, I will argue in one case, my lord, because that will be fairly.
As it is ಆಗಿಬಿಡತ್ತೆ.
Please.
ಉಳಿದವಕ್ಕೆಲ್ಲ ಸೇಮ್ ಆಗತ್ತೆ. ಕಾಮನ್
ಅಲ್ಲ, same, similar, my lord, question of law is involved. And my lord, the matter is pertaining to grant of land to the ex defense personnel. My lord.
ಹಾ.
My lord, may I request your lordship to take 8.7.
8.7.
That is writ appeal number 100623 of 2023.
ಹಾ.
I think writ appeal copy ಇಲ್ಲ ಅಂತಾರೆ ಇವರು. I think it is solved. My friend says you don't have writ appeal copy. ಇಲ್ಲ, extra ಇಲ್ಲ.
ನೋಡೋಣ ತಿರಿ.
Please.
You appear for respondent.
Please.
ಅಲ್ಲ. ಸರ್ವ್ ಮಾಡಿಲ್ಲ ಅಂತಾರೆ ಅವ್ರಿಗೆ. Shall I continue or?
Continue.
Only after.
No, if at all it
Please,
comes to.
please,
the question does not arise.
My lord, the impugned order, my lord, is at.
Documents have been served. Please.
ಆಗಿದೆ.
Documents only have been served.
ಕೊಟ್ಟಿದ್ದಾರಾ?
Memo of appeal.
ಆಯ್ತು ಕೂತ್ಕೊಳ್ಳಿ.
Please.
Be seated. Please be seated. ಹಾ.
My lord, the impugned order, my lord, is at ink page 12. My lord, there the direction issued, my lord, the order passed by the learned single judge is, my lord. I will take
What is the wrong with this order? They are all defense personnel.
Please, my lord.
They have guarded our frontiers of the country.
It's not denied, my lord. It is admitted
Therefore,
fact. It
yes.
is admitted.
What are
The only
legal-
fact is, my lord, the lordship has directed to grant land in particular survey numbers.
Yes.
Those survey numbers are the Goma lands.
Yes.
So it will be against the provision of the act and orders of this honorable court. That is, we are unable to implement this order. That's the gist of the case, my lord.
ಈಗ ಸೋಲ್ಜರ್ಸ್ಗೆ ನಮ್ಮ ಸೈನಿಕರಿಗೆ ಜಮೀನನ್ನು ಕೊಡುವಾಗ
ಅಲ್ಲ, ಅದಕ್ಕೆ wherever land is not available for grant, site ಕೊಡಬೇಕು ಅಂತ ಗವರ್ಮೆಂಟ್ ಆರ್ಡರ್ ಆಗಿದೆ ರೀಸೆಂಟ್ ಆಗಿ. We have offered site.
ನೀವು ಯಾರಿಗೂ ಗೈರಾನ ಲ್ಯಾಂಡ್ ಅನ್ನು ಯಾರಿಗೂ ಅಲಾಟ್ ಮಾಡಿಲ್ವಾ? ರೆಕಾರ್ಡ್ ಮಾಡ್ಕೊತೇನೆ
ಇಲ್ಲ. ಇಲ್ಲಿ
ಅಫಿಡವಿಟ್ ಹಾಕಿ. ಇಡೀ ಸ್ಟೇಟ್ ನಲ್ಲಿ ಗೈರಾನ ಲ್ಯಾಂಡ್ ಅನ್ನ ನಾವು ಯಾರಿಗೂ ಅಲಾಟ್ ಮಾಡಿಲ್ಲ ಅನ್ಕೊಂಡ್ ಒಂದು ಅಫಿಡವಿಟ್ ಹಾಕಿ.
ಅಲ್ಲ,
Then we will take action.
ಅಲ್ಲ, that I don't know whether
Therefore you
land
should
is
know.
not, but in this district,
No question of district.
no
It is a
land is
policy.
available.
Therefore we are asking, you file an affidavit saying that we have not allotted Gairana land to anybody in the whole of state. Then we'll look
Whole of
at
state ಅಲ್ಲ ಸ್ವಾಮಿ.
whole of state. ಬೇಕು
ಇಲ್ಲಿ
ನಮ್ಗೆ.
ಈ district ಅಲ್ಲಿ deputy commissioner has filed an affidavit.
Makes
before the
no
London
sense.
city.
Makes no sense. Allotment of lands to the soldiers. ನಮ್ಮ ಸೈನಿಕರು ಸಾಯ್ತಿರ್ತಾರಲ್ಲಿ ಬಾರ್ಡರ್ಸ್ ನಲ್ಲಿ. ನಿಮ್ಗೆ ಬೇಕಾದವರಿಗೆ ಎಲ್ಲಿ ಬೇಕು ಲ್ಯಾಂಡ್ ಕೊಟ್ಕೊಂಡು ಸೈನಿಕರಿಗೆ ಕೊಡಬೇಕು ಅಂದಾಕ್ಷಣ ಇವೆಲ್ಲ ಸಮಸ್ಯೆ ಆಗ್ತದೆ ನಿಮಗೆ. Therefore, if you want to justify your contention, ಒಂದು ಅಫಿಡವಿಟ್ ಹಾಕಿ. ಇಡೀ ರಾಜ್ಯದಲ್ಲಿ ಕಳೆದ 15 ವರ್ಷದಲ್ಲಿ ನಾವು ಗೈರಾಣ ಲ್ಯಾಂಡ್ ಅನ್ನ ಯಾರಿಗೂ ಕೊಟ್ಟಿಲ್ಲ ಹಾಕಿ.
ಇಲ್ಲ ಹಂಗ ಹೇಳಕ್ ಬರಲ್ಲ ಸ್ವಾಮಿ, ಬಿಕಾಸ್ my lord, ನಾನು ನಿಮಗೆ ಒಂದು ಸಿನಾಪ್ಸಿಸ್ ಕಳಿಸ್ತೀನಿ. There are rules, my lord, we have to follow the rules. My lord, ಎಲ್ಲ ಒಂದ್ ಕಡೆ ಹಾಕಿದ್ನಲ್ಲಪ್ಪ.
ನಿಮ್ಮ ಫಸ್ಟ್ ಗ್ರೌಂಡ್ ಏನು ರೆಡ್ಡಿಗಾರು ಗೈರಾಣ ಲ್ಯಾಂಡ್ ಅನ್ನ ಸೈನಿಕರಿಗೆ ಕೊಡಲು ಬರುವುದಿಲ್ಲ, ಕರೆಕ್ಟಾ?
ನಮ್ಗೆ ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ ಸ್ವಾಮಿ, ಲ್ಯಾಂಡ್ ಅವೈಲೇಬಲ್ ಇದ್ರೆ ಕೊಡ್ತೀವಿ.
ಅಲ್ಲ
ಬಟ್ land availability illa anda, that is the whole problem. We have filed affidavit before the London single judge, but still, my lord, the London single judge are direct.
ಕರೆಕ್ಟ್ ಇದೆ, ಲರ್ನಡ್ ಸಿಂಗಲ್ ಜಡ್ಜ್ ಕರೆಕ್ಟ್ ಹೇಳಿದ್ದಾರೆ. ಅದು ತಪ್ಪು ಅಂತ ತೋರಿಸ್ಬೇಕು ನಮಗೆ. ಅದನ್ನ ತೋರಿಸೋದಿದ್ರೆ ಈ ಪ್ರಶ್ನೆಗೆ ಉತ್ತರ ಕೊಡಬೇಕು. ಇಡೀ ರಾಜ್ಯದಲ್ಲಿ ಕಳೆದ 15 ವರ್ಷದಿಂದ ಈ ಗೈರಾಣ ಲ್ಯಾಂಡ್ ಅನ್ನ ನಾವು ಯಾರಿಗೂ ಕೊಟ್ಟಿಲ್ಲ. ಅಫಿಡವಿಟ್ ಹಾಕಿ. ನಿಮಗ್ ಬೇಕಾದವ್ರಿಗೆ ಕೊಡ್ತೀರಿ, ಬೇಡಾದವ್ರಿಗೆ ಕೊಡಲ್ಲ. ಆ ರೀತಿ ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ. ಆ ರೀತಿ ಈಗಾಗಲೇ ಅಲ್ಲಿ ಸಾಯ್ಲಿಕ್ಕೆ ಬಿಟ್ಕೊಂಡು ಇಲ್ಲಿ ಹೆಂಡತಿ ಮಕ್ಕಳ ಗತಿ ಏನು? Nobody will come forward for protecting the country tomorrow.
No, my lord. The rule provides, my lord, I will take your lordship to the rules. How the, ಇದು ಕೊಡ್ರಿ, rule 8, grant, land grant rules 8.
ಬೇರೆ ದೇಶದಲ್ಲೆಲ್ಲ ಸೈನಿಕರಿಗೆ ಎಷ್ಟೊಂದು ಗೌರವ, ಎಷ್ಟೊಂದು ಪ್ರೊಟೆಕ್ಷನ್.
My lord, we have got highest respect. ಅದ್ರ ಬಗ್ಗೆ
Please listen, please listen.
Yes.
Answer our question.
ನಾನು affidavit ಹಾಕ್ತೀನಿ ಸ್ವಾಮಿ. How it has been done ಅಂತ. I will show that.
Learned additional advocate general appearing for the appellant submits that the impugned order of the learned single judge is bad in as much as it directs grant of Gairana land to the defense personnel. First, at this stage, we want to know whether any Gairana land has been granted to anyone.
ಈ district ಗೆ ಕನ್ಸಿಡರ್ ಮಾಡಿ.
Please do not say like that. District ರಾಜ್ಯ ಅಲ್ಲ, ನಮಗೆ ರಾಜ್ಯ ಇದೆ. ಈ ಊರಲ್ಲಿ ಕೊಟ್ಟಿಲ್ಲ ಅಂದ್ರೆ ಬೇರೆ ಊರಲ್ಲಿ ಕೊಟ್ಕೋತ ಹೋಗ್ತೀನಿ ಅಂತಾನ?
If land, the ground reality of this district, we all
All right, you argue this. Anyone in the state, in the state, in the last 20 years, amendment yavat bantu? When the amendment came?
27/10/2021.
27/10/2021. 2021.
This amendment is, my lord, a
During
result
the
of
pendency
contempt
of-
proceedings. When contempt notice was issued, my lord, this
That makes no sense. Rule is a rule. Call this matter, next week, what do you want date? 18. No further time will be granted.
Make one more submission. I have filed a pleading application. I'm a Gram Panchayat, my lord.
How you are concerned with that? The application filed by the Gram Panchayat seeking impediment is liable to be rejected in view of decision of apex court in Rajia Begum versus Shahnaz Begum, 1958, Supreme Court. Since the Gram Panchayat is neither a necessary party, nor a proper property, nor a desirable party. First, shall we impose cost? We want to impose cost because many such cases are coming. You are irrelevant to you. How you are concerned with this?
We have also filed a writ petition. seeking mandamus.
Anyway,
Our
you
application
fight
for grant of land mallards is still
rejected. Next.
Please.
ಸೈನಿಕರಿಗೆ ಲ್ಯಾಂಡ್ ಕೊಡೋದಂಗೆ ಇನ್ಯಾರಿಗೆ ಕೊಡ್ತೀವಿ? ಯಾವ್ದು ಬೇಕಾದಕ್ಕೆ ಲ್ಯಾಂಡ್ ಕೊಡೋದು? ಎಲ್ಲ ಇರುವಂತ ಲ್ಯಾಂಡ್ ಬ್ಯಾಂಕ್ ಅನ್ನೆಲ್ಲ ಹಾಳು ಮಾಡಿ ಹಾಕಿರಿ ಸ್ಟೇಟ್ನವ್ರು. ಸಾರಿ ಟು ಸೇ ದಿಸ್. ವಿ ಆರ್ ಸಾರಿ ಟು ಸೇ ದಟ್ ದೇರ್ ಆರ್ ಸಚ್ ಜಜ್ಮೆಂಟ್ಸ್ ನಾವು. ಎಷ್ಟು ಕಡೆ ಸೆಟ್ ಅಸೈಡ್ ಮಾಡ್ತಾ ಇದ್ದೇವೆ ನಾವು ಮಾಡ್ಕೊಂಡಿದ್ದನ್ನ. ಎಲ್ಲ ಫಾರೆಸ್ಟ್ ಲ್ಯಾಂಡ್ ನಲ್ಲಿ ಕೊಡೋದು. ಸುಪ್ರೀಂ ಕೋರ್ಟ್, ಆನರಬಲ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹೇಳಿದೆ ಫಾರೆಸ್ಟ್ ಲ್ಯಾಂಡ್ 1 ಇಂಚ್ ಲ್ಯಾಂಡ್ ಅನ್ನು ಬಿಡಬಾರ್ದು, ಕೊಡಬಾರ್ದು ಅಂತ ಹೇಳಿದೆ. ಅಂತವನ್ನ ಕೊಟ್ಕೋತ ಹೊಟ್ರಿ. ನಂತರ ಬೇರೆ ಬೇರೆ ಪಬ್ಲಿಕ್ ಲ್ಯಾಂಡ್ ಅನ್ನ ಎಲ್ಲರಿಗೂ ಕೊಟ್ಕೋತ ಹೋಗೋದು, ಆ ರೈತರ ಲ್ಯಾಂಡ್ ಅನ್ನು ಎಕ್ವೈರ್ ಮಾಡಿಕೊಳ್ಳೋದು. ಆಮೇಲೆ ಏನು ಹುಡುಗಾಟಿಕೆ ನಡೆಸಿರಿ ಎಲ್ಲ ನೀವು.
ಡಿವಿಷನ್ ಬೆಂಚ್ ಆಫ್ ದಿಸ್ ಆನರಬಲ್ ಕೋರ್ಟ್ ಹ್ಯಾಸ್ ರೆಸ್ಟ್ರಿಕ್ಟೆಡ್.
ಇದೆ ನಮ್ಮ ಮುಂದೆ ಕೇಸ್ ಈಗ 900 ಆಡ್ ಕೇಸಸ್ ಇದಾವೆ. ರೈತರು ಲ್ಯಾಂಡ್ ತಗೊಂಡು ಕಾಂಪನ್ಸೇಷನ್ ಕೊಟ್ಟಿಲ್ಲ. ಒಂದ್ ಸ್ವಲ್ಪ ಲಿಮಿಟ್ ಇರ್ಬೇಕು. ಸರ್ಕಾರ ನಮ್ದು ಕಲ್ಯಾಣ ರಾಜ್ಯ, ಆ ಪ್ರಕಾರ ನಡ್ಕೋಬೇಕು. ಸೈನಿಕರಿಗೆ ಕೊಡಲ್ಲ ಅಂದ್ರೆ ಇನ್ಯಾರಿಗೆ ಕೊಡ್ತೀವಿ?
I'll place my lord, everything my lord.
Since 1961, my lord, this is land, this land in question is Sarkari Pada, my lord.
Next.
9, Girish Dharwad.
Prepare for the complainant.
My lord, I have paid an appeal, my writ appeal, my lord.
Connected writ appeal is filed by the, my lord, respondent in the writ petition. Contemporary complaint is the petitioner.
But
this matter, my lord, had come up before my lords, and for few minutes, my lords are pleased to hear. This relates to, my lord, pay protection of the personal below officer's rank. Learned single judge has directed, my lord, to compute the salary and prefix it. Order, my lords, would find at page number 110, operative portion. I'm referring to my contempt petition, my lord, page number 110.
Writ appeal, my lord, it is at page number 13.
First contempt.
Serial number, page number.
Writ appeal, page number 13.
13.
13. Writ appeal.
Reasoning ಎಲ್ಲಿದೆ?
Please. Paragraph number 7 in the start. May I read? Copy put.
ಇಲ್ಲ ಇಲ್ಲ ಪೇಜ್ ನಂಬರ್ ಕೊಟ್ಟಿರ್ಬೇಕಲ್ಲ ಪೇಜ್ ಮಿಷನ್ ಆಗಿಲ್ಲ.
ಆಬ್ಜೆಕ್ಟ್ ಆಫ್ ದ ಪಾಲಿಸಿ ಏನು ಅಂದ್ರೆ, ಅವರೆಲ್ಲ ಡಿಫೆನ್ಸ್ ಪರ್ಸನೆಲ್.
ಎಸ್,
ಅವರೆಲ್ಲ ನಮ್ಮ ರಾಜ್ಯ ದೇಶದ ಗಡಿಯನ್ನು ಕಾಯ್ದಿರ್ತಾರೆ, ಸರ್ವಿಸ್ ಮಾಡಿರ್ತಾರೆ ಅನ್ಕೊಂಡು ಒಂದು ಸ್ಪೆಷಲ್ ಟ್ರೀಟ್ಮೆಂಟ್ ಇರ್ತದೆ ಅವ್ರಿಗೆ. ಏನು, ಅವರು ಡಿಫೆನ್ಸ್ ಸರ್ವಿಸ್ ನಲ್ಲಿ ಇದ್ದಾಗ ಅವರ ಲಾಸ್ಟ್ ಡ್ರಾನ್ ಸ್ಯಾಲರಿ ಏನಿದೆ ಅದಕ್ಕಿಂತ ಕಡಿಮೆ ಸ್ಯಾಲರಿ ಕೊಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ ಅನ್ನೋದು ಬ್ರಾಡ್ ಪಾಲಿಸಿ. ದಟ್ ಇಸ್ ದಿ ಪಾಲಿಸಿ. ದೇರ್ ಆರ್ ಸಚ್ ಜಜ್ಮೆಂಟ್ಸ್. ಇದರಲ್ಲಿ ಏನ್ ತಪ್ಪಿದೆ?
ಇದರಲ್ಲಿ ಅಲ್ಲ, ಅವರು ಅಪೀಲ್ ಹಾಕಿದ್ದಾರೆ.
ಅಲ್ಲ ಮೇಲೆ
I am the petitioner.
What is wrong with this order?
Because the protection should be given to the ex-serviceman when he is employed in a civil service.
Correct.
Then what are the factors is required taken into consideration ಅನ್ನೋದು ಪ್ರಶ್ನೆ ಇಷ್ಟ ಇದರಲ್ಲಿ. What are the components which are required to be taken into consideration? And I have been governed by the provisions of the circulars issued by the Department of Finance. And kindly, my lord, at annexure, I'll annexure E, my lord.
Page
number 65, my lord.
65.
65, my lord, of the writ appeal. I'll take my lord's attention to page number 67, 2.1.
2.1.
2.1, ಅದರಲ್ಲಿ more particularly Roman 1.
In respect of re-employment taking place on or after 1/1/2006, pre-retirement pay for those who retired after 1/1/2006 means the pay in the pay band plus grade pay, but inclusive of non-practicing allowance, if any, last drawn before retirement.
Yes, sir. These, when I am fixing the pay, my lord, it should not be less than the grade pay and the band plus grade pay.
Drawn before
Yes, ma'am.
retirement.
And his salary certificate, I have, along with, I have filed, my lord, the counter affidavit to the contempt petition, wherein I have made a calculation. Counter affidavit by the respondent.
Writ appeal, writ petition,
Contempt ನಲ್ಲಿ ಅಂದ್ರೆ
ಅಲ್ಲ.
calculation details have given in, madam.
writ petition ದಲ್ಲಿ objection ಹಾಕಿದ್ರಾ?
ಹಾಕಿದ್, I filed objection.
ಎಲ್ಲಿದೆ objection? ತೋರಿಸಿ. Where have you taken up that contention? Page 98.
At page number
98.
98, my lord.
Which paragraph you have taken up that contention?
My lord, I have taken it, paragraph number 9, my lord. And 10.
The pay in the pay band plus grade pay.
And non-practicing allowance, if any.
ಅದು ಆ ಪ್ರಶ್ನೆ ಇದರ ಬರ್ಲಿಕ್ಕಿಲ್ಲ.
ಅಲ್ಲಿ ಇದರ ಬಲ್ಲ, ಯಾಕಂದ್ರೆ ಓನ್ಲಿ ಇನ್ ಫೇರ್ ಮೆಡಿಕಲ್ ಪ್ರಾಕ್ಟೀಷನರ್ಸ್ ಅವ್ರಿಗೆ ಮಾತ್ರ ಬರುತ್ತೆ.
Allowance, if any, last drawn before retirement.
And as per my last done, the pay in band was 10,670.
10,000 ಎಲ್ಲಿದೆ?
My lord, I have filed a counter affidavit to the contempt petition ದಲ್ಲಿ. I filed a calculation also.
Okay. Contempt ನಲ್ಲಿ ಹಾಕಿರಾ?
Contempt ನಲ್ಲಿ ಹಾಕಿದ್ದೇನೆ. After this, again I have recalculated it after receipt of the contempt notice, and I given in page number 3, my lord. Page number 3, my lord, salary fixation done under the caption.
Salary
Fixation done.
Recalculated fixation as per revised pay.
And the ಒಂದು post revised and the pre revised ಎರಡು ಇದಾವೆ, my lord.
Last pay drawn military service. 22,000.
10,670 was the pay in band, my lord. Last one.
Grade pay is 2,800.
ಅದಕ್ಕೆ ನಾನು I have made addition of ಇದನ್ನ DA
Correct.
at the rate of 115.8%. So that it comes to 22,443.
ಇದು ನೀವು ಮಾಡಿದ್ದಾ?
ಇದು ಹೌದು ಮೇಲೆ ಫಿಕ್ಸೇಷನ್ ಮಾಡಿದ್ದು.
Recalculated ಅಂದ್ರೇನು?
My lord, ಇದನ್ನ ಈಗ ಮುಂಚೆ ಒಂದು ಮಾಡಿದ್ರು, ಆಮೇಲೆ after receipt of notice again we have recalculated.
ಆ ಟೇಬಲ್ ಸರಿ ಇದೇನೋ ಅದು ಬೇಡ?
ಇಲ್ಲ.
ಸರಿ ಇಲ್ಲ?
ಇಲ್ಲ, I'll just clarify the things after my senior
ಇಷ್ಟ
completes.
ಹೇಳಿ ಮತ್ತೆ ಆಮೇಲೆ
ಇಲ್ಲ, ಇದು ಸರಿ ಇಲ್ಲ. ಅದಕ್ಕೆ ಕ್ಲಾರಿಫಿಕೇಶನ್
ಕೊಡಿ, ಅಷ್ಟು ಕೊಡಿ.
ಅಲ್ಲ, for
ಅಷ್ಟ್ ಟೈಮ್ ಬೇಕಾಗಲ್ಲ ನಂಗೆ, ಬೇಗ ಕೊಡ್ಬೇಕು, ಸ್ಯಾಲರಿ ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಡಿ.
salary certificate,
Don't waste time of the court.
ಇಲ್ಲ, ಅದಕ್ಕೆ ನಾನು 1 ನಿಮಿಷ ಕಂಪ್ಲೀಟ್ ಕೊಟ್ರೆ I'll just submit. Contempt,
Where is your service salary pay?
contempt petition may kindly be taken notes. ಅದರಲ್ಲಿ ಇದೆ ನನಗೆ refer to my lord. Only 2-3 sentences my lord I'll complete.
Page number 86, Annex G is the salary certificate, my lord.
86.
My last drawn
Page number
salary,
86.
my last drawn salary, my lords, page number 77 of my contempt petition.
ನಿಮ್ ಲಾಸ್ಟ್ ಸ್ಯಾಲರಿ ಪಿಟಿಷನ್ ತೊಳಿ,
ಅದೇ
ಕ್ರಿಮಿನಲ್ ಅಪೀಲ್ ನಿಮ್ಮ ಅಪೀಲ್ ಮೆಮೊ ತೊಳಿ.
Annex G, my lord, page
contempt
number
ಒಳಗಡೆ, my
86.
lords, ಅಲ್ಲ sir, ಒಂದು second. My lords, may kindly take the contempt.
86, my lord, Annex G.
ಎಷ್ಟಿದೆ?
33,703. This is
ಏನೇನು
what-
ಇನ್ಕ್ಲೂಡ್?
Well, what the pay band is 10,670, my lord.
ಪೇ ಬ್ಯಾಂಡ್
10,670.
ಪ್ಲಸ್ ಗ್ರೇಡ್ ಪೇ.
Grade pay 2,800.
contempt file ಕೊಟ್ಟಿದೆ. Continue.
30,564 ಆಗ್ತದೆ.
ಅಲ್ಲ, ಪ್ರೊಟೆಕ್ಷನ್ ಕೊಡ್ಬೇಕಾದ್ರೆ ಯಾವ ಕಾಂಪೊನೆಂಟ್ ತಗೊಂಡು ಪ್ರೊಟೆಕ್ಷನ್ ಅಷ್ಟೇ ಮಾಡ್ಕೊ, ಎಲ್ಲ ಎಂಟರ್ ಸಾಲರಿ ತಗೊಂಡು ಪ್ರೊಟೆಕ್ಷನ್ ಕೊಡಕ್ಕಾಗಲ್ಲ.
ಇವೆರಡು.
ಇನ್ನೊಂದು ಯಾವ್ದು ಡಿ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ.
DA ಅಲ್ಲೇ 7890 ಇದೆ. 89 ಐಟಮ್ ನಂಬರ್ G.
7 ಬೇರೆ ತೋರಿಸ್ತಾರೆ, ಹೆಚ್ಚು ತೋರಿಸ್ತಾರೆ ಇಲ್ಲಿ.
ಅಲ್ಲ, ಅದಕ್ಕೆ for clarification of the entire thing, I'll refer to only one document. ಒಂದೇ ಒಂದು ಡಾಕ್ಯುಮೆಂಟ್, annexure B may kindly be seen for only one moment. Contempt petition ತಗೊಳ್ಳಿ ಸ್ವಾಮಿ, ಅದ್ರ ಮೇಲೆ ಎಲ್ಲ ಕ್ಲಾರಿಫೈ ಆಗುತ್ತೆ.
ಅದ ನಿಮ್ದು
ನಾವು ತಗೊಂಡಿದ್ದೀವಿ.
ಅಲ್ಲ,
Writ appeal ಕಾಪಿ
ಅಲ್ಲ,
ಕೊಟ್ಟಿಲ್ಲ, ಅದಕ್ಕೆ ಐ ಆಮ್ ರಿಕ್ವೆಸ್ಟಿಂಗ್ ಫಾರ್ ಕಂಟೆಂಪ್ಟ್ ಮರೋಡ್.
ಅಲ್ಲ, ಆಫೀಸ್
ಕಂಟೆಂಪ್ಟ್ ಹಿಡ್ಕೊಂಡಿವಿ. ಕಂಟೆಂಪ್ಟ್ ಹಿಡ್ಕೊಂಡು ಯಾವ ಪೇಜ್?
ಪೇಜ್ ನಂಬರ್ ಮರೋಡ್ಸ್ 42.
my lord, in the writ appeal, I'll say that.
ಕನ್ಫ್ಯೂಷನ್ ಆಗ್ತದೆ ಸರ್.
ಅಲ್ಲ, Annexure A in the, ನಿಮ್ದು document you are referring in that Annexure A.
Let me
of the
submit
writ
my lord,
appeal.
42 ಅಲ್ಲಿ, this is the my lord personal manual 3.1, my lords may kindly see.
3.1.
Yes. My lords, basic salary of re-employed ex-serviceman shall be fitted at the minimum scale in which he is appointed. However, if the gross salary as per Y below at the minimum of scale does not produce an amount of equal or more than last drawn salary as per X below in the defense services, additional increments to make up the differences and thus provide protection to the last drawn salary.
ಅಂದ್ರೆ in any event it should not be less
Less
than
than
last drawn
yes.
ಅನ್ನೋದು policy.
This is my argument completed.
I'll
They have to compute as per this.
Because I have been governed by the provision circulars issued by
ಇದೇನು ಈ ಸರ್ಕ್ಯುಲರ್?
Circular, yes, this is the personal manual, that circular,
Manual
adanu clarify
of the
ಮಾಡ್ತೀನಿ.
year 1986.
My senior
my
Manoj
lord.
did not submit one thing.
The
This
personal
is
manual
all following one DOP.
ಸರ್ಕ್ಯುಲರ್ ಏನು?
Yes, alla, this is subsequent to issuance of a DOPT circular, which was, my lords may kindly take, issued only in respect of persons re-employed in armed forces only, not outside. ಅಲ್ಲಲ್ಲ, ರಿಟೈರ್ ಆಗಿ armed forces ಅಲ್ಲೇ re-employment ಆದವರಿಗೆ. This is outside the armed forces. My lords may kindly consider.
ಎರಡು ಸರ್ಕ್ಯುಲರ್ ಇದಾವೆ.
There are totally 3. Annexure C ಇಂದ ಸ್ಟಾರ್ಟ್ ಆಗ್ತದೆ. Annexure C ತಗೊಳ್ಳಿ ಸ್ವಾಮಿ, page number 47 in my contempt. Yes. 24th July 2009.
2009.
Page number 47.
ಇದು ಯಾವ ಡೇಟ್ ಇಂದ ಇದು? ಅದು Annexure B.
Annexure B is the original personal manual issued, my lords, in the year 1986.
86.
That governs all these things. Idu subsequent ಏನಿದೆ, this was issued only in respect of, my lord, persons re-employed in the armed forces only, not outside. 2009 ಏನಿದೆ.
One second.
Yes.
What you want to say is,
Yes.
there is a special law.
Yes.
In the form of circular.
Personal manual.
For defense personnel.
Yes.
And other than defense personnel, ಬೇರೆ ಬೇರೆ ಇದೆ.
ಇಲ್ಲ, ಅದರಲ್ಲಿ there are 2 categories. Defense personnel who retired and got re-employed in other sectors like insurance in the present case.
Correct.
These circulars were issued in respect of persons who got re-employment in the armed forces only.
Oh,
Sometimes they
re-employment
take
in the
back.
armed forces
Yes.
only.
So these circulars, my lord, are in respect of those persons, not applicable to me.
ಎಲ್ಲಿ ಅದೆಲ್ಲಿದೆ?
As Annexure C, my lord, I pointed out page number 47. Subject may kindly be seen. This is the circular dated 24 July 2009, page number 47.
47.
Subject, pay and allowances of retired released armed forces officers on re-employment in the armed forces. I am not this person.
Yes, brother.
My lord,
Subsequent
kindly-
ಎಲ್ಲ circulars are in respect of
kindly
these
please, page
persons.
number 67, my lord. What is the confusion has been created? Page number 67.
One second. ನೀವು ಈಗ ಓದಿದಂತ ಸರ್ಕ್ಯುಲರ್
ಅದೇ ಮೇಲೆ ಅದರಲ್ಲಿ ಫಸ್ಟ್ ಲೈನ್ ಬಿಕಾಸ್ ನಾನು ಪರ್ಟಿಕ್ಯುಲರ್ಲಿ ಪೇಜ್ ನಂಬರ್ 67 ತಾವು ಆಲ್ರೆಡಿ ರೆಫರ್ಡ್ ಇಟ್.
ಒಂದ್ ನಿಮಿಷ ಅಲ್ಲ, ನಮ್ ಪ್ರಶ್ನೆ ಅರ್ಥ ಮಾಡಿಕೊಳ್ಳಿ. ನೀವು ಯಾವ ಪ್ಯಾರಾಗ್ರಾಫ್ ನಮ್ಗೆ ಓದಕ್ ಹೇಳಿದ್ರಲ್ಲ, ಅದು ಪೇಜ್ 47 ನಲ್ಲಿರುವಂತ 24 ಜುಲೈ 2009 ಸರ್ಕ್ಯುಲರ್
ಅಥವಾ 2014 ಸರ್ಕ್ಯುಲರ್.
ಅವ್ರು 2014
ಐ ಆಮ್ ರೆಫರಿಂಗ್ ಟು 2014 ಸರ್ಕ್ಯುಲರ್.
ಅದು ಪೇಜ್ ನಂಬರ್
67 ರಿಟ್ ಅಪೀಲ್ ಅಲ್ಲಿ.
ರಿಟ್ ಅಪೀಲ್.
Guidelines is for pay fixation of ex-servicemen, ex-ECO and SSCO re-employed in public sector banks or on or after 1/1/2006. Fixation of pay ex-servicemen in public sector bank is governed by the guidelines and instructions issued by the government of India from time to time. Accordingly, based on the government guidelines, instructions in post issued wide DOPT bearing numbers, which my brother has referred, 2009, dated 5th April 2010, and clarification given wide OM number 3/19/2009, the established pay 2, dated 8 November 2010, fitment of pay of ex-servicemen and ECOs, SCOs who are been appointed in the bank or after to be done as under. So that what my brother is trying to say that it is this circular is applicable only ex-service, armed force is not correct. It is applicable to the banks and other civil organizations.
ಎಲ್ಲರಿಗೂ ಅಪ್ಲೈ ಆಗುತ್ತೆ.
ಎಲ್ಲರಿಗೂ ಅಪ್ಲೈ ಆಗುತ್ತೆ.
Even this circular has to be in consonance with annexure B.
Employed financial institutions, Bank of India, etc., as re-employed, etc., etc., honor the guidelines regarding.
Copy of the guidelines are attached to the.
The last para 2, bani page
Yes,
number
yes.
65, bani para 2 odi.
2.1 more.
2.
These
Page
guidelines are,
65.
yes, these guidelines are equally applicable to ex-servicemen re-employed in RBI, public finance institutions, public sector insurance companies under which I come under. GIPSA, IRDA, it is therefore advised to implement these guidelines. Now, in this also, my friend is referring to 2.11.
2.11.
Yes. Adralli kuda ಏನು ಹೇಳ್ತಾರೆ, what does, yes,
Read.
pay fixation of an ex-serviceman would be through protection of pay plus DA drawn by him at the time of released from armed forces. As per the instructions issued by the Ministry of Defence wide letter dated so and so 24th July 2009 and advised by DOPT. Once again, they refer to 24th July 2009.
Then they have modified it, then go.
No, this is not modification.
Let us read.
Yes, I'm sorry. And advised by DOPT wide 3/19 of 2009, dated 8th November 2010, pre-retirement pay has been defined as under. In respect of re-employment taking place on or after 1/1/2006, pre-retirement pay for those who retired after 1/1/2006 means the pay in the pay band plus pay grade, but inclusive of non-practicing allowance, if any, last round before retirement. Now, yes, this also more shoots from the 2009 circular, which is only for the armed forces. That's why, that is what my contention was in the
Then
writ
this
petition.
They have said this applies to the armed forces people also.
No, 2009 circular said it applies only to the armed forces. It defined.
Correct.
They took more explanation from that and issued this circular in respect of persons belonging to my category also. That's why this cannot be contrary to the personal manual. Personal manual says in any case you have to match the last round salary in the armed forces. Even if this is considered, these two.
One sentence ಹೇಳಿ pass ಕೊಡಬೇಕು. You are not narrating some story. You have to assess.
Yes.
ಮತ್ತೆ ಅದ್ರ ಇಂಪ್ಯಾಕ್ಟ್ ದೇಶದಲ್ಲೆಲ್ಲ ಇಂಪ್ಯಾಕ್ಟ್ ಆಗ್ತದೆ.
That's why, Murad.
ನಿಧಾನವಾಗಿ
Yes.
ಹೇಳ್ಬೇಕು. ಈಗ
Yes.
ಈ ಸರ್ಕ್ಯುಲರ್ ದ ಉದ್ದೇಶ,
in my humble submission, ಇದರಲ್ಲೂ ಕೂಡ ನನ್ನ ಸ್ಯಾಲರಿ ಕಡಿಮೆ ಕೊಡಬೇಕಂತ ಏನು ಹೇಳೇ ಇಲ್ಲ. Even if it is considered to be
ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡಬೇಕು ಅಂತ
calculate ಮಾಡಬೇಕು ಅಂತ.
ಎದಕ್ಕೆ ಮಾಡಬೇಕು?
Annexure B says calculate in such a manner that it matches your last round salary. This says what is pay ಅಂತ ಹೇಳ್ತಾರೆ ಅಷ್ಟೇ. What is the pay means pay band plus pay grade. That itself is not my pay. They have to match the increments to such an extent that, Murad, it matches my last round salary. E confusion no writ petition
ಯಾರು issue ಮಾಡಿದ್ದಾರೆ?
This is issued by, my lords, the
Department of Ministry of Personal Public Governance.
Department of Financial
Financial
Services.
Service.
ನೀವು ಇನ್ನೊಂದು ಹೇಳಿದ್ರಲ್ಲ ಅದನ್ನ ಯಾರು
Other DOPT, Department of, Murad, Personal.
ಅದೇ ಸೇಮ್ ಡಿಪಾರ್ಟ್ಮೆಂಟೇ.
Illa, this is Department of Financial Services. That is Government of India issued circular, Minister of Defence.
ಅದು ಡಿಫೆನ್ಸ್ ಮಿನಿಸ್ಟ್ರಿ
2009, which says it is only for armed forces.
ಅಲ್ಲ, 10 ಸಾರಿ ಹೇಳಿದ್ರಿ ನೀವು ಅದನ್ನ.
ಇಲ್ಲ ಅಂದ್ರೆ that is the confusion.
ಕನ್ಫ್ಯೂಷನ್ ಆಗ್ತದೆ ನಮಗೆ.
ಈಗ ಏನಾಗಿದೆ, ಅದಕ್ಕೆ my humble submission is, but even after taking into this into consideration also, my salary has to be fixed in terms of annexure B only. Specifically says you have to match up the increments and pay as per, of course, some components which Marad I would be entitled only in the military, like Marad I'll submit, which I'm not entitled to would be Marad, ಅದರಲ್ಲಿ good conduct badge pay ಅಂತ ಒಂದು ಬರ್ತದೆ 240 rupees, then classification pay, these things I'm not entitled to. Basic pay, DA, they have to match in such a manner that it has to be Marad appropriate to the last. Last time also saw Marad my note which I have made in the that salary certificate. I would be entitled to Marad excluding those which only are exclusive to the military pay, 30,564 would have been my salary on re-employment. But what they calculate is
pay itself you want to be.
That is what annexure B says. Pay should be matched, increment ಜಾಸ್ತಿ ಮಾಡಿ ಅದನ್ನ match ಮಾಡಬೇಕು. And this annexure E only defines pay. Annexure E only defines pay, nothing more.
Fixation of annexure B through protection of pay plus DA drawn by him at the time of release from armed forces. As per the instructions issued by the Ministry of so and so. Pre-retirement pay has been defined as protection of pay plus DA.
Pay is question for him. Pay is something different.
Basic pay.
Your understanding of pay should be as per
Annexure B.
Page 42.
Yes.
Pay andre why you consider add some increment because it should not.
Alla, they also given the illustrations are also given. My lords may kindly see X and Y. ಅದರೊಳಗಡೆ my lords may kindly see X and Y. In X, my lord, so many components paid in the military services are given, and in Y there are only 4 components.
ಒಂದು DOPT ದು.
My lord, there is one more document. Exhibit R1 can be, again, there is a clarification has been given in the 2012, exhibit R1, page number 106.
R1 na?
R1 at page number 106, my lord. This issue has been clarified once again by the Government of India, Ministry of Finance. 106, my lord.
06. ಇದೇನಿದು?
That is a circular issued by, clarification issued by the Department of Finance.
MSP ಅಂದ್ರೇನು?
Military service pay.
Military service pay.
ಅಂದ್ರೆ ಅವೆಲ್ಲ ಬೇರೆ ಅಲೌನ್ಸ್ ಎಲ್ಲ ಬಂದಿರ್ತಾವ ಅವನ್ನೆಲ್ಲ
That anyway I am not
ಮಾಡಬಾರ್ದು ಅಂತ. Only again it made very clear that the service would include band pay plus gate pay only again.
There is no doubt it includes only those 2 months, absolutely no doubt. But they have to be matched to the last round salary.
But the protection should be given, not to the match salary. The protection should be given that it should not be less than these components.
ಈ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ನೀವು ಮಾಡಿದ್ರೆ it will be less than what he was
no my lord, it is more than that. ಆ component ಆ salary entire gross salary ತಗೊಳ್ಳ ಹಾಗಿಲ್ಲ my lord. Only what we are required to take that the component grade pay plus band pay plus DRNs also because he has been renewed. ಆ ಮೂರು ಸೇರಿಸ್ಕೊಂಡ್ರೆ ಕಡಿಮೆ ಆಗಬಾರ್ದು.
ಕಾಂಪೋನೆಂಟ್ಸ್ ಬರೋದಿಲ್ಲ,
ಬರಂಗಿಲ್ಲ. ಆ ಮೂರನ್ನು ಸೇರಿಸಿದ್ರೆ ಅದು ಎಷ್ಟು ಬರುತ್ತೆ ಅದಕ್ಕಿಂತ ನಾನು ಕಡಿಮೆ ಫಿಕ್ಸೇಷನ್ ಮಾಡೋ ಹಾಗಿಲ್ಲ. So I have made accordingly, I have taken pay in band 10,670, grade pay 2,800, DA at the rate of 115 on the basic and 8,7,973, totally 22,443. So that my fixation shall not be at any condition less than 22,443. Accordingly, it has been fixed at 23,004. ಯಾಕಂದ್ರೆ at the available ಆ time ನಲ್ಲಿ ಎಷ್ಟು ಡಿ ಎ ಸಪೋಸ್ ಇಟ್ ಹ್ಯಾಸ್ ಬಿನ್ ಇನ್ವಾಲ್ವ್ಡ್ ಇನ್ ದ ಸಿವಿಲ್ ಇದನ್ನ ಆಸ್ ಎನ್ ಸಿವಿಲ್ ಸರ್ವಿಸ್ ದಲ್ಲಿ ಇದ್ದಾಗ ಎಷ್ಟು ಕೊಡ್ಬೇಕಾಗಿತ್ತು ಅಂದ್ರೆ ಡಿ ಎ ಪ್ರಕಾರ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಮಾಡಿದೆವು. ಅಗೇನ್ ಇಲ್ಲಿ 33.1 ರಿವೈಸ್ ತಗೊಂಡು ಅದ್ರ ವಿ ಹ್ಯಾವ್ ಕ್ಯಾಲ್ಕುಲೇಟೆಡ್.
ಅವ್ರು ಹೆಂಗ್ ಮಾಡಿದ್ದಾರೆ, ಹೆಂಗ್ ಮಾಡಿದ್ದಾರೆ
ಮೈ ಲಾರ್ಡ್? ಅವ್ರು ಹೇಳ್ತಾರೆ ಮೈ ಲಾರ್ಡ್, ಎರಡೂ ಫಾಲೋ ಮಾಡಂತದ್ದು, ಎರಡು ಇನ್ಕನ್ಸಿಸ್ಟೆಂಟ್ ಆಗ್ಬಿಡಾಕತ್ತೈತಿ ಮೈ ಲಾರ್ಡ್. ಎರಡು 14/12/2000 ನೋಟಿಫಿಕೇಶನ್ ಫಾಲೋ ಮಾಡಂತ ಹೇಳ್ತಾರೆ ಮೈ ಲಾರ್ಡ್. ಆಮೇಲೆ ಅದು ಪರ್ಸನಲ್ ಮೇಲೆ ವೈನು ಫಾಲೋ ಮಾಡಂತ ಹೇಳ್ತಾರೆ, ವಿಚ್ ಇಸ್ ನಾಟ್ ಪರ್ಮಿಸಿಬಲ್. ಅಟ್ ಪೇಜ್ ನಂಬರ್ 20 Roman 3 ಮೈ ಲಾರ್ಡ್. Number 8 ನಲ್ಲಿ ಕ್ಲಿಯರ್ ಬರೀತಾರೆ ಮೈ ಲಾರ್ಡ್, ವಾಟ್ ಆರ್ ದ ರಿಕ್ವೈರ್ಡ್ ಬಿ ಟೇಕನ್ ಇಂಟು ಕನ್ಸಿಡರ್. ಅಗೇನ್
come to para 8 of impugned judgment.
The pay protection provided to the ex-servicemen employed in the public sector banks is governed by the guidelines instruction issued by the DOPT OM number 3/19/2009 established also 5/4/2010 and is subject to change from the time to time. The guidelines specify for protecting the pay of the re-employed ex-servicemen and only elements for considered are pay plus DA, and the term pay means basic pay plus grade pay as per DOPT circular dated 8/11/2010.
ಅವರ ನಿಮ್ಮ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಲೆಟರ್ ಎಲ್ಲಿದೆ?
Appointment letter is not produced for it.
ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಲೆಟರ್ ಎಲ್ಲಿದೆ? ಅದ್ರಲ್ಲಿ ಏನಂತ ಅಶ್ಯೂರೆನ್ಸ್ ಕೊಟ್ರಿ ಅವರಿಗೆ?
ಇಲ್ಲ ಮೇಡಮ್, ಅಫಿಷಿಯಲ್ಸ್ ಎಲ್ಲ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆಗ್ತಾರೆ, ಬಟ್ ಫಿಕ್ಸೇಷನ್ ಮಾಡ್ಬೇಕಾದ್ರೆ
ಅಲ್ಲಿ ಏನ್ ಹೇಳಿರಿ ನೀವು? ನಿಮ್ಮ ಪೇ ಹಿಂಗೆ ಇರ್ತದೆ, ನೀವು ಇಂಥ ಬಣ್ಣದ ಅಂಗಿ ಹಾಕೊಂಡ್ ಬರ್ಬೇಕು ಏನಾದ್ರು ಇರುತ್ತಲ್ಲ ಅದ್ರ
ಅಲ್ಲ. ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಐ ಗೆಟ್ ಇಟ್ ಮೇಲೆ ಇವನ್
ಆರ್ಡರ್ ನಲ್ಲಿ ಇರ್ತದೆ ಅದು. ನೀವು ಮೊದಲಿಗೆ ಅವರಿಗೆ ಯು ಹ್ಯಾವ್ ಗಿವನ್ 23,799 ಆಲ್ಸೋ
ಬಿಫೋರ್ ಫಿಕ್ಸೇಷನ್ ಆಗೋಕ್ಕಿಂತ ಮುಂಚೆ ಬಂದ ಕೂಡಲೇ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಕೊಟ್ಟೆವು ನಾವು. ಫಿಕ್ಸೇಷನ್ ಆ ಸಬ್ಸಿಕ್ವೆಂಟ್ ಆಯ್ತು, ಇಮಿಡಿಯೇಟ್ಲಿ ಬಂದ ಕೂಡಲೇ ಫಿಕ್ಸೇಷನ್
ಡೇಟೆಡ್ ಏನ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್?
Date of appointment is my lord
15.
Date of appointment ಹೇಳಿ.
I'll just, yes ma'am.
23/11/2015 my lord.
23/11/2015. As on that date, the circular
fixation ಆಗ್ಲಿಲ್ಲ, subsequently fixation has been made after 8 or 9 months the fixation has been done. ಅವಾಗ ಇಮಿಡಿಯೇಟ್ಲಿ ನಾವು ಅದನ್ನ ಆ ಪ್ರಕಾರ ಸ್ಯಾಲರಿ ಕೊಟ್ಟು ಆಮೇಲೆ ಫಿಕ್ಸೇಷನ್ ಸಬ್ಸಿಕ್ವೆಂಟ್ ಆಯ್ತು.
ಪೇಜ್ ನಂಬರ್ ಏನು ನಿಮ್ದು ಸ್ಯಾಲರಿ ಇದ್ರದ್ದು ನಿಮ್ಮ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆರ್ಡರ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿರಾ?
ಇಲ್ಲ, ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆರ್ಡರ್ ಇಸ್ ನಾಟ್ ಪ್ರೊಡ್ಯೂಸ್ಡ್.
ಅಲ್ಲಿ ಅಶ್ಯೂರೆನ್ಸ್ ಏನ್ ಕೊಟ್ಟಿದ್ರು ನಿಮಗೆ?
Just
that decides the terms of employment.
yes.
Subsequently ಬೇರೆ ಬೇರೆ ಸರ್ಕ್ಯುಲರ್ ಕೊಟ್ಟು ಮೊದಲು ಕೊಟ್ಟಂತ ಸ್ಯಾಲರಿ ಡೌನ್ ಗ್ರೇಡ್ ಮಾಡಕ್ ಬರ್ತದ?
ಅಲ್ಲ ಮೈ ಲಾರ್ಡ್, ಬಿಕಾಸ್ ಅದನ್ನ ಫಿಕ್ಸೇಷನ್ ಆಗೋಕ್ಕಿಂತ ಮುಂಚೆ ಎಂಪ್ಲಾಯ್ಮೆಂಟ್ ಸ್ಯಾಲರಿ ಕೊಟ್ರು.
ಅಲ್ಲಿ ಏನ್ ಹೇಳಿರಿ ಅಂತ ಗೊತ್ತಾ? ಅಲ್ಲಿ ನೀವು ಹೇಳಿದ್ರೆ ಸ್ಯಾಲರಿ in the pay scale, salary in the pay scale of ಅಂತ ಇತ್ತು ಅಂದ್ರೆ ಆ ಪೇ ಸ್ಕೇಲ್ ಅನ್ನ ಮೇಂಟೈನ್ ಮಾಡಬೇಕಾಗ್ತದೆ. ಮುಂದಾಗೋ ಬದಲಾವಣೆ ಸಂಬಂಧಪಡಲ್ಲ. ಬೆನಿಫಿಷಿಯಲ್ ಇದ್ರೆ ಕೊಡಬೇಕಾಗ್ತದೆ, ಡೆಟ್ರಿಮೆಂಟಲ್ ಇದ್ರೆ ಅದನ್ನ ಅಪ್ಲೈ ಮಾಡಕ್ ಬರಲ್ಲ. ಹಂಗ ರಾಮಜೋಯಿಸರು ಬರ್ತಾರೆ ಆ ರೀತಿ.
In fact, I also produced in the writ petition along with memo. ಅದನ್ನ ತರಿಸ್ತೀನಿ, ಒಂದೇ ನಿಮಿಷ ಟೈಮ್ ಕೊಡಿ. writ petition ಅಲ್ಲಿ 2 other persons similarly situated as in
ತೋರಿಸಿದ್ರೆ ಹೇಳ್ಬೋದು. ಅವ್ರಂಗಾಗಿತ್ತು, 3 ಜನ ಮದುವೆಗೆ ಬಂದಿದ್ರು, ನಾವೇನ್ ಮಾಡ್ಕೊಂಡು ನಿಮ್ಮ ಸ್ಯಾಲರಿ ಸರ್ಟಿಫಿಕೇಟ್ ತೋರಿಸಿ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಲೆಟರ್.
I'll just get it. May I just 1 minute may I see?
ಬಸ್
Please.
ಎಲ್ಲಿಂದ ತರಬೇಕು ಈಗ ಅದನ್ನ?
ಇಲ್ಲ, ನಾನು ಆನ್ಲೈನ್ ತರಿಸ್ಬಿಡಿ. He is more now transferred to some other place. He'll send it to me online, sir.
ತರಿಸಿ ಪಾಸ್ ಔಟ್.
Yes.
10 VP would be.
For the appellant, my lords, wherein the rule of law has been violated by the members of Gram Panchayat. To start with, my lord, may I take your lordships to annex H page 53.
ಏನಿದೆ ಜಡ್ಜ್ಮೆಂಟ್ ಏನಂತ ಇದೆ?
My lord, judgment confirms an illegal resolution and the order passed by Jilla Panchayat approving my appointment as a data and operator cum clerk.
You were appointed as
Clerk cum data entry operator.
clerk cum
Data entry operator.
data entry operator.
Please, my lord. This is pursuant to the notification for a minute, my lord, page 53 may can be seen, annexure H.
H,
Yes, my lord. Ink page 53.
ಇದು recruitment notification,
Yes, my lord. It prescribes the notification inviting applications for the post. Several posts, including clerk cum computer operator, word seal number 2. ನೇಮಕಾತಿ ನಿಬಂಧನೆಗಳು seal number 4 may kindly be seen.
ಕಮ್ ಡಾಟಾ ಎಂಟ್ರಿ ಆಪರೇಟರ್ ಹುದ್ದೆ ಖಾಲಿ ಇದ್ದು
Yes,
ಸದರಿ ಹುದ್ದೆಗೆ ಸರ್ಕಾರದ ಆದೇಶ ನಿರ್ವಹಿಸುತ್ತಿದ್ದರೆ ಅನುಮೋದನೆ ನೀಡತಕ್ಕದ್ದು.
no, no, 53, annexure H for a minute.
53 ನಾ?
ಹೌದು, ink page 53. ಆದ್ಯತೆ
ಐಟಮ್ ನಂಬರ್
seal number 4 ನೇಮಕಾತಿ ನಿಬಂಧನೆಗಳು. Item number 2, inviting application for the post of clerk cum data entry operator.
ಐಟಮ್ ನಂಬರ್ 4
ಗ್ರಾಮೀಣ ಅಭಿವೃದ್ಧಿಯಲ್ಲಿ ಅಭಿನವ ಹೊಂದಿದವರ ಆದ್ಯತೆ, ಗ್ರಾಮ ಜಾತಿ ಅಭಿವೃದ್ಧಿ ಆದ್ಯತೆ, ಪರಿಶಿಷ್ಟ ಜಾತಿ ಪರಿಶಿಷ್ಟ ಪಂಗಡ ಮಹಿಳೆಗೆ ಅಂಗವಿಕಲರಿಗೆ ಸೈನಿಕ ಆದ್ಯತೆ.
Instruct him. You are a briefing council, you have to instruct him, please. Yes.
We are not yet got the pages.
Page 53.
53, 53.
Yes. Yes.
ಆದ್ಯತೆ, the order of preference to appoint.
Preference.
Yes, my lord. At seal number 3, ಪರಿಶಿಷ್ಟ ಜಾತಿ ಪರಿಶಿಷ್ಟ ಪಂಗಡ ಮಹಿಳೆಯರಿಗೆ ಅಂಗವಿಕಲರಿಗೆ ಸೈನಿಕರಿಗೆ ಆದ್ಯತೆ. The appellant is a woman, a lady candidate, as well as she is otherwise physically able.
ಎರಡರಲ್ಲಿ ಬರ್ತಾರೆ ಅಂತ.
ಹೌದು. ನೆಕ್ಸ್ಟ್ ಮೈ ಲಾರ್ಡ್, ಸದರಿ ಹುದ್ದೆ ನಿಗದಿಪಡಿಸಿದ್ದಲ್ಲಿ ಹೆಚ್ಚಿನ ಅಂಕ ಪಡೆದವರಿಗೆ ಆದ್ಯತೆ. Yes, I have scored 484 marks in the qualifying examination. 484.
484 marks.
Please, my lord.
Out
of 600. Whereas respondent number 5 has scored 385 marks. This may kindly be seen at page 55 for a minute, my lord.
55.
Yes.
ನಡಾವಳಿಗಳು.
Yes. ಅದರಲ್ಲಿ seal number clerk cum computer operator ಹುದ್ದೆಗೆ ಬಂದ ಅರ್ಜಿ. The next item.
54 ಅಲ್ಲ.
55.
55.
Yes, ಅದು ಸ್ಕೋರ್ ಕಾರ್ಡ್ ಮೇಂಟೈನ್ ಮಾಡಿದ್ದಾರೆ. ಮಾರುತಿ ಬಿ ತಿರ್ಲಕ್ಕನ್ ಅವರು is respondent number 5.
ನೀಲಾಕ್ಷಿ
484.
385, 484.
Please. So I am a lady candidate. I am physically otherwise able, and I am the highest scorer. This being so, the next interesting aspect, my lord, may kindly be seen, page 56. ಈ ದಿನದ ಸಭೆಯಲ್ಲಿ ಒಟ್ಟು 14 ಜನ ಸದಸ್ಯರಲ್ಲಿ 8 ಜನ ಸದಸ್ಯರು ಈ ಕೆಳಕಂಡ ಬಹುಮತದಿಂದ ಆಯ್ಕೆ ಮಾಡಿದರು. ಕರವಸೂಲಿ ವಿರುದ್ಧ ಚೈತ್ರಾ ಬೋಪಣ್ಣ ಜನಗೇರಿ ಇವರು ಹೆಚ್ಚಿಗೆ ಬಂದು ಆಯ್ಕೆ ಮಾಡಿದರು. ಕ್ಲರ್ಕ್ ಕಮ್ ಕಂಪ್ಯೂಟರ್ ಆಪರೇಟರ್ ಹುದ್ದೆ ಮಾರುತಿ ಬಿ ತಿರ್ಲಕ್ಕ ಇವರನ್ನು ಅನುಭವ ಹಾಗೂ ಇತರ ಇಲಾಖೆಯಲ್ಲಿ ಕೆಲಸ ಅನುಭವದ ಆಧಾರದ ಮೇಲೆ ಹಾಲಿ ಕಾರ್ಯದಲ್ಲಿ ಕಾರ್ಯನಿರ್ವಹಣೆ ಆದ್ಯತೆ ಮೀರಿಯನ್ನು ಸದರಿ ಹುದ್ದೆಗೆ ಆಯ್ಕೆ ಮಾಡಿದರು. This illegal resolution, the next column.
ಇವ್ರು ಏನ್ ಮಾಡಿದ್ರು ಅದು ಮೊದಲೇ ಕಾಲಂ ಓದಿದ್ದನ್ನ ಎಕ್ಸ್ಪ್ಲೇನ್ ಮಾಡಿ ನಮ್ಗೆ. ನೀವೇನ್ ಓದಿದ್ರಿ ಅದನ್ನ?
ಕ್ಲರ್ಕ್ ಕಮ್ ಕಂಪ್ಯೂಟರ್ ಆಪರೇಟರ್ ಹುದ್ದೆ
ಶ್ರೀ ಮಾರುತಿ ಬೀತ್ ಕಳೆದ
ತಿರ್ಲಕ್ಕನವರಿವರನ್ನು
ಪಂಚಾಯತಿ
ಅನುಭವ ಹಾಗೂ
ಅನುಭವ ಹಾಗೂ ಇತರ ಇಲಾಖೆಯಲ್ಲಿ ಕೆಲಸ ನಿರ್ವಹಿಸಿದ್ದರಿಂದ ಅನುಭವದ ಆಧಾರದ ಮೇಲೆ ಮತ್ತು ಹಾರೈ ಕಾರ್ಯದಲ್ಲಿ ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಿರುವುದರಿಂದ ಆದ್ಯತೆ ಮೇರೆಗೆ ಇವರನ್ನು ಸದರ ಹುದ್ದೆಗೆ ಆಯ್ಕೆ ಮಾಡಿದರು.
ಅವರು ಅಲ್ಲೇ ವರ್ಕ್ ಮಾಡ್ತಾ ಇದ್ರ ಮೊದಲು.
ಹಿ ವಾಸ್ ವರ್ಕಿಂಗ್ ಟೆಂಪರಲಿ. ಅದರಲ್ಲಿ ಈ ದಿನದ ಸಭೆಯಲ್ಲಿ ಒಟ್ಟು 14 ಜನ
ಆದ್ಯತೆ ಗ್ರಾಮೀಣ ಉದ್ಯೋಗವನ್ನು ಹೊಂದಿರುವ ಆದ್ಯತೆ ಫಸ್ಟ್ ಅವರಿಗೆ, ನಂತರ ವ್ಯಾಪ್ತಿಯ ಅಭ್ಯರ್ಥಿಗಳಿಗೆ ಆದ್ಯತೆ, ನಂತರ ಪರಿಶಿಷ್ಟ ಜಾತಿ, ನಂತರ ಸದರಿ ಹುದ್ದೆ ನಿಗದಿಪಡಿಸಿದ ವಿದ್ಯಾರ್ಥಿಯಲ್ಲಿ ಹೆಚ್ಚಳ ಅಂಕಗಳನ್ನು ಮಾಡಿದಂಥದ್ದು. ಎಷ್ಟು ದಿವಸ ಅನುಭವ ಎಷ್ಟಿದೆ ಅವರಿಗೆ? ಎಷ್ಟು ವರ್ಷದಿಂದ ವರ್ಕ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ?
ನಥಿಂಗ್ ಫಾರ್ ಕಮಿಂಗ್ ಮೈ ಲಾರ್ಡ್. ಇದ್ರಲ್ಲಿ ಇನ್ನೊಂದು ಇಂಟ್ರೆಸ್ಟಿಂಗ್ ಪಾಯಿಂಟ್ ಹೇಳಿ ನೆಕ್ಸ್ಟ್ ಐ ವಿಲ್ ಕಮ್ ಟು ಯುವರ್.
ಅಲ್ಲ, ಈ ಪ್ರಶ್ನೆಗೆ ಉತ್ತರ ಕೊಡಿ. ಕೋರ್ಟ್ ಡೌಟ್ ಅನ್ನು ಕ್ಲಿಯರ್ ಮಾಡ್ಬೇಕಲ್ಲ, ಕೋರ್ಟ್ ಪ್ರಶ್ನೆಗಳನ್ನು ಉತ್ತರ ಕೊಡ್ಬೇಕಲ್ಲ ನೀವು ಯಾರಾದ್ರೂ ಮೊದಲು, ಆಮೇಲೆ ನಾವು ಹೋಗೋದು.
ಅನಕ್ಷರಿ ಎಫ್
ಉತ್ತರ ಕೊಡಿ.
ಅದೇ
ಎಷ್ಟು ವರ್ಷದಿಂದ ಇದ್ದ?
14/9/2011 he was working in office of
2011.
14/9/2011 he was working in Tahsildar office. Thereafter 5/1/2016 he is working in Gram Panchayat. 5/1/2016 in Gram Panchayat
till date.
Till date. Annexure F and F1.
ಮತ್ತೆ ವಾಟ್ ಈಸ್ ಫನ್ ಇನ್ ಹ್ಯಾವಿಂಗ್ ಕಾಂಪಿಟೇಟಿವ್ ಎಕ್ಸಾಮಿನೇಷನ್?
ಅಲ್ಲ, ಅದು
ಆದ್ಯತೆ ಕೊಡಬೇಕು ಅಂದ್ರೆ ಯಾವಾಗ ಬರ್ತದೆ? ಇಬ್ರು ಒಂದೇ ಮಾಡಿದಾಗ ದಿ ವೆರಿ ಆಬ್ಜೆಕ್ಟ್ ಆಫ್ ಸೆಲೆಕ್ಷನ್ ಈಸ್ ಟು ಚೂಸ್ ಬೆಸ್ಟ್ ಆಫ್ ದ ಕ್ಯಾಂಡಿಡೇಟ್ ಇನ್ ದ ಫ್ರೇ. ದಟ್ ಈಸ್ ದಿ ಆಬ್ಜೆಕ್ಟ್ ಆಫ್ ಹೋಲ್ಡಿಂಗ್ ಎಕ್ಸಾಮಿನೇಷನ್. ಆದ್ಯತೆ ಅಂದ್ರೆ ಈ ಮಾರ್ಕ್ಸ್ ಅವ್ರಕ್ಕಿಂತ ಜಾಸ್ತಿ ಇದ್ದಾಗೂ ನಿಮ್ಗೆ ಆದ್ಯತೆ ಕೊಡಬೇಕು ಅಂತನ ಅಲ್ಲ. ವೆರಿ ಫನ್ ಇನ್ ಹ್ಯಾವಿಂಗ್ ದ ಎಕ್ಸಾಮಿನೇಷನ್.
Annexure G ಒಂದು ಸರ್ಕ್ಯುಲರ್ ಇದೆ, ಗವರ್ಮೆಂಟ್ ಸರ್ಕ್ಯುಲರ್
G.
Annexure G. It starts from page number 47.
51 ಬನ್ನಿ, ನೋಡಿದೀವಿ ನಾವು.
51 clause 6.
ಕ್ಲಾಸ್ 6 ಬನ್ನಿ.
ಹೌದು. ಈ ಸರ್ಕಾರದ ಆದೇಶದಂತೆ ಗ್ರಾಮ ಪಂಚಾಯತಿ ಕ್ಲರ್ಕ್ ಕಮ್ ಡಾಟಾ ಎಂಟ್ರಿ ಆಪರೇಟರ್ ಹುದ್ದೆ ಖಾಲಿ ಇದ್ದು, ಸದರ್ ಹುದ್ದೆಗೆ ಸರ್ಕಾರದ ಆದೇಶದ ಅನುಸಾರ ಡಾಟಾ ಎಂಟ್ರಿ ಆಪರೇಟರ್ ವೃಂದದ ನೌಕರರು ನೇಮಿಸಿಕೊಂಡು ಹಾಲಿ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸುತ್ತಿದ್ದರೆ ಅನುಮೋದನೆ ನೀಡತಕ್ಕದ್ದು.
ಇದು ಮಾಡಿಲ್ಲಲ್ಲ, ಇದು ಮಾಡಿಲ್ಲಲ್ಲ,
ಇದನ್ನ ಮಾಡಿ.
ಇದು ಮಾಡೋದಿದ್ರೆ ನೋಟಿಫೈ ಯಾಕೆ ಮಾಡಿದ್ರಿ ಪೋಸ್ಟ್ ಅನ್ನ? ಇದನ್ನ ಮಾಡಿದ್ರೆ ಕರೆಕ್ಟ್ ಇತ್ತು. ಅದು ಮಾಡಿಲ್ಲದಾಗ ಈಗ ವಿ ಹ್ಯಾವ್ ಕ್ರಾಸ್ಡ್ ದಟ್ ಬ್ರಿಡ್ಜ್ ನೌ.
ಅಲ್ಲ, while making appointment they have considered this experience.
Where competitive examination is held.
Examination ಆಗಿಲ್ಲ ಇದರಲ್ಲಿ.
ಎಂತದ ಸೆಲೆಕ್ಷನ್ ಪ್ರೊಸೆಸ್ ಆಗಿದೆಪ್ಪ. ಡೈರೆಕ್ಟ್ ಆಗಿದೆ, ಹೌದಾ? ಡಾಟಾ ಇಟ್ಕೊಂಡು ಮಾಡಿದ್ವಿ. ಯು ಹ್ಯಾವ್ ನೋಟಿಫೈಡ್ ದ ವೇಕೆನ್ಸಿ. ವೇಕೆನ್ಸಿ ವಾಸ್ ನೋಟಿಫೈಡ್.
ಎಸ್,
ಕರೆಕ್ಟಾ?
ಹೌದು.
ನೋಟಿಫೈ ಯಾಕೆ ಮಾಡಕ್ ಹೋಯ್ತು? ಇದನ್ನ ಈ ಪ್ರಕಾರ ರೆಸಲ್ಯೂಷನ್ ಮಾಡಬೇಕಿತ್ತು.
ಅದರಲ್ಲಿ ಕ್ಲಾಸ್ 4 ಮೇಲಿದೆ, ಸರ್ಕಾರಿ ಇಲಾಖೆಯಲ್ಲಿ ಕೆಲಸ ನಿರ್ವಹಿಸಿದವರಿಗೆ ಆದ್ಯತೆ.
ಆದ್ಯತೆ ಅರ್ಥನೇ ಇಲ್ಲ ಅದಕ್ಕೆ.
ಪ್ರಿಫರೆನ್ಸ್
ಅಂದ್ರೆ ಏನು ಅರ್ಥ?
ಇಫ್ ನೋ ಸಚ್
ಸೇಮ್ ಇದ್ದಾಗ ಯಾರನ್ನ, ಇಟ್ ಇಸ್ ಲೈಕ್ ಎ ವೆರಿ ಎ ಹಂಗ್ರಿ ಡಾಂಕಿ ವಿಚ್ ಸೆಸೆರೋ ಸೇಸ್. ಎ ಹಂಗ್ರಿ ಡಾಂಕಿ, ತುಂಬಾ ಹಸಿವೆಯಿಂದ ಬಳಲ್ತಿರುವಂತ ಕತ್ತೆಗೆ 2 ಹಸಿರು ಹುಲ್ಲಿನ ಪೆಂಡೆಯನ್ನ ಇಟ್ರೆ ಮುಂದ್ಗಡೆ ಇದನ್ನ ತಿನ್ಬೇಕು ಅದನ್ನ ತಿನ್ಬೇಕು ಅನ್ಕೊಂಡು ಕನ್ಫ್ಯೂಸ್ ಆಗಿ ಸತ್ತೋಗ್ಬಿಡ್ತದ. ಆದ್ಯತೆಯನ್ನು ಹಂಗ ಅರ್ಥ ಮಾಡ್ಕೋಬೇಕು. ಆದ್ಯತೆ ಅಂದ್ರೇನು? ಆಲ್ ಥಿಂಗ್ಸ್ ಬೀಯಿಂಗ್ ಕೆಪ್ಟ್ ಸೇಮ್. ಯಾರಿಗೆ ಕೊಡ್ಬೇಕು ಅನ್ನೋ ಆದ್ಯತೆ ಅಂದ್ರೆ ಆ ಅರ್ಥದಲ್ಲಿ.
ಬಿಫೋರ್
ತೆಗಿರಿ that Supreme Court on words and phrases by Surendra Malik. Preference in employment, recruitment.
It says quantitatively and qualitatively same ಇದ್ದಾಗ,
ಎಲ್ಲ ಸೇಮ್ ಇದ್ದಾಗ ಅವಾಗ ಅವ್ರ ನಡುವೆ ಯಾರನ್ನು ಚೂಸ್ ಮಾಡಬೇಕು ಅನ್ನೋ ಪ್ರಶ್ನೆ ಬಂತು. ಅವಾಗ ಒಂದು ಯಾರ್ಡ್ಸ್ಟಿಕ್ ಕೊಟ್ಟು ನಾರ್ಮ್ ಕೊಟ್ಟಾರ. ತೀರಾ ನಾವೇನು ಚಾವಂಗ ಆಡಿ ಚೂಸ್ ಮಾಡಕ್ ಬರಲ್ಲ, ಒಂದು ನಾರ್ಮ್ ಬೇಕಲ್ಲ, ನಾರ್ಮೇಟಿವ್ ಪ್ರೊಸೆಸ್ ಬೇಕಲ್ಲ. ಆ ಕಾರಣಕ್ಕೆ ದೇ ಹ್ಯಾವ್ ಪುಟ್ ದಿಸ್ ನಾರ್ಮ್. ಏನು ಎಲ್ಲ ಈಕ್ವಲ್ ಇತ್ತು ಅಂತಂದ್ರೆ ಆ ರೀತಿ ಕೊಡ್ತೀವಿ. ಇಲ್ಲಪ್ಪ ಅಂದ್ರೆ ಆದ್ಯತೆ ಅಂದ್ರೆ ನಾಳೆ ಇಟ್ ವಿಲ್ ಕ್ರಿಯೇಟ್ ಹೆವಾಕ್. ಆ ರೀತಿ ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ.
She is claiming that she is having secured more marks. That also the word comes under ಆದ್ಯತೆ. ಸರ್ಕಾರಿ ಹುದ್ದೆ ನಿಗದಿಪಡಿಸಿದ ವಿದ್ಯಾರ್ಥಿಯಲ್ಲಿ ಹೆಚ್ಚಿನ ಅಂಕ ಪಡೆದವರಿಗೆ ಆದ್ಯತೆ.
And 3 counts.
So same yardstick.
One is a woman. According to the notification, that should be preferred.
ಅದು ಅಕ್ಯುಮುಲೇಟೆಡ್ ಅಂತ
Second, she is physically otherwise able. ಅಂಗವಿಕಲರಿಗೆ ಆದ್ಯತೆ.
Accumulated ಇಲ್ಲ.
And the order of merit.
Accumulated ಇಲ್ಲ. ಅವು cumulative ಅಲ್ಲ.
ಆಮೇಲೆ ಇನ್ನೊಂದು ಇಂಟ್ರೆಸ್ಟಿಂಗ್ ಆಸ್ಪೆಕ್ಟ್, 14 ಜನ ಸದಸ್ಯರಲ್ಲಿ 8 ಜನ they pass a resolution to appoint respondent number 5. The remaining 6 pass a resolution to appoint this appellant as this thing. The next may kindly be seen, my lord. The next column.
Meaning majority decision ಆಗಿದೆ ಅಂತ ಅದರ್ಥ ಆಗಲ್ಲ. Majority goes against you. That will not take you.
ಒಂದು ಆ ಮೆಜಾರಿಟಿ ತಪ್ಪು ಮಾಡಿ ಸ್ಟ್ರೈಕ್ ಆಫ್ ಮಾಡಿದ್ದಕ್ಕೆ all the 8 members have been disqualified by the government. Maybe the members how? Disqualified for having taken this decision.
ಅದೆಲ್ಲಿದೆ?
Please, my lord, this is next day.
All they have been disqualified.
Yes.
Correct madam.
For a minute.
ಅವ್ರಿಗೆ ಒಂದು ಕಾಪಿ ಕೊಡಿ. ಹೌದು.
Already
6 or 8 ಯಾರು ಡಿಸ್ಕ್ವಾಲಿಫೈ ಆದಂತವರು 8% sir.
The 8 persons who proposed to.
He is a candidate.
Yes. For a minute, my lord. Next sir, R10 starts from page number 100. 103 ಮುಗಿತು 104 ಇದೆ ತಮಗೆ ಕೊಟ್ಟಿದ್ದೀನಲ್ಲ ಅದರಲ್ಲಿ ಇದೆ. Internal page 4 may kindly be seen for a minute, my lord. Internal page 4, para 2.
ಇದನ್ನೇನು ಚಾಲೆಂಜ್ ಮಾಡ್ಲಿಲ್ವಾ ಅವ್ರು ಯಾರು?
ಮಾಡಿಲ್ಲ. ದಿನಾಂಕ 8/10/2021 para 2 in internal page 4. para 2, my lords. ದಿನಾಂಕ 8/10/2021 ವಿಚಾರಣೆಯಲ್ಲಿ ಎದುರಾದ ಶ್ರೀಮತಿ ಸರಸ್ವತಿ ರಮೇಶ್ ಮಾದರ್ ಮಾಜಿ ಅಧ್ಯಕ್ಷರು ಹಾಗೂ ಮಾಜಿ ಸದಸ್ಯರು ಸೋ ಅಂಡ್ ಸೋ ಗ್ರಾಮ ಪಂಚಾಯತಿ ಮುಂಡಗೋಡು ತಾಲೂಕು ಉತ್ತರ ಇವರು ವಿಚಾರಣೆಗೆ ಹಾಜರಿದ್ದು ಸೇವನ ಬಂದ ಮೆರಿಟ್ ಹೊಂದಿದ ಅಭ್ಯರ್ಥಿಯ ಆಕ್ರಮಣ ಪ್ರತಿಯಲ್ಲಿ ಗೊಂದಲ ಉಂಟಾಗಿದ್ದರಿಂದ ಸದಸ್ಯರುಗಳು ಸದನ ಸಭೆಯನ್ನು ಬಹಿಷ್ಕರಿಸಿ ಠರಾವು ಪರಿಶೀಲಿಸಲು ಸಹಿ ಹೊಡೆದು ಹಾಕಿ ಶ್ರೀ ಬಂಗಾರಪತಿಪ್ಪಣ್ಣ ಬೋಡ್ಬಾಯಿ ಮಂಜಪ್ಪ ಚನ್ನಪಡ ಪಾಟೀಲ್ ಮಾಜಿ ಸದಸ್ಯರು ಒಪ್ಪಿಕೊಂಡಿರ್ತಾರೆ. ಸದನ ಹಾಜರಿದ್ದ ಅಧಿಕಾರಿಯವರು ಮೆರಿಟ್ ಹೊಂದಿರುವ ವಿದ್ಯಾರ್ಥಿ ಕುಮಾರಿ ನೀಲಾಕ್ಷಿ ಓಂಕಾರಪ್ಪ ದೊಡ್ಡ ಅಂಗಡಿ ಇವರು ಕ್ಲರ್ಕ್ ಕಮ್ ಡಾಟಾ ಆಪರೇಟರ್ ಹುದ್ದೆಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಮಾನ್ಯ ವಿಚಾರಣೆ ಧಾರವಾಡ ಪೀಠ ರಿಟ್ ಅರ್ಜಿ ಸಂಖ್ಯೆ ದಾಖಲಿಸಲು ಈ ಪ್ರಕರಣ ಮಧ್ಯಂತರ ತಡೆಯಿರುವುದಾಗಿ ಸೂಚಿಸುತ್ತಾರೆ. ಮುಖ್ಯ ಕಾರ್ಯನಿರ್ವಾಹಕಾರಿ ಜಿಲ್ಲಾ ಇವರು ಸಲ್ಲಿಸುವ ದಾಖಲೆ ಅನುಸಾರ ಎದುರುದಾರ ವಿರುದ್ಧ ಮಾಡಲಾದ ಆರೋಪಗಳು ಸಾಬೀತಾಗಿ ವಿಚಾರಣಾ ಸಮಯದಲ್ಲಿ ಕಂಡು ಬಂದಿರುತ್ತದೆ. So they have been disqualified for a period of 6 years by the order dated 14/12/2021.
Are you sure? We'll record your submission. Are you sure? Ask
100%
counsel.
That's a document placed on record, if your lordship.
So, is it questioned? Is it questioned? Record your submission. If you answer, if it is wrong, then it will be difficulty. Please tell. Was it questioned, quashed, any merit proceedings are taken up against this?
Please, the preamble of the.
ಅವ್ರಿಗೆ ಹೇಳಿ ನಾವೇನ್ ಕೇಳ್ತಾ ಇದೀವಿ ಅಂತ ಹೇಳಿ.
ಮಾಡಿಲ್ಲ.
You are sure that it
as far as my knowledge goes.
Knowledge ಅಂದ್ರೆ ಅರ್ಥ ಏನು? On what basis you formed your knowledge, belief?
That has to be, Jilla Panchayat has to make it sure. We are not.
ಜಿಲ್ಲಾ ಪಂಚಾಯತ್ ಯಾರು?
You are served unrepresented.
Served unrepresented. ಅವ್ರಿಗೇನು ಇವ್ರು ಬಂದ್ರೇನು ಅವ್ರು ಬಂದ್ರೆ ಯಾರಿದ್ರು ನಡೆದು ಹೋಗ್ತಾರೆ. ಎರಡೂ ಕಡೆಯಿಂದ ದುಡ್ಡು ಬರ್ತದೆ.
Government also being a party, government should get it clarified.
ಇದನ್ನ ಈ ಆರ್ಡರ್ನ ಅದರ ರಿಪೀಟ್ಸಿನ ಚಾಲೆಂಜ್ ಮಾಡ್ರೆ ನೋಡಕ್ ಆಗ್ತದ ನಮ್ಮ ಇದರಲ್ಲಿ ಗೊತ್ತಾಗ್ತದ?
ಗವರ್ನಮೆಂಟ್ ಆರ್ಡರ್ ಹಾಕಿದ್ರೆ ಬರುತ್ತೆ.
ಗವರ್ನಮೆಂಟ್ ಆರ್ಡರ್ ಈ ಗವರ್ನಮೆಂಟ್ ಆರ್ಡರ್ ಅಲ್ಲಿ
ಚೆಕ್ ಮಾಡ್ತೀನಿ.
ಚೆಕ್ ಮಾಡಿ ಕೊಡಿ ಬೇಕು.
ಪ್ಲೀಸ್
ಈಗಲೇ ಕೊಡಿ.
ಲೋಕೇಟ್ ಆರ್ಡರ್ ಅಂತ ಹಾಕಿದ್ರೆ ಜಿಯೋ ತೋರಿಸುತ್ತೆ ಮಾಡಿ ಫೋಟೋ ಆರ್ಡರ್ ಹೊರಗೆ ಇದ್ದಲ್ಲ
ಅವನ್ನೆಲ್ಲ ಇಂಥ ಆರ್ಡರ್ಸ್ ಹಾಕುವಾಗ ಒಂದು ಚೆಕ್ ಮಾಡ್ಕೋಬೇಕು. ಎಲ್ಲರ ಚಾಲೆಂಜ್ ಆಗಿ ಕ್ವಾಶ್ ಆಗಿ ಆಗಿದ್ರೆ.
As far as the instructions of the appellant are concerned, from the same locality, and as for their instruction, they have not challenged it so far. This is the order of 2021, and we are in 24. So December 21 order.
ದಿನೇಶ್ ಏನಿಲ್ಲ. ಏನ್ ಡಿಫರೆನ್ಸ್ ಬೇರೆ ಏನಿದೆ? ಈ ಆದ್ಯತೆ ಅನ್ನೋದು ನೋಡಿದ್ರೆ ಮಾತ್ರ ಅಷ್ಟೇ ತಾನೇ?
ಅಲ್ಲ, what happened, my lord, earlier she filed a writ petition. Earlier she filed a writ petition without making the selected candidate as a party. A direction was issued to accommodate her as per the appointment letter. That was challenged.
ಅದಾದ್ಮೇಲೆ ನೀವೇನ್ ಮಾಡಿದ್ರಿ?
Writ appeal ಹಾಕೊಂಡ್ವಿ. Writ appeal ನಲ್ಲಿ liberty was given to file a fresh writ petition challenging the very same order. I filed the writ petition challenging the same order and also the brought to the notice of the court regarding all this. The impugned order, my lord.
ಆ ರಿಟ್ ಪಿಟಿಷನ್
In view of, my lord, allowing my writ petition, the court observes the interfering the earlier order passed by writ petition is not necessary. That observation, my writ petition came to be allowed. My appointment is upheld.
appointment is upheld.
That itself is
11
included in
onwards,
this
my lord.
petition.
Order of the learned single judge. Para 11 onwards, I am permitted
is
to read.
considered.
ಹೌದು.
ಅದು ಕನ್ಸಿಡರ್ ಆಗಿದೆ.
ಅಲ್ಲ, ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ದಾರೆ. How, my lord, the court has come to conclusion regarding, my lord, the appointment. Para 11 onwards, my lord. From the reading of resolution dated 7/11/2017 by the Gram Panchayat, it is very clear that out of 14 members, 8 members had resolved to appoint the petitioner to the post of clerk cum computer operator, and remaining 6 had resolved to appoint the respondent 5 to said post. The said fact was not brought to the notice of this court in WP number so and so, and attention appears to have been drawn only to the resolution of 6 members out of 14 members who had resolved to recommend the selection of respondent number 5 to the post of clerk cum computer operator. Under these circumstances, it appears that the court has observed that majority of the Gram Panchayat members had resolved to select the petitioner as a clerk cum computer operator on the ground that she has secured.
ಕನ್ಸಿಡರ್ ಅಂತ ಮಾಡಿದ್ವಿ.
See, the way, the para 11, my lord, is contrary to rule of law. Rule of law is overruled by the learned single judge.
No.
If by majority, if they pass some illegal resolutions, can it be given an effect by the courts? It's a question.
This was decided when?
This is decided on
June 2023.
6th June.
Why did you not tell the learned single judge about this order? Which now you want to produce, this you had not pleaded at all.
You have produced the copy.
You had produced copy?
Yes.
Before single judge, we have produced.
It was produced at annexer R10.
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 Out. Starts from page 100.
ಪ್ಲೀಡಿಂಗ್ಸ್ ತೊಳಿಲ್ಲ, ಪ್ಲೀಡಿಂಗ್ಸ್ ಅಮೆಂಡ್ ಮಾಡಿಕೊಳ್ಳಿಲ್ಲ.
Statement of objections ಹೇಳಿದೀವಿ.
ನಿಮ್ಮ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿರ ಅದನ್ನ
ಮಾಡಿದ್ದೀವಿ.
ಎಲ್ಲಿದೆ?
My lord, it starts from page 72.
72.
Yes. Page 77, paragraph 76 it starts, my lord. In page 76, paragraph 15 of my statement of objections. It is submitted that the CEO of Karwar has initiated the.
Yes, he has taken up that contention.
Yes.
That is not treated by the learned single judge. You have specifically taken.
For the 77.
I was under impression for the first time he was producing it. That was not, that was produced also.
ಹೌದು, that was there on record.
Annexer R10 ಆಗಿತ್ತು.
ಹೌದು.
ಮತ್ತೆ ಈಗ ಯಾಕೆ ಹಿಂಗ್ ಕೊಡ್ತಾ ಇದ್ದೀರಿ?
ಅದು ಒಂದು ಪೇಜ್ ಮಿಸ್ಸಿಂಗ್ ಆಗಿತ್ತು ಅಪೀಲ್ ಫೈಲ್ ಮಾಡುವಾಗ ಆಪರೇಟಿಂಗ್ ಪೋರ್ಷನ್. ಅದಕ್ಕೆ ನಮ್ಮ ಗಮನಕ್ಕೆ ಮೈ ಲಾರ್ಡ್ Panchayat for the offence under section 43A and 48A of Karnataka Gram Swaraj Act. Then members of Gram Panchayat have manipulated the resolution book.
Writ petition, writ appeal allowed on the following grounds. One.
One grounds. If you take the notification which is issued, my lord, it does not prescribe only on the basis of 10 marks card or PUC marks.
No, let all those things now will pale into insignificance because
Please.
the government has punished them for passing the wrong resolution.
My lord, if you say them, Lord, this order, the order which is, they have debarred, my lord, for contesting elections, under section 43 of the Act, my lord.
So they are punished.
and they have been disqualified to continue as the members.
Lord, that cannot be a basis to set aside all those orders which they have made while conducting, while doing the, Lord, their official work. Otherwise, Lord.
That
only-
resolution.
No, 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 Lord.
That has been,
No, no.
they have, the government has commented so bitterly on these, what, see the way how they have passed the resolution.
ರೆಸಲ್ಯೂಷನ್ ಅದರಲ್ಲಿ ಹೇಳಿದ್ರೆ ಸ್ವಲ್ಪ ಗಲಾಟೆ ಮಾಡಿದ್ದಾರೆ ಅಥವಾ ಹರಿದು ಹಾಕಿದ್ದಾರೆ ಅನ್ನೋ ಅದೋ ಒಂದೇ ಕಾರಣಕ್ಕೆ ದೇವ ಮನೆ
ಮೊದಲು ರೆಸಲ್ಯೂಷನ್ ಪಾಸ್ ಆಗಿತ್ತು,
ರೆಸಲ್ಯೂಷನ್ ಮಾಡಿ
ಆಮೇಲೆ ಹರಿದು ಹಾಕಿದಾರೆ ಅದನ್ನ. ಮತ್ತೆ ಇನ್ನೇನ್ ಬೇಕು ಅದಕ್ಕಿಂತ ಜಾಸ್ತಿ?
ದಟ್ ಕೆನಾಟ್ ಬಿ ಗ್ರೌಂಡ್ otherwise what happens,
Otherwise everything have, nothing will happen.
All those act.
Otherwise ಆ ಇಲ್ಲಿಗಲ್ ಥಿಂಗ್ ಮಾಡಿದ್ದಕ್ಕೆ ಅವ್ರಿಗೆ ಪನಿಷ್ಮೆಂಟ್ ಮಾಡ್ತೀವಿ ನಾವು, ಬಟ್ ಇಲ್ಲಿಗಲ್ ಥಿಂಗ್ಸ್ ಅನ್ನು ನಾವು ವಿಲ್ ಕೀಪ್ ಇಂಟ್ಯಾಕ್ಟ್. ಫ್ರೂಟ್ಸ್ ಆಫ್ ದಿ ಪಾಯ್ಸನಸ್ ಟ್ರೀ, ಫ್ರೂಟ್ಸ್ ಆಫ್ ದ ಪಾಯ್ಸನಸ್ ಟ್ರೀ ಡಾಕ್ಟ್ರಿನ್ ನಲ್ಲಿ ಬರುತ್ತಿದೆ. ಇಫ್ ಎ ಟ್ರೀ ಈಸ್ yielding the poisonous tree, it has to be cut at the root. Fruits of the poisonous tree ದಲ್ಲಿ ಬರುತ್ತಿದೆ.
There is no finding that because of the illegal acts or whether they have done less merited candidate has been appointed. There is no.
ಅದು ನೀವು ಹೇಳೋದು ಎಲ್ಲಿ ಗೊತ್ತಾ, ಅದಕ್ಕೆ ಒಂದು ಡಾಕ್ಟ್ರಿನ್ ಆಫ್ ಡಿ ಫ್ಯಾಕ್ಟೋ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಅಂತಿದೆ, ಅದು ಇದರಲ್ಲಿ ಅಪ್ಲೈ ಆಗಲ್ಲ. This is a thing which has been done blatantly in violation of law, and see the propriety, impropriety.
Then my remedy is, let the matter, let the read and the,
Why read? There is already resolution. No resolution is passed.
That resolution is not set aside. And
We will set aside now.
no, my appointment cannot be set aside based on that.
Because
Not, even otherwise the qualification is considered.
There is one more thing, if tomorrow, we don't know, this order is set aside by the High Court.
ಅವಾಗ ನೀವು seek recall of this order, will recall also.
Otherwise.
As long as the order remains, as long as the order remains, so long the consequences will follow.
And one more thing, there is no appointment order of this appellant. It is the appointment of this respond number 5 under the impugned resolution. Whether unless setting aside that resolution and the appointment process, whether my lord the.
No, we'll pass the order. The power of the writ court, see Kalinga tubes, the power of the writ court is measured by the power of the authority whose proceedings are put in challenge.
There may be chances, some more meritorious than the appellant.
Somehow you want to sustain it, Berkeley.
One more thing,
Writ petition is
I
allowed
have
on
been
that.
appointed, given an appointment order, and by an annexed queue, my appointment has been approved by the Jilla Panchayat. That queue is caused by the Learning Single Judge. That's all, my lord.
Appointment order is issued.
Issued.
Tell it.
My lord, it is at page R2, page 83.
83.
Yes.
My lord, that was issued based on the earlier order passed in the writ petition.
See,
In reference
my
to.
application was pursuant to the notification inviting applications and I have been duly appointed. My appointment is issued, and by annexed R3, I have reported to the duty also.
It is in reference to earlier order passed in writ
I have
petition.
seen that. You have seen that. That is relatable to earlier order.
Yes, that was challenged in the.
Pursuant to the same notification.
Is allowed on the following ground. Number 1, earlier proceedings were held by the Gram Panchayat another.
Yes, my lord, Gram Panchayat,
Gram Panchayat. Kudgadi.
R4.
Kudgadi. Earlier, Gram Panchayat had passed the resolution to accept the candidature of the appellant herein as clerk cum data entry operator. First, apparently, the appellant is more meritorious than the contesting private respondent herein. First, this, that apart, she is a lady candidate coupled with physical handicap. First, she had secured, her qualifying marks were 484 out of 600, whereas that of the contesting respondent were 385. First. That being the position, the candidature of the private respondent could not have been accepted for the post in question. First up, next paragraph. The members of the Gram Panchayat who were 14 in number had participated in the proceedings on the eventful day. First up, the resolution came to be passed accepting the candidature of the contesting respondent by a majority of 8:6. Semicolon. There was some misbehavior and misconduct by these 8 people, which has been spoken of in the government order dated
14th December 2021.
14 December 2021, that eventually resulted into their disqualification for a period of, for their electoral disqualification for a period of 6 years under the provisions of section 43 capital small a small 6 Roman 6 of
Section 12.
read with section 12L
Yes.
12LE of the Gram Swaraj Karnataka Gram Swa Panchayat Raj Act 1993. First up, at page 4 of the said order, it is stated as under. First up, this shows that the resolution whereby the appointment was bestowed upon the private respondent herein is nothing but fruit of a poisonous tree, and therefore nobody can eat it. This aspect of the matter has not been considered by the learned single judge, despite a specific contention to that effect was taken up at the para so and so 15 of the statement of objections.
By the next R10 also.
And the government order, copy of government order 2 was produced as annexure or 10. First, had a learned single judge adverted to the same, comma, the end product of the writ petition would have been much different. First, in the above circumstances, this appeal is allowed, semicolon. Impugned order of the learned single judge is set at naught, semicolon. Writ petition number so and so filed by the contesting respondent is dismissed. First, the consequence, the appointment shall be issued to the appellant to the post of clerk cum data entry operator within in the subject within a period of 8 weeks. Within a period of 8 weeks. First, if he is broken, the same shall be viewed very seriously. First stop. Next paragraph, sentence particular. Ordinarily, a writ court, be it at the original level or at the appellate level, would not direct grant of appointment letter. First. However, the peculiar facts of this case would not leave any discretion to this court than to direct appointment in an unusual way. First. Okay, ಅದೊಂದು start. costs reluctantly made easy.
Deeply applied.
Liberty may be reserved, Lord. If that order is set aside by the competent court, liberty to move this court, Lord, for review of the order.
For any reason, if the order whereby the 8 members of the elected members of the Gram Panchayat have been disqualified, comma, is set at naught in an appropriate proceeding, comma, it is open to, no, brother, we will not reserve liberty because even otherwise meritorious candidate, to lady candidate to handicap.
That contentions are not appreciated.
No, it's apparent. It is apparent on merits also, she is. Recall that.
This is the only factor.
ಆದ್ಯತೆ ಮೂರಿದವು. Though cumulative ಇಲ್ಲ ಅಂದ್ರೂ ಸಹಿತ, he is not in a position to answer properly. There are judgments which he has not brought. I'm sorry, I'm also sorry to say this.
Preference ಅಂದ್ರೆ ಏನಂತ?
Preference ಅಂದ್ರೆ ಏನು ಯಾವ್ದ್ರಿ judgment ಅದು ಕೊಡಿ.
Equal ಬೇಕು.
ರೆಡಿ ಮಾಡ್ಕೊಂಡ್ ಬರ್ಬೇಕು, ನೀವೆಲ್ಲ senior advocates ನೋಡ್ತಿರ್ತಾರೆ ಮತ್ತೆ.
That principle applies to her also. She also will be seeking appointment as she has secured more marks.
No, his candidate has secured more marks.
ಅಲ್ಲ, ಅದಕ್ಕೂ ಆದ್ಯತೆ ಅಂತಾನೆ ಇದೆ.
Preference, the expression preference amongst others means prior right, advantage, per se, etc. But how would it be possible to give precedent on one over the other? It signifies that the other things being equal, they do not do the research at all. You people, I'm sorry, but 84, 1 SCC, 107, Supreme Court said, where everything is equal, then the question of preference arises, not otherwise. Here, 84 Supreme Court and report. The senior advocate, Mr. So submits that the question of preference arises where everything is equal and not otherwise. And the enumeration in the subject recruitment notification has to be construed accordingly, first off. This we agree, since same is echoed by the apex court in Sher Singh versus Union of India, 1984, 1 SCC 107. Adon ground ಮಾಡಿ structure ಮಾಡಬೇಕು judgment ಅನ್ನ, please.
Membership restored also, nothing will happen.
Nothing will happen.
Merit has to
Quite
prevail.
naturally, yes, sir.
Merit has to prevail.
Notification clear ಇಲ್ಲ, only on the basis of 10th marks card ಅಂತ ಹೇಳಿ ಉಳಿದಿದ್ದನ್ನ ಪ್ರಿಫರೆನ್ಸ್ ಅಂದ್ರೆ ಇಲ್ಲ.
Merit is very clear. It is not even age.
ಅವ್ರನ್ನ ಕಿತ್ತು ಹಾಕಿದ್ದಾರೆ, ಡಿಸ್ಕ್ವಾಲಿಫೈ ಮಾಡ್ಯಾರ ಒಂದು 6 years. ಸ್ಟಿಲ್ ಅದು ಮಾಡಿದ ಬ್ಯಾಕ್ಗ್ರೌಂಡ್ ಮೇಲೆ ಹಿಂಗ್ ಮಾಡಿದ್ದಾರೆ ಅನ್ನೋದಕ್ಕೆ ಮಾಡಿದ್ದಾರೆ. ನೀವು ಹೇಳಿದ ಡಾಕ್ಟ್ರಿನ್ ಆಫ್ ಡಿಫೆಕ್ಟಿವ್ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಮೇಲೆ ಒಳ್ಳೊಳ್ಳೆ ಜಜ್ಮೆಂಟ್ಸ್ ಇದೆ. ಜಸ್ಟಿಸ್ ಚಂದ್ರಶೇಖರ್ ಅಯ್ಯರ್ ಅವ್ರ ಜಜ್ಮೆಂಟ್ ಇದೆ, ಪ್ಲಸ್ ದಿ ಜಜ್ಮೆಂಟ್ ಆಫ್ ಜಸ್ಟಿಸ್ ಸೀನಿಯರ್ ಚಂದ್ರಚೂಡ್ ಸಾಹೇಬ್. ಡಿಫೆಕ್ಟಿವ್ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಯಾವಾಗ ಬರ್ತದೆ ಅಂದ್ರೆ, ಸಪೋಸ್ ಒಬ್ಬ ಪರ್ಸನ್ ಅಪಾಯಿಂಟ್ ಮಾಡಿರ್ತೀವಿ, ಅವ ಎಲ್ಲ ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಆಗಿ ಅವನ್ನೆಲ್ಲ ಆರ್ಡರ್ಸ್ ಮಾಡ್ತಾರೆ 36(2)(3) ಅವು ಇದ್ರ ಮೇಲೆಲ್ಲ. ರಾಮಾಂಜನೇಯ ಆಗಿತ್ತು, ಡೆಪ್ಯೂಟಿ ಕಮಿಷನರ್ ರಾಮಾಂಜನೇಯ ಆಗಿತ್ತು. ಇಲ್ಲಿ if his appointment is settled, the actions taken by those persons will be saved by employing the doctrine of de facto representation. ಆ ರೀತಿ ಮಾಡ್ಬೇಕು ಆರ್ಗ್ಯುಮೆಂಟ್. ನೋಡಿ
11, Ashok Naik.
Yes, my lord. I am for appellant, my lord. Clement appeal for announcement.
ಏನು ground ಮೇಲೆ? Income.
My lord, consortium and income, my lord.
13,750 plus 40%.
Tribunal ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ?
Madam?
Tribunal
10,000, my lord.
10,000.
10,000.
ಇದು ಕರೆಕ್ಟ್ ಇದೆಯಾ? Loss of 40%. Consortium ಇದು ಕರೆಕ್ಟ್ ಇದೆ ಅಲ್ಲ?
ಉಳಿದೆಲ್ಲ ಸರಿ ಇದೆ. Done.
Dispose.
Please.
12, government has to be referred to the learned.
Please report indicate that the matter is required to be posted to the learned single judge. Said note is accepted, registered to verify once again and post before appropriate jurisdiction.
13, Shantha Gowda.
Very limited question I am before this.
Yes.
What has happened, my lord? There is an interim order which was granted. I had challenged the order of the land tribunal before the learned single judge. Only on the ground that the tribunal, while granting occupancy right, has held that the surrender which was of lease, which had happened on 15/10/1955,
Surrender.
surrender of lease, which had happened in 15/10.
The Land Reforms Act came into force only in 1961.
That is what I want to tell. The tribunal, that is the only,
ಅದ್ಯಾವ್ದು surrender ಯಾವ ಆಜ್ಞೆ ಮಾಡಿದ್ರು?
under the Bombay Agriculture and Tenancy Act.
Surrender ಆಗಿತ್ತು.
Agide, I mean, there was a Tehsildar order also, Panchanama also, everything was done. Thereafter, the property has been sold also.
One second. The tenant had surrendered.
And there is a Tehsildar order also, conducting inspection.
Surrender is registered.
It's not registered, my lord.
There is
Under
one
that,
judgment of Apex Court, which went from Bombay High Court. The surrender needs to be registered and told.
no, there are certain other authorities also, my lord, which complies that, which in fact, with the authority, everything I was ready, there was an interim order which was granted. One of the party has expired. I filed an amendment application, allowed, it was allowed. Only amendment was, even amended petition was also filed. Only amendment was not carried out. On the day of only the matter came up, my lord, I could not appear through online. The Honorable learned single judge has discontinued the interim order and revoked the earlier order of bringing LRs on record. Only on that point, if the direction that matter can be disposed of, only on that point I am.
If it was, my lord, normal circumstance, my lord, I wouldn't have opposed the writ appeal. Or, my lord, may I request, my lord, since there is, my lord, statement which are on oath, which are made contrary to the record, and, my lord, allegations are made in writ appeal.
Surrender ಆಗಿತ್ತು ನಿಜನಾ?
My lord, that is not an issue. My lord, in the present appeal, my lord, may I request, my lord, page 70, my kind.
Anyway, now we are asking you.
Yes.
Many times we see amendment ಆದ್ಮೇಲೆ ordinarily within two weeks, 15 days amendment ಮಾಡಬೇಕು. ಯಾವ್ದದು? Order
6 rule 18.
Rule 19.
18.
Order 6 rule. And that is held to be applicable to writ proceedings also because of rule 39 of writ proceeding rules. ಏನೋ ಒಂದು amendment ಮಾಡಿಲ್ಲ. But court has got power to give time there also. ಅದನ್ನ explore ಮಾಡಿಲ್ಲ.
Moreover, legal representative.
Statement which is made on oath is contrary to the record. My lord,
In statement.
my lord, the affidavit which is filed before the learned single judge was, my lord, amendment is already carried out.
There's a mistake.
My lord,
I agree, my lord.
that is the reason.
Agree,
My lord,
I
that is-
mistake, I agree.
What ಇತ್ತು? ಏನದು? Whether amendment is carried out or not will be looked into, can be ascertained by looking into the originals. Record ನಲ್ಲಿ. ಏನೋ ಒಂದು by mistake ನಲ್ಲಿ ಏನೋ ಒಂದು
My
ಹೇಳ್ತಾರೆ.
lord, my lord, learned single judge proceeds on the basis, my lord, he took note of the fact.
Just ಮಾಡಿ. Suppose if you also come about in 2018, you came out with the same plea. I can find out that WP number, where you said merely because amendment is not carried out, straightway the amendment could not have been struck off. An opportunity should have been given to the council to make amendment. I upheld that
Yes.
submission also. So the same position applies. ಈ ರೀತಿ ಮಾಡೋದು ಬೇಡ. ಏನು entry order ಇತ್ತಲ್ಲ, entry order continue ಮಾಡಿ. We will request the learned single judge to dispose of the writ petition.
Prover, when the
My lord,
LR
if it
application
was,
was
my lord,
issued,
normal-
they have filed a wakalat. His own
My lord,
colleagues,
if
he has
it had
filed a
been
wakalat.
normal circumstance,
Way of
my lord, I
offense.
wouldn't have opposed the writ appeal also. Nor, my lord, we are not opposed the application also. My lord, just bring to my lords 3 documents. My lord, where, my lord, writ petitioners, my lord, in spite of, my lord, knowing the fact that the person has died, my lord, it is reflected in the writ petition that he has passed away. My lord, applications were filed to bring the LRs. My lord, we never opposed. Then, my lord, applications were allowed. My lord, we never opposed. Then, my lord, when the matter was listed for non-carrying out the amendment, my lord, at that time, I never opposed. Then, my lord, an application is filed saying that, my lord, we have already carried out the amendment. Amended cost title is already filed. My lord, this honorable court, looking into the fact that the statement is made that, my lord, amendment is not carried out. My lord, this is a
This intra-court appeal calls in question an interim order. That's all. ನೋಡಿ ಎಷ್ಟು books ಕೊಡ್ತೀರಿ? How many books you will present to your landlord?
No, I'm a subsequent purchaser, my lord. Anything what the court.
For his mistake.
Yeah, my mistake also.
Lighter.
Yes, yes. Anything, my lord, further association.
ಒಳ್ಳೆ ಒಂದು 4-5 ಪುಸ್ತಕ ಕೊಡ್ಸಿ.
Please, my lord, I'm ready.
This intra-court appeal calls in question a learned single judge's interim order dated so and so, whereby interim relief granted to the appellant herein in the pending WP number so and so has been discontinued. And also the application that was allowed for granting, bringing LRs.
Bringing LRs which were allowed has been revoked.
That was
Recalled,
allowed
sorry.
for bringing LRs of the
52
deceased. Yaru, deceased?
This is the respond number 2, my lord.
Second respond number 2 also has been rescinded. First of all, the short order reads as under. Next paragraph. Learned counsel appearing for the contesting respondents vehemently opposes the appeal, contending that such an intra-court appeal is not maintainable in view of Tammanna versus Renuka, semicolon. The conduct of the writ petitioner, who happens to be the appellant herein, having been blemished, comma, the said order came to be passed by the learned single judge, and therefore no leniency should be shown by the appellate court. First, so contending, Kuthwali, please be seated. He seeks dismissal of the appeal. Next, having heard the learned counsel for the parties and having perused the appeal papers, we are inclined to grant conditional indulgence in the matter as under, as and for the following reasons. 1, the writ petition, the subject writ petition in number 103727 of 2023 lays a challenge to the tribunal's order whereby occupancy has been granted to the contesting respondent side. First up, the appellant had was granted reprieve by the ಬೇರೆ judge ಕೊಟ್ಟಿದ್ರಾ? By other learned single judge, staying the staying operation ಅನ್ನೋ
Operation.
staying up. ಕುತ್ಕೊಂಡು ಹೇಳಿ. This is not primary school. We are all members. ಏನೇನೋ ಕಾರಣಕ್ಕೆ ನಾವು ಈಗ ಕೊಡ್ತೇವೆ. ನೀವು you have the pleasure of sitting that side. We have, I don't say displeasure, but we sit this side. ಏನ್ ಪ್ರತಿಮಾ? Full stop. And the same was continued from time to time. Full stop. However, on some fault, which of course is demonstrable from the records, comma, the other learned single judge, the learned single judge passed the impugned order, which appears to be a bit harsher than the usual. First up. Next paragraph. True it is that ordinarily when leave is accorded for bringing the LRs of the deceased party or for amending the pleadings, comma, such amendments, be it in the cause title or in the body of the pleadings, needs to be carried out within a period of 15 days as prescribed under Order 6, Rule 918 of CPC 1908. Full stop. This provision of the CPC is made applicable to the writ proceedings as well in view of Rule 39 of writ proceeding rules 1977. Full stop. Of course, discretion lies to the court, with the court, in extending the period for making such amendments. First off, discretion has been exercised by the learned single judge to the prejudice of the appellant herein, after finding that certain aspects which he had told the court in the form of affidavit were found to be not true. First off, everything should go according to the tenets of truth, since our constitutional, since the High Court's motto is Satyameva Jayate. Satyameva Jayate is also true, full stop. But at times, mistakes are committed, and that they are not irretrievable. They are not, they are not incorrigible. First, justice of the case warrants that the impugned order needs to be set at naught, and the reprieve granted in the subject said writ petition needs to be revived, subject to condition. First, in the above circumstances, we allow this appeal, semicolon, the impugned order of the learned single judge is set at naught, semicolon. As a consequence, the interim order dated
23/6/23. 23/6/23.
continued. Semicolon. The order whereby the LR application was allowed is revived. Interim order revive banta? Interim order is continued. But the appellant shall effect necessary changes to the pleadings in the writ petition, in the pending writ petition, within 2 weeks.
It's already done.
First stop.
Already done.
Madidara, if already not done. If already not done. Anyway. ನೋಡ್ಕೊಂಡ ಮಾಡ್ದಂಗೆ ಕಾಣ್ತಾರೆ.
Application in the.
He has helped you.
Fact on the.
ಹಿಂಗೆಲ್ಲ ಮಾಡಬಾರ್ದು. The appellant shall present a set of 5 books you have to give. The following 5 books to the read Vamsharuksha of Bhairappa, S.L. Bhairappa. He discusses pious obligation in Hindu law. And the Chief Justice of our High Court, I think Govind Bhatt, he had suggested to the advocates to read it before arguing matters pertaining to pious obligation in the Hindu law. That Katyayani, etc., that some Rao who writes history, etc. It's a very good book. Ratne from Sri Lanka, her conduct. So many things are discussed in that one book.
One book to me.
1 second. Huh?
One book to me.
Yeah.
No, he himself has a big library. Father is a great thinker and writer also.
Encyclopedia.
ಆಯ್ತಾ? ಒಂದು ವಂಶವೃಕ್ಷ ಕೊಡಬೇಕು. ನಂತರ ಪಿ ಲಂಕೇಶ್ ಅವರ ಹುಳಿ ಹುಣಸೆ ಮರ ಅನ್ಕೊಂಡು ಒಂದಿದೆ, ಓದುವಂತ ಪುಸ್ತಕ. ನೀವು ವ್ಯೂಸ್ ಯಾರ್ಯಾರೋ ಏನೇನೋ ಕ್ರಿಟಿಕಲ್ ಇರ್ತಾವ ಬೇರೆ, ಬಟ್ ಭಾಷಾ ಪ್ರೌಢಿಮೆ ತುಂಬಾ ಚೆನ್ನಾಗಿದೆ. ಅದೊಂದು ಹುಳಿ ಹುಣಸೆ ಮರ. ಅರೆ ನಂತರ ನಮ್ಮ ಟ್ಯಾಗೋರ್ ಅವರ ನೌಕಾಘಾತ ಅನ್ಕೊಂಡು ಒಂದಿದೆ. ದ ಶಿಪ್ ರೆಕ್ ಅಂತ ಮಾಡ್ಯಾರ, ದ ರೆಕ್ ಅಂತ ಇಂಗ್ಲಿಷ್ ನಲ್ಲೂ ಇದೆ, ಅದೊಂದು ಕೊಡ್ಬೇಕು.
2 sets I'll give anything.
Roses in December by M.C. Chagla, the great judge. Yes, wonderfully
Turning law.
Then All from Memory by B.V. Acharya. He is also Bhishma Pitamaha of our High Court. Okay, 5 books you have to give to the library.
Please.
All right.
Yes.
Thank you.
One sufficient. My lord, my application for vacating is disposed of.
ಅದು dispose of ಆಗಿದೆ.
By virtue of my lord discontinuing the interim order, my application at IA number 23 is disposed of.
The application in IA number
1 of 23.
1 of
23.
2023 may be heard by the learned single judge. In view of this order.
Please, great.
This order.
14 days ಇದೆ. 6 rule 18, 14 days ಇದೆ.
14 days ಇದೆ ಅಲ್ಲ? 14 days, correct. ಅಲ್ಲಿ 2 weeks ಇದೆ ಅಲ್ಲ? 14 days. You should thank our gracious friend.
Yes. He has been
great respect for all, and for him, of course, it is quite natural.
Great.
Yes.
14, Srinivas P. Naik.
He needs, my brother is saying your team has to be widened now.
Yeah.
Enlarged. Prashant also.
Yes, my lord.
All.
14. Any of the next?
Lords, wife's appeal challenging the decree of divorce, my lords.
Dismissed, huh?
No, my lords, divorce has been granted, your lords,
Granted.
on the ground of desertion, my lords.
Application is not filed.
It's filed, my lords,
First day.
at page number.
Lifted. What are the office objections you are not complying?
Lords, office objection is with regard to payment of court fees, my lords. Court fees has been paid, your lordship.
Paid.
And another office objection is,
Paid.
please,
When you have paid?
last week, your lordship.
Not paid. Records.
Why she will lie?
And with regard to signature of the presiding officer at the order portion of the judgment, my lords. At page number 15 of the judgment, your lordship.
15, huh?
15 of the judgment, my
What
lords.
makes the difference? How that can be a ground? If an order is pronounced in the open court, whether it bears signature or not, it is judgment. There are such judgment. Merely because he has not said, can we set aside the order on that ground?
My lords, office objection is with regard to.
Office objection.
Yes.
What kind of office objection?
They are-
What he should do, she should do.
That court fee is paid, which is to verify. Insofar as other office objections are overruled. Next, issue emergent notice, delay is there?
No, my lords.
Delay.
No delay.
Application.
It's not pressed, my lords.
Abundant.
Delay is not, there is no delay,
No delay.
no delay.
You have this,
You sit down, she is doing so well. She is arguing, we have seen her arguing other matters also.
Meanwhile, there shall be an interim order of stay of the imputed judgment and award of the family court dated so and so, past and so and so. Further,
Yenigi.
the respondent husband is restrained from contracting second marriage. All parties.
ಈ ಏಣಿಗೆ ಇದೆಯಲ್ಲ, ಏಣಿಗೆ ಬಾಳಪ್ಪನವ್ರ ಊರನು? ಅದೇ ಊರಾ? ಅದೇ ಊರು. Great singer.
15. Lingaraj Maradi.
Is a claimant appeal for enhancement.
Notice delay ಇದೆ.
Yeah,
489 days.
ನೀವು ತಗೊಳ್ತೀರಾ?
ಅಲ್ಲ, already notice was ordered. I don't mind.
Caution, delay of 489 is days in judging the appeal is condoned by denying the interest if the appellant claimant succeeds in the appeal.
Till today ಅಂತ ಮಾಡಿದ್ರೆ ಅನ್ಕೋ. 2016 ಇಂದ ಇಲ್ಲಿ ಮಟ್ಟ ಅವರು ಸುಮ್ಮನೆ this appeal is kept idle before this honorable court.
Till this day. You are right.
He is not entitled, first delay. If he he is not entitled to claim interest for 489 days delay as well as from the filing of appeal to this day. ಏನು ನೋಟಿಸ್ ಆಗಬೇಕಾ? ನೋಟಿಸ್ ಆಯ್ತಾ?
Notice order ಆಗಿದೆ. It has to be heard.
Argue.
is a connected matters, my lord, that 5 more matters.
List with so and so.
But those are pertaining before, pending before the learned single judgment.
Single judge ಕೊಡ್ಬೇಡಿ.
Oh, my lord, there is a common judgment.
No,
There is a some,
sir, we
Oh,
can't-
pending, ಯಾರ ಮುಂದೆ pending ಇದಾವೆ?
Single ಮುಂದೆ.
ಇದು ನಾವೇನ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರ್ತದೆ?
that will-
ಇದನ್ನ ಆರ್ಗ್ಯೂ ಮಾಡಿ, they will duplicate this order in those petitions. Those appeals.
You are not filed appeal, huh?
ಇಲ್ಲ.
ಏನಿದೆ?
This is only appeal before the division bench?
ಹೌದು, ಇದು ಒಂದೇ ಇದೆ. They are claiming 25 lakhs.
this is a short synopsis, my lord.
They are claiming 25 lakhs in this case.
4-1 notification on 12/5/2010, my lord. The purpose of the acquisition is the construction of the Chinagu Kere near the Pennur village. And the total extent of land is 3 acre 23 gunta. And the SLO has a highland, and the fixed land rupees 36,160 rupees per acre on 29/2/2012 that an award. And in the reference application, we are claiming the 25 lakh per acre. And reference court has considered a capitalization method to growing up the paddy crop allowed. He has announced rupees 2,54,760. And in this appeal, my lord, I have relying the, there is exhibit P13, 14, 15 sale deeds of the Karnataka village. These are
ಯಾವ year?
is in the year of
2009.
5/8/2009 and 1/7/2009 and 96/2009 sale.
ಅದು ಎಕರ್ ನಲ್ಲಿ ಇದೆಯಾ, ಸ್ಕ್ವೇರ್ ಫುಟ್ ನಲ್ಲಿ ಇದೆಯಾ?
It is in the square feet, my lord.
ಸ್ಕ್ವೇರ್ ಫೀಟ್.
These are the converted lands.
ಸ್ಕ್ವೇರ್ ಫೀಟ್ ನಾಗ ಇದ್ದಾಗ ಅದು ಕನ್ವರ್ಟೆಡ್, ನಿಮ್ ಕನ್ವರ್ಟೆಡ್ ಅಲ್ಲ.
ಇಲ್ಲ.
And exhibit P18, my lord. That is the same village
guidelines value of this sub-register valuation, 4,50,000 for the irrigated land.
Guideline irrigated.
Irrigated.
Dry ಗೆ?
This is Nandu irrigated land. It has been
Irrigated.
considered in the reference code. It's considered as a irrigated land.
ಗಾಡಿ ಲ್ಯಾಂಡ್ ನಿಮ್ಮ ಇದರಲ್ಲಿ ರೆವೆನ್ಯೂ ರೆಕಾರ್ಡ್ಸ್ ನಲ್ಲಿ ಏನಂತ ಇದೆ ತೋರಿಸಿ. How he entered that finding that it's an irrigated land under the Land Reforms Act, Schedule 1 ಅಲ್ಲಿ A, B, C, D category ಇದೆ. ಅದರಲ್ಲೆಲ್ಲ ಬರಬೇಕು. That should be reflected in the revenue records.
Transport, how much is granted?
2 lakh.
2,50,000.
54,760.
ಇಲ್ಲಿ ಏನ್ ಬೇರೆನ ಬರ್ದಿದಾರ? You are not written that. Reference code, how much granted is not written? 2,50,000.
2,54,760.
54,760.
The revenue record, my lord, ಅದರಲ್ಲಿ
4,50,000.
ಲೈಟ್ ತರಿ ಅಂತ ಬರ್ದಿದ್ದಾರೆ.
Irrigated. ನಿಮ್ಮ ರೆಕಾರ್ಡ್ಸ್ ನಲ್ಲಿ ಏನಂತ ಇದೆ?
ಅದರಲ್ಲಿ
What basis? ಗಾಡಿ ಅಂದ್ರೆ
ಅಲ್ಲಿ ಲೈಟ್ ತರಿ ಅಂತ ಇದೆ.
ತರಿ. ತರಿ ಭೂಮಿ.
ತರಿ
ತರಿ ಅಂದ್ರೆ irrigated.
It is irrigated.
RTC mark ಆಗಿದೆ.
ಆಗಿದೆ.
RTC is marked.
Exhibit
P28 to 33.
P28 to
33.
ಅಷ್ಟರ ಕೊಡ್ಲೇಬೇಕಲ್ಲ. ರಿಜಿಸ್ಟರ್ ಗೈಡ್ಲೈನ್ ವ್ಯಾಲ್ಯೂ ಪ್ರಕಾರ. ಗೈಡ್ಲೈನ್ ವ್ಯಾಲ್ಯೂ ಅವಾಗಿಂದಿದು. ಗೈಡ್ಲೈನ್ ವ್ಯಾಲ್ಯೂ ವಿಚ್ ಇಯರ್ ಗೈಡ್ಲೈನ್ ವ್ಯಾಲ್ಯೂ ಇದು? Guideline value periodically keeps on changing by the notification of the government. ಯಾವ year?
18.
ಆ year ಬೇಕಾಗ್ತದೆ.
And I am relying one more.
Answer question. Which year guideline value?
That Moradabad railway is something different, away from your place. Same.
P18, my lord, it is on 2013 and 14.
With 18, P18.
It is in the year 2013 and 14 guidelines. And
ಆ year ಕೊಡಬೇಕು.
2000.
Google ನೇ ನೋಡಕ್ಕಾಗತ್ತನ?
2011 and
Guideline value
of 2010 and 11.
2010 for this area.
Pennur village, Gangavatal.
And I am relying on one more exhibit, my lord. Lord, one more submission. At exhibit fee 21.
P21.
Fee 21, my lord.
Consent award.
It is
Consent
a,
award.
It is a consent award, my lord. On the same year 2009, there are two acquisitions. It is for the minor irrigation, that is for the railway line has been passed over that entire village, my lord. Total 19 villages, total 19 villages that the government has decided for the dry land 6 lakh per acre, for the light 8 lakh per acre, for the thorny land is a 15 lakh rupees. That has been decided.
Small extent.
These are all agricultural lands.
Correct, but consent award ಅಲ್ಲಿ ಪುನಃ ಹೆಡ್ಡೇಕ್ ಬೇಡಪ್ಪ ಬೇಗನೆ.
ಇಲ್ಲ ಅದರಲ್ಲಿ 2 acre ಇದೆ 3 acre.
Consent award includes solution.
It includes.
ಅದು ಕಾಂಪೋನೆಂಟ್ ಎಲ್ಲ ಅವಾಗ ಅದನ್ನೆಲ್ಲ ಮೈನಸ್ ಮಾಡಿದ್ರೆ ಎಷ್ಟಾಗ್ತದೆ? ಅಲ್ಲಿ ಲಂಪ್ಸಮ್ ಇರ್ತದೆ ಕನ್ಸೆಂಟ್ ಅವಾರ್ಡ್.
It always includes all statutory benefits.
You have to answer only.
ಇಲ್ಲ ಇನ್ಕ್ಲೂಡ್ ಆಗಲ್ಲ.
No, it includes, my lord. In the consent, my lord, we have not challenged that again that award, my lord. It includes all.
ಕನ್ಸೆಂಟ್ ಅವಾರ್ಡ್ ನಲ್ಲಿ ಲಂಪ್ಸಮ್ ಇರ್ತದೆ.
It is a lump sum. And we are not claiming any statutory benefits on that.
ಅವನ್ನೆಲ್ಲ ತೊಳಿಕ್ ಬರಲ್ಲ. ಒಂದು ರೀಸನಬಲ್ ಹೇಳಿ. ಒಂದೇನು ರೀಸನಬಲ್ ಎಷ್ಟು? ಆ ಇಯರ್ಗೆ ಎಷ್ಟಿದೆ? Since you bank upon the guideline value, we will give you guideline value of that year. ಆ ಇಯರ್ಗೆ ಏನಿದೆ ತೋರಿಸಿ.
You have produced the 2013-14 guidelines actually.
13-14 ಅಲ್ಲ, 2009 ಇದೆ. 2009 ಗೆ ಯಾವ್ದಿತ್ತು ಆ ವ್ಯಾಲ್ಯೂ ಬರುತ್ತೆ. ಅದನ್ನು ಹೇಳಿಲ್ಲ ನೀವು. ಅದನ್ನೆಲ್ಲ ಹೇಳ್ಬೇಕು. ಇದು 2000 ರಿವೈಡ್ ಅಂತ ಹೇಳ್ಬೇಕು. ಫೇರ್ ಆಗಿರ್ಬೇಕು. ನಾವು ಕೇಳ್ಕೊಂಡು ಹೇಳ್ಸೋಣಂಗೆ ಆಗ್ಬಾರ್ದು.
One more submission that during the course of cross examination, he himself has admitted that it is a dry land. Dry land. They shows with regard to RTS that it is
finding
RTC will torsa ide. Alla torsa, but it is admitted fact. But that RTC's records have been considered by the reference court.
RTC record entries enjoy presumptive value under section 133 of the Land Revenue Act.
Two petty crop on finding ಇದೆಲ್ಲ. You
What
have
to
not
finding
filed
ಇದೆ?
appeal.
ಇಲ್ಲ ನಾವೇನು.
Order ಮೇಲೆ
ಅಲ್ಲ, I'm considering this irrigated land, you should have a dry land ಅಂತ ಅವ್ರು
ಬರಲ್ಲ. Supreme Court ಏನ್ ಹೇಳ್ತದೆ ಅಂದ್ರೆ, in their appeal, they can show certain findings that have been recorded against us or bad, they are liable to without filing appeal ಅಂತ hold ಮಾಡಿದ್ರು 2008 Supreme Court. Only on finding you cannot file appeal. Just ಮಾಡಬಹುದು. ಆ ಪೀರಿಯಡ್ ಏನಿದೆ? ಅದೊಂದೇ ಇರೋದು. ಅದೊಂದು ತಗೊಂಡ್ರೆ ಸಿಕ್ತು. ಗೈಡ್ಲೈನ್ ವ್ಯಾಲ್ಯೂ ಏನಿದೆ?
Just 2 days time, my lord, I have to find out that what is that.
2 days. 5 minutes ಕೊಡ್ತೇವೆ ನಾವು.
ಅಲ್ಲ,
ಫೋನ್ ಮಾಡ್ಕೊಳ್ಳಿ.
may I seek for a password by 2:30 I will pay.
Please.
ಮತ್ತೆ 2 days ಇದ್ರಾಗ ಹೋಗ್ತದೆ ಟೈಮ್ ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದು. ಅವರು ಇನ್ನೊಬ್ರು ಪಾಸ್ ಓವರ್ ಮಾಡಿದ್ವಿ ಹೋಗೇ ಬಿಟ್ರು.
16 Anil Kale.
This is landowners appeal, my lord, seeking, my lord, enhancement. Lord, respond number 3 to 12. Lord, they are also, my lord, claimants. They have also, my lord, joint reference is filed. Therefore, my lord, may I seek, my lord, to transpose them as the appellants.
ಅವ್ರು ಮಾಡಿದ್ರೆ ಅವ್ರಿಗೆ ಬೆನಿಫಿಟ್ ಬರಲ್ಲ, ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರಲ್ವಾ?
Yes, my lord, they have not challenged the appeal, they have not filed. Reference is common, my lord, common reference is filed, but they have not filed appeal.
No, therefore once we modify the reference order.
Yes, my lord.
They too were before the reference court.
Yes, they were before the reference court.
Otherwise 28 principle ಏನು? ಇವ್ರಿಗೆ ಕೊಟ್ಟು ಅವ್ರಿಗೆ ಕೊಡಲ್ಲ ಅಂತೀರ? ಅವ ಬಂದಿಲ್ಲ.
ಬಂದಿಲ್ಲ, ಬಟ್ ಇಲ್ಲಿಂದ ಅವರು ಡಿಲೀಟರಿ ಆಗಬೇಕು. ದೇ ಕ್ಯಾನ್ ವಿದೌಟ್ ಸೀಕಿಂಗ್ ಟ್ರಾನ್ಸ್ಪೋರ್ಟೇಷನ್ ದೇ ಕ್ಯಾನ್ ಫೈಲ್ ಅನ್ ಅಪ್ಲಿಕೇಶನ್, ರೈಟ್? ಇಲ್ಲಿ ಬರ್ದೇನೆ ದೇ ಕ್ಯಾನ್ ರಿಮೈನ್ ಎಕ್ಸ್ಪರ್ಟ್. ದೇ ಕ್ಯಾನ್ ಫೈಲ್ ಅಪ್ಲಿಕೇಶನ್ 28 ಕೇಳಬಹುದಲ್ಲ ಅವರು?
28 they have filed reference, my lord. The person who has not filed reference, then he can go, my lord, on 28A.
ಹೌದು, those who have 19-1, 18-1, 18-1 ಅವೇಲ್ ಮಾಡಿದ್ರೆ 28 ಬರೋದಿಲ್ಲ.
Yes.
ಟ್ರಾನ್ಸ್ಫರ್ಜೇಷನ್ ಅಲ್ಲ ಮಾಡು.
Who are the respondents?
Respondent number
Anil?
1 and 2.
How many respondents?
My lord, 3 to 12, my lord. 3 to 12.
Well done, this is number so and so. The present application is filed by the appellant under order 1, rule 1, seeking transposition of respondent number 3 to 12 as the appellant number 13, on the ground that those respondents were the applicants before the reference court, and at the time of filing the application, they could not come forward to file appeal. And they at the time of appeal. Of filing the present appeal, they are not come forward to give instructions and sign wakala. However, later they came to know about the filing of the appeal and seeking for transposition themselves as the parties in the above proceeding. We have heard the learned counsel for the appellant / applicant and learned AG perused the material available record. We have considered view that the interest of justice would be met if the respondents 3 to 12 are transposed as appellant number 4 to 13 in the above appeal, so that they would also get the benefit of compensation in the case appeal is allowed. Considering the same, the application is allowed, the respondent number 3 to 12 are permitted to be brought as transposed as appellant number 3 to 12, 13, 4 to 13 in the appeal. To stop the appellant to amend the cause title accordingly and also file amended
Amended cost title, my lord, ready, my lord, I'll file it today.
And file amended cost. Office the lackey.
Delay ಇದೆ, delay.
Next.
ಅದು delay ಬರ್ತದ,
Delay.
transposition.
ಅಲ್ಲ, not main appeal,
ಇದರಲ್ಲಿ.
main appeal.
I1 of 16. ಅದು I2 ಆಗ. Delay ಮಾಡ್ಬೋದು. Accept. ಅದು delay ಮಾಡಿ. Accept the cost show. Delay of 392 days in preferring the appeal is condoned by denying the interest for the aforesaid period. Give the for the aforesaid period as well as the delay from the date of filing of the appeal till this date. If the appellant succeeds in the appeal. Call for TCR.
My lord, records will be called for.
Call for TCR and page.
One submission. Lord, my name may kindly be deleted. Appellant ಇಲ್ಲ.
Register to delete the name of Sri V.S. Kalsur Bhat.
You can't appear for the other side also.
Yes, yes, yes.
ಯಾರು appear ಆಗ್ತಾರೆ?
Irregardless.
G appears.
17, ಮೃತ್ಯುಂಜಯ ಹೇಳಿಕೇರಿ.
It is the appeal by the wife, my lord, accrued by grant of decree of divorce.
ಯಾವ ground ಮೇಲೆ?
My lord, on the ground of cruelty and desertion, my lord, an petition was filed. Now, my lord, the court, my lord, has granted the decree of divorce on the ground that, my lord, she had left him and she resided, my lord, separately for, my lord, about 8 years, my lords. The fact, my lord, the court also notes that he had filed an application for restitution of conjugal rights in 2012, my lords. I went to the court and said that, my lord, I've never gone out. He had thrown me. I'm always ready to join him. The very next date of hearing, my lord, he files an application and he withdraws that restitution of conjugal rights. So once he does that, my lords, whether, my lord, the court is justified in saying that I have destituted or deserted him and, my lord, grant of decree of divorce.
You have withdrawn restitution application, petition.
Please, your lordship. No, when not I filed the petition under section not the seeking for restriction of conjugal rights. Not she filed the criminal case against him, not the petition, this respondent and his parents, your lordships, and the married sister under section 498 of IPC, your lordships. Therefore, no, I withdrawn that not the restriction of conjugal rights, your lordships.
Have you said that in your withdrawal application?
Lord, for a moment, no, kindly see the not the cross examination of not the.
Have you said in withdrawal memo? ನಾನು ಇವರು ಹಿಂಗ್ ಮಾಡಿದಾಳೆ ಹಂಗಾಗಿ ನಾನು ವಿಡ್ರಾ ಮಾಡ್ತಾ ಇದ್ದೀನಿ ಅಂತ ಹೇಳಿದ್ರ ಅಥವಾ ಬೇರೆ ಆರ್ಗ್ಯುಮೆಂಟ್?
ಅಲ್ಲ ಅದ್ರ ಹೇಳಿಲ್ಲ, ಬಟ್ not during pendency of the not the petition restrict conjugal rights ಅವಾಗ she filed the not petition under section 498 of IPC against the aged parents, this respondent and not the married sisters, your lordships.
When the petition restitution petition was filed?
My lord, in 2012, my lords.
Dated?
6/1/2012.
6/1/2012.
Yes.
When he sought the criminal cases were filed by you?
Criminal cases, my lord.
That's in 2012, your lords.
On 12/1/2016, it was withdrawn. 12/1/2016, my lord, it was withdrawn.
Criminal case is filed in the 2012, your lordships.
2016, it was withdrawn.
16, it was withdrawn.
He withdrew that restitution petition when?
On 12/1/2016.
When it was filed?
My lord, 6/1/2012.
6/1. When notices were served on him?
In that matter, my lords, that my lord is not aware.
When notice was served on you?
I'm not aware, but not the, as per the, not the criminal case is also filed in there 2012 itself, your lordships. I had a judgment copy of the criminal case, your lordships. In 2012, the not the criminal case is filed against him, not the this respondent and not his parents and the married daughters.
Criminal case also she has withdrawn?
Illa, she had not withdrawn, the lordships.
She has withdrawn it on 12/1/2016.
Not that one.
That is MC petition. MC, my lord. Restitution of conjugal rights.
ಅವ್ರು ಹಾಕಿದ್ದು?
ಅವ್ರು ಹಾಕಿದ್ದು
ಅವ್ರೇ
ನಾವು ವಿಡ್ರಾ
withdraw
ಮಾಡ್ಕೊಂಡಿದ್ದೇವೆ.
2012 ಅಲ್ಲಿ ಫೈಲ್ ಮಾಡಿದ್ರು, ಅದನ್ನ 2016 ಅಲ್ಲಿ ವಿಡ್ರಾ ಮಾಡ್ತಾರೆ. Because of the criminal cases filed in the year 2012 ಅಂತಾರೆ.
NCR ಇದೇನು? Argue. Others need not wait. We'll take up this matter. It's very old matter, 2018 matter.
My lord, so that
ಇಬ್ರು ಜೊತೆಗೆ ಹೋಗಕ್ ಜೀವನದಲ್ಲಿ ಜೊತೆಗೆ ಇರ್ಬೇಕು ಅಂತ
ಅಲ್ಲ
ಅನ್ಸಲ್ವಾ?
15 ವರ್ಷ ಸಪರೇಷನ್ ಆಗಿ ಅಲ್ಲಿ ಸಪರೇಷನ್ ಆಲ್ಮೋಸ್ಟ್ 15 years ಆಯ್ತು. And not the separate is none other than the not the sisters not the daughters, your lordship. Sister daughter, your lordship.
Sister's daughter, not ಅಕ್ಕನ ಮಗಳು.
Akkan Magalu.
Akkan Magalu, my lords, that they got married and my lord, there are two children, one boy and a girl, my lords. Now boy is 18 years now and the girl is, my lord, about 16 years now. My lords, there was a lot of differences between the elders, my lords. It's since my lord, a sister daughter is only married, it was not, it's a,
15 ವರ್ಷ ಆಗಿ ಹೋಗಿದೆ.
but we have, she has always been ready, my lords. But even before this court also, my lord, even today, earlier, my lord, a mediation was held. She said, my lord, in trial court also, she said she will go. Here before this court also, she said she will go. And my lord, mediation was also held. And even to this day, my lord, she says she is ready to go.
15 ವರ್ಷ ಆದ್ಮೇಲೆ ಅವ್ರನ್ನ ಹೆಂಗೆ ಮನಸ್ಸು ಒಡೆದು ಹೋಗಿರ್ತದೆ? 15 ವರ್ಷ ಆದ್ಮೇಲೆ ಜೋಡಾವಣೆ ಮಾಡೋದು ಹೆಂಗೆ?
My lord, that your lordship, my lord, is fair enough in that. Now, why divorce should not be granted? I asked, my lords, the same thing. Now, my lord, there is a daughter, my lord, 16-year-old daughter is there, my lords. Now, that daughter and son, both of us with the appellant wife, my lord, wife only, my lords. She is taking care of them. One thing. Second, my lord, a rustic village, my lord, she has to get this daughter also married, my lords.
ಈಗೂ ಮಾಡಿ.
My lord,
ಈ divorce will not come in the way of.
my lord, a lot of things will come. Anyway, my lord, he is about now 59 and he's going to 16 and so there is, my lord, as for my this thing, my lord, he is also not going to marry as another woman and lead his life, my lords. So, my lords, if this decree goes, my lords, at least, my lord, some status will be in the society will be saved, my lords.
What are the allegations of cruelty you have pleaded?
Cruelty,
How
my-
you have proved?
my
ಇಲ್ಲ,
lord-
judgment ಹಾಕಿದ್ದಾರೆ.
ಹೌದು, in order to arrest this not respondent, in order to arrest this respondent, your lordship, she filed the not the criminal case against the not the.
Not oral statements.
ಅಲ್ಲ, this is
You
an
should show the
document, please, your lordship.
Just ತೋರಿಸಿ.
ಇದೆ 498 ಕೇಸ್ ಆಗ್ತದೆ. ಆಮೇಲೆ ಸಿವಿಲ್ ಸೂಟ್ ಹಾಕೊಂಡು ಪಾರ್ಟಿಷನ್ ಸೂಟ್ ಕೇಳ್ಕೊಂಡು that was decreed, your lordship, and it was confirmed before this honorable court, your lordship.
Sir, this is
ಅದೇ
not a
ಹೆಂಗೆ
way
ಎಷ್ಟು?
to argue.
ಹೌದು, ಪಾರ್ಟಿಷನ್ ಸೂಟ್ ಹಾಕೊಂಡು ಸೂಟ್ ಇಸ್ decreed, your lordship.
ಅಂದ್ರೆ ಸರಿ ಇದೆ ಅಂತ ಆಗ್ತದ? ಸೂಟ್ ಡಿಕ್ರಿ ಆಗಿದೆ ಅರ್ಥ.
The suit filed by the not the present appellant seeking partition
is decreed.
decreed, your lordship.
ಮತ್ತೆ ಅವ್ರ ಪರವಾಗಿ ಆಗ್ತಲ್ಲ?
ಹೌದು, ಅವ್ರ ಪರವಾಗಿ ಆಯ್ತು.
ಅದೇನು ಕ್ರುಯಲ್ಟಿ ಆಗ್ತದೆ?
ಅಲ್ಲ ಅಂದ್ರೇನು ಮಲ್ಟಿಪಲ್ ಕೇಸಸ್ ಆಗ್ತಾರೆ ಇವ್ರ ಮೇಲೆ.
ಸಪೋಸ್ 10 ಕೇಸ್ ಹಾಕ್ಯಾರ ಅಂತ ಇಟ್ಕೊಳ್ಳಿ, 10ರಲ್ಲಿ ಅವ್ರು ಸಕ್ಸೀಡ್ ಆಗ್ತಾರೆ, ಅವಾಗ ನಾವು ಅವ್ರ ಅಗೇನೆಸ್ಟ್ ಹೋಲ್ಡ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರ್ತದ?
Another contest, your lordship, not the brothers and sisters of these respondents are not the job holders, your lordship.
Sir, you should take the pleading and say what are the
Pleading,
pleaded ಅಂತ ಹೇಳಿ.
ಏನ್ ಪ್ಲೀಡಿಂಗ್ ಮಾಡಿ?
Subsequent events.
ಏನ್ ಮಾಡಿ?
In the cross examination, your lordship, kindly present.
ನಿಮ್ಮ ಪ್ಲೀಡಿಂಗ್ಸ್ ನಲ್ಲಿ ಏನೇನು ಅವ್ರ ಬಗ್ಗೆ ಅಲಿಗೇಷನ್ ಏನೇನ್ ಮಾಡಿ
Cruelty, what are the cruelty?
ನೀವು ನೋಡಲ್ಲ, ಎರಡು ಮಕ್ಳಿದಾವ, ಒಂದು ಸೂಟ್ ಹಾಕೊಂಡು ಮಾಡಿಕೊಳ್ಳಿದ್ರೆ ಬದುಕೋದು ಹೆಂಗ ಅವಳು?
ಅಲ್ಲ not because you
ಎರಡು ಮಕ್ಳು ಆಲ್ ರೈಟ್. ಡಿಡ್ ಯು ಪೇ ಎನಿ ಮೇಂಟೆನೆನ್ಸ್ ಫಾರ್ ದಿ ಚಿಲ್ಡ್ರನ್?
ಹೌದು, ಕೊಡ್ತಾ ಇದ್ದೀವಿ.
ಎಷ್ಟು ಕೊಡ್ತಾ ಇದ್ರಿ?
not the monthly 7,500 is not till today they are paying, your lordship.
ಎರಡು ಮಕ್ಳಿಗೆ?
ಎರಡು ಮಕ್ಕಳು ವೈಫ್ ಕೂಡ ಇದಾಗಿದೆ 7,500.
ಎರಡು ಮಕ್ಳಿಗೆ 3,500, 7,000.
2,500 each ಅಂತ ಆಗಿದೆ.
2,500
each.
ಪಾನಿಪುರಿನೂ ಬರಲ್ಲ.
ಬರಲ್ಲ, but not they have not filed any more enhancement, your lordship.
ವಾ ಹರೆಸ್ಮೆಂಟ್.
Moreover, not the this respondent is ready to pay not the one some settlement ಮಾಡಕ್ಕೆ ready ಇದ್ದಾರೆ ಈಗ ಅವರು.
5.5 ಲಕ್ಷ ಡ್ಯೂ ಇದೆ.
One time settlement, he is ready to pay the dues, your lordship.
All those things will not help your case. Pleading ಇದರಲ್ಲಿ
ಪ್ಲೀಡಿಂಗ್ಸ್
what are the
ತೋರಿಸಿ ಏನೇನ್ ಮಾಡಿದಾಳ ಅವಳು?
ಅಲ್ಲ ಅದರಲ್ಲಿ
ಕೇಳ್ತೀರಾ?
Please.
It is such that you are unable to lead the married life.
married.
ಅದೆಲ್ಲ ತೋರಿಸಿ.
ಅದಕ್ಕೆ ಬೇಕಾಗುವ
For
ಸ್ಟ್ರಕ್ಚರಿಂಗ್
that,
ಅಲ್ಲಿ ಇದೆ ಪ್ಲೀಡಿಂಗ್ಸ್.
for that to kindly my lord the peruse the cross examination not the pleadable. ಅದರಲ್ಲಿ ಅವರು ಒಪ್ಪುತ್ತಾರೆ. In order to harass this.
Sir, it is your case. You have gone to the court. You show us the
ನಿಮ್ ಪ್ಲೀಡಿಂಗ್ಸ್ ತೋರಿಸಿ
Please.
ಏನಂತ ಹೇಳಿ ನೋಡೋಣ. ಅವಳು ಅಂತಮ್ಮಂದ್ರ ಮೇಲೆ ಕೇಸ್ ಹಾಕೋತಾಳಪ್ಪ. ನೀವು ಪ್ರಾಪರ್ಟಿ ಕೊಡಲ್ಲ ಅನ್ನೋದಕ್ಕೆ ಪಾರ್ಲಿಮೆಂಟ್ ಕಾನೂನು ಮಾಡಿದೆ, ಕೊಡಬೇಕು ಅನ್ಕೊಂಡು ನಾವು ಹೋಗಿದ್ದಾರೆ. ಶಿ ಹ್ಯಾಸ್ ಸಕ್ಸೀಡೆಡ್ ಅಂಡ್ ದಿಸ್ ಕೋರ್ಟ್ ಹ್ಯಾಸ್ ಅಪ್ರೂವ್ಡ್ ಇಟ್.
Please.
ಅದನ್ನೇನು ತಪ್ಪು ಅಂತ ಹೇಳಕ್ ಆಗ್ತದೆ?
Kindly my present the evidence of not the PW1, your lordship.
ಪ್ಲೀಡಿಂಗ್ಸ್ ಹೋದ ಅಭ್ಯಾಸ ಇಲ್ಲ.
ಇದೆ ಅಲ್ಲ ಎವಿಡೆನ್ಸ್ ನೋಡ್ಬಿಟ್ಟು ಗೊತ್ತಾಗಿದೆ.
ನಾವ್ ಹೇಳ್ದಂಗೆ ನೀವು ಕೇಳ್ಬೇಕು, ನೀವ್ ಹೇಳ್ದಂಗೆ ನಾವು
Please.
ಕೇಳಲ್ಲ. ಜಡ್ಜ್ ಹೇಳ್ದಂಗೆ ನೀವು ಕೇಳ್ಬೇಕು.
Pleading, if it is not a pleaded evidence, something whether we are required to look into that. Which you are
ಪ್ಲೀಡಿಂಗ್ಸ್
not
ಓದಿ ಅಂತ
pleaded.
ನಾವ್ ಹೇಳ್ದಾಗ ಪ್ಲೀಡಿಂಗ್ಸ್ ಓದ್ಬೇಕು, ಇಲ್ಲ ನಾವು ಓದ್ಕೋತೇವೆ ಬಿಡಿ, ನೀವು ಕುತ್ಕೊಂಡ್ಬಿಡಿ, ನಮ್ ತಿಳಿದಂಗೆ ನಾವು ಮಾಡಿ ಹಾಕಿರ ಕೊಡ್ರಿ ಇವನ್ನೆಲ್ಲ. The marriage ಅದು ಯಾವ್ದೋ ಒಂದು ಸೈಟ್ ಕ್ವಶನ್ ಅಲ್ಲ.
What are the allegations of cruelty?
My lord, the allegation is that, my lord, ಅರ್ಜಿದಾರನ ಅಣ್ಣ ತಮ್ಮಂದಿರು ಸರ್ಕಾರದ ವಿವಿಧ ಇಲಾಖೆಯಲ್ಲಿ ನೌಕರಿ ಮಾಡುತ್ತಿದ್ದಾರೆ. ಅವರ ಇಲಾಖೆಯ ಮುಖ್ಯಸ್ಥರಿಗೆ ವಿನಾಕಾರಣ ಇಲ್ಲಸಲ್ಲದ ಆಪಾದನೆಗಳನ್ನು ಮಾಡಿ ಎದುರುದಾರರು ಅರ್ಜಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಇದರಿಂದ ಅರ್ಜಿದಾರರ ಸಹೋದರ ಸಾಕಷ್ಟು ಅನಾನುಕೂಲತೆ ಕಷ್ಟ ಅನುಭವಿಸಿದ್ದಾರೆ. This is the pleading, my lords, in the application, petition for divorce.
You are harassing by writing letters to them.
No, my lords.
Where is the material for that? How it is proved? ಏನು ಕೊಟ್ಟಿದಾರಾ?
ಇಲ್ಲ ಆ ತರದ್, my lord, I had filed that, my lords.
Vague assertion.
ಹೌದು.
They are citation.
They have to.
Where are the reasons of the trial court?
My lord, the trial court reasoning, my lord, is at page 20, internal page 27, para 30.
Para?
30, 30.
ಇಷ್ಟೇನಾ?
ಆಮೇಲೆ
ಇಷ್ಟೊಂದು ಪ್ಯಾರಾಗ್ರಾಫ್ ಅಷ್ಟೇನಾ?
my lord, the judgments, the
No, you are not there for 7 years is a ground for cruelty ಅಂತನಾ?
that's what the court says. And another one is, my lord, that para 24 is about filing of cases.
ಎರಡು ಲೈನ್
Very rulings.
Very rulings. ಆಮೇಲೆ ಕೊನೆಗೆ ಇದೊಂದು, ಆಮೇಲೆ if your, how court was, my lord, initially itself was prejudiced is, kindly take page 18, para 15.
Exhibit P5 and P6 are the.
Once ಎಲ್ಲರಿಗೂ ಗೊತ್ತಾಗ್ಲಿ, ಎಲ್ಲ family court how it is considered. Please read para 30. Whether this order can sustain. Para 30 OT.
Please
read para.
Page 27, appeal memo.
Para number 30, lordship. 30.
It is a reason, no?
Please.
Or other than that, any reason other than OD first.
ಇಲ್ಲ ಅದು ಇದು ಅದೇ.
But in this case, the respondent has deserted 7 to 8 years to the company of the petitioner to lead marital life, then it is more than cruelty of respondent against the petitioner. Therefore, this ruling is not applicable to the case on hand. The respondent has not taken any care like that of a married woman in respect of her husband after her marriage. And due to long desertion of respondent, the petitioner is entitled for the relief of divorce from the respondent. Hence, the point for consideration is answered in the affirmative.
So, desertion is a cruelty, amounting to cruelty as per the judge, learned judge. So, whether he have voluntary gone or you have troubled her.
ಅದನ್ನ examine ಮಾಡೋದು ಬೇಡವಾ?
Evidence ಬೇಕು, ನೀವು pleading ಹೇಳಬೇಕು. Despite I have called, I have sent notice, she has not come.
Come.
I have panchayati was held, this she has not come.
ಇದನ್ನ uphold ಮಾಡಿದ್ರೆ no marriage will be sustained in the country.
In contrary to that, you file a petition, withdraw that.
For that, not the, when she filed the criminal petition, withdraw it to lordship.
No, that what we don't know that reason.
And moreover, not.
ಆ reason ಹೇಳಿಲ್ಲ, ನೀವು ಈಗ ಹೇಳ್ತಾ ಇದೀರಿ. ತೋರಿಸಿ ಮೆಮೊದಲ್ಲಿ.
ಇಲ್ಲ, ಅದ್ರಲ್ಲಿ ನಾವು ಒಪ್ಕೊಂಡಿದ್ದಾರೆ ಇದರಲ್ಲಿ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲಿ.
ಏನಂತ?
ಹೌದು. For a moment, may I read you lordships? The cross examination of RW.
ಅದೇನೋ ಹೇಳಿದ್ರೆ
ಅವರೇ ಒಪ್ಕೊಂಡಿದ್ದಾರೆ.
ಎರಡು ಮಕ್ಕಳಿದಾವು. ಮ್ಯಾರೇಜ್ ಟ್ಯಾಕ್ ಮ್ಯಾರೇಜ್
Last 4 years back, not this response of not the attack, heart attack ಆಯ್ತು. ಅವಾಗ ಕೂಡ ಬಂದು ನೋಡ್ಲಿಲ್ಲ, ಬರ್ಲಿಲ್ಲ ಅವರು. Heart attack is not the continuous treatment to lordships.
Sir, one second. That is not the way how you should argue. 13(1)(a) and B. B is a desertion. Desertion where it is proved that voluntarily with an intention to discard the marital relations,
she went away.
That
No
pleading should be
justification.
there and evidence should be there. That is not, but granted resolution on that.
ಏನದು ಅದು ಕೆಟಲ್ ಟ್ರೆಸ್ಪಾಸ್ ಆಕ್ಟ್ ನಲ್ಲಿ ಒಂದು ಪಿಟಿಷನ್ ಹಾಕ್ದಂಗಿದೆ.
ನಂಗೆ ಅನ್ಸುತ್ತೆ ಅಂತ ಕೊಡಕ್ಕಾಗಲ್ಲ.
No marriage will be safe.
That
ಈ ರೀತಿ ಎಲ್ಲ ಅಲೋ ಮಾಡಿದ್ರು.
in that regard, this respondent issued the legal notice through his counsel, lordship, requesting her to come and join the matrimonial life, lordships. She did not care that letter, lordships. Therefore, this respondent filed the petition seeking restriction of conjugal rights, lordship. During that petition, your lordship, she filed the petition under section 498 of IPC.
ಯಾವಾಗ?
Petition pending ಇರಬೇಕಾದ, restriction conjugal petition pending ಇರಬೇಕಾದ, your lordship.
ಯಾವತ್ತ?
In 2012, lord, she filed the petition.
When you filed your petition, MC ಯಾವತ್ತ ಹಾಕಿ ನೋಡಿ. 2018.
This is what is OS 9 of 13 ಏನದು?
That is for partition, my lord.
ನೀವು ಹಾಕೊಂಡಿದ್ದು.
ಹೌದು, because he did not pay the maintenance in spite of there being an order.
It is independent right. ಅದಕ್ಕೆ
ಆಮೇಲೆ ಅಲೋ ಆಗಿದೆ ಅದು.
And that is
suit is decreed and appeal is dismissed by the coordinate bench.
Confirm ಮಾಡಿದ್ದಾರೆ.
ಮತ್ತೆ
so she not get the shares in the not the
MC6 is for restitution of conjugal rights.
get the share in the suit property, lordships.
ಏನ್ ತಪ್ಪಿದೆ ಅದರಲ್ಲಿ?
ತಪ್ಪಿಲ್ಲ, ಅದಕ್ಕೆ ಏನಾಗುತ್ತೆ ಅಂದ್ರೆ there is no possibility of settlement. in one time ಕೊಡ್ಲಿ ಇಲ್ಲಿ ಮಾಡಲಿಕ್ಕೆ ರೆಡಿ ಇದ್ದಾರೆ.
para 7 milord.
ಮತ್ತೆ ಇದು ಮೆಡಿಸಿನ್ ರೆಫರ್ ಆಗಿತ್ತು, ಅಲ್ಲಿಲ್ಲ ಕನ್ಸಿಲೇಷನ್ ಆಗಿಲ್ಲ, ಇದಾಗಿದೆ ಸ್ವಾಮಿ ಇದು.
ಏನ್ ಆರ್ಗ್ಯುಮೆಂಟ್ರಿ ನಿಮ್ದು?
ಮೆಡಿಸಿನ್ ರೆಫರ್ ಆಗಿತ್ತು.
ಪ್ಯಾರಾ 7 ನಲ್ಲಿ MC ಬಗ್ಗೆ ಹೇಳಿದ್ದಾರೆ. ಪ್ಯಾರಾ 7 ನಲ್ಲಿ that restitution ಬಗ್ಗೆ ಹೇಳಿದ್ದಾರೆ.
ಜಡ್ಜ್ಮೆಂಟ್ ಸೇರ್ಕೊತಾರ ಜಡ್ಜ್ ಎಂತ ಡಿಸ್ಕಷನ್ ಇಲ್ಲ ಎಂತದಿಲ್ಲ.
Para 7 ನಲ್ಲಿ the court observes that he has withdrawn that MC petition for restitution.
ಬಟ್ ಫೈಂಡಿಂಗ್ ಇಲ್ಲ ಅದಕ್ಕೇನು.
But finding ಹಂಗ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಎಷ್ಟು ಈಸಿ ಇತ್ತು ನೋಡಿ ಹಿಂಗೆಲ್ಲ ಬರೆದಿದ್ರಲ್ಲ ಎಲ್ಲರಿಗೂ.
ಏನಿದು
4-5 pages ಎಲ್ಲ ಇದೆ ನೋಡಿ.
ಎರಡೇ ಪ್ಯಾರಾಗ್ರಾಫ್ ಅಷ್ಟೇ. 2 paragraphs. No marriage will be safe at the hands of a judge like him.
ಎಲ್ಲ ಜಡ್ಜ್ಮೆಂಟ್ಸ್ ಹೆಡ್ ನೋಟ್ ಆಫ್ ದ ಜಡ್ಜ್ಮೆಂಟ್ ಫ್ರಮ್ ಪೇಜ್ ನಂಬರ್ 10 to ಇದು ಅಪ್ ಟು ದ ರೀಸನಿಂಗ್ 4 ಲೈನ್ ಬಿಟ್ಟರೆ ಬರೀ ಜಡ್ಜ್ಮೆಂಟ್ಸ್ ಹೇಳಿದ್ದಾರೆ.
ಎಲ್ಲಿ ಡಿಸ್ಕಷನ್ ಎಲ್ಲ ಆಗಿದೆ? ಯಾವ ಎವಿಡೆನ್ಸ್ ಡಿಸ್ಕಷನ್ ಆಗಿದೆ?
ಡಿಸ್ಕಷನ್ ಆಗಿಲ್ಲ ಬಟ್
ಏನು ಆಗಿಲ್ಲ.
ಅದರ್ ಡಾಕ್ಯುಮೆಂಟ್ ಶೋ ದಟ್ ದೇರ್ ಇಸ್ ಎ ಪ್ಯೂರ್ ಕ್ರುಯಲ್ಟಿ ಮೇಲೆ ಇದಾಗಿದೆ. ಯಾಕಂದ್ರೆ
ಅದರ ಬೇಕಲ್ಲ ಡಿಸ್ಕಷನ್. ಇಂಥ ದಿವಸ ಹೋದ್ಲು, ಇವ್ಳು ಕರೆದ್ರು ಸಹಿತ ಬರ್ಲಿಲ್ಲ, ಇವಳು ಹೋಗಕ್ಕೆ ಏನೋ ಕಾರಣ ಇಲ್ಲ, ಏನಾರ ಒಂದು ಬೇಕಲ್ಲ. ಏನು ಹೋಗ್ಬಿಟ್ಲು ಅನ್ಕೊಂಡು ಅಲ್ಲಿ ಹೋಗುವಂತ ಅಟ್ಮಾಸ್ಫಿಯರ್ ನೀವೇ ಜನರೇಟ್ ಮಾಡಿದ್ರೆ?
ಇನ್ ಸೋ ಫಾರ್ ಕ್ರುಯಲ್ಟಿ ಇಸ್ ಕನ್ಸರ್ನ್ ನಾಟ್ ದಿ ದಿಸ್ ಅಪೆಲೆಂಟ್ ಹ್ಯಾಸ್ ಬೀನ್ ಅಡ್ರೆಸ್ ಲೆಟರ್ ಟು ದಿ ನಾಟ್ ದಿ ಮ್ಯಾರೇಜ್ ನಾಟ್ ದಿ ಸಿಸ್ಟರ್ಸ್ ಲಾರ್ಡ್ಸ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಲೆಟರ್ ಬರೆದು ಕೂಡ ಅವ್ರ ಮೇಲೆ ಆಕ್ಷನ್ ತಗೊಳ್ಳಿದ್ರು ಸಸ್ಪೆಂಡ್ ಮಾಡಿ ಅಂತ ಇದು ಮಾಡ್ತಾರೆ.
ಕೋಲಿ ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ ಅದೆಲ್ಲ ಪ್ರೂವ್ ಮಾಡ್ತಾರೆ.
ಅದೇನು ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಏನೇನಿದೆ ಅದು?
Not the Supreme Court apex court judgment to lords.
Well, it's our High Court has referred to the Koili judgment and
ಕೋಲಿ
the Lordship was referring to my lord this Naveen Koili judgment.
Correct.
That is referred by this bench.
guidelines
For the coordinate bench and rendered. There is another.
ಲೇಟ್ ಅಲ್ವಾ ಕೋಲಿ ಜಡ್ಜ್ಮೆಂಟ್ ರೆಫರ್ ಮಾಡಿ ಗೈಡ್ಲೈನ್ಸ್ ಇದೆ ಅದರಲ್ಲಿ ಎಲ್ಲ.
Yes, ma'am.
That way out.
And another my lord an apex court judgment thereafter Koili judgment.
The allegations should be so cruel.
It's impossible to live
Impossible
ಅಂತ.
to live. Not a usual wear and tear.
ಎಲ್ಲ ಮ್ಯಾರೇಜ್ ನಲ್ಲಿ ಇರ್ತದೆ.
Reality.
My respect when not this
The duration length does not amounting to desert.
my respect submission when this respondent issued
Plus descendi ಅಂತ ಬರುತ್ತಲ್ಲ. Voluntarily.
Desert and desert and
my respect when this respondent issued the legal notice to the Lord's counsel requesting her to come them and join the matrimonial life to lordships. Instead of not she joining the matrimonial life, she filed the not the petition your lordship under section 498 5PC.
ಏನಿಲ್ಲ, ಅವ್ರು ಸೂಟ್ ಹಾಕಿದ್ದಕ್ಕೆ ಸೀಟ್ ಬಂದ್ಕೊಂಡು ಅದನ್ನ ಹಾಕೊಂಡಿದ್ರು.
And my lord thereafter in another case my lord thereafter my lord in another case the apex court my lord after Koili judgment
ಅದಕ್ಕೆಲ್ಲ ಅವಾಗ ಸೂಟ್ ಹಾಕಿರಲಿಲ್ಲ. ಅವಾಗ ಸಬ್ಸಿಕ್ವೆಂಟ್ಲಿ it has been filed your lordship. Suit is filed more in the year
para 9
ವಯಸ್ಸು 2013 ನಲ್ಲಿ ಹಾಕೋತಾರೆ ಸ್ವಾಮಿ ಅವರು. 2013 ನಲ್ಲಿ ಸೂಟ್ ಫಾರ್ ಪಾರ್ಟಿಷನ್
ಅದನ್ನ ಹಾಕಿದ್ಮೇಲೆ ನೀವು ಅದನ್ನ MC ಹಾಕಿದ್ದೆ ಅವಾಗ 2018 ಹಾಕಿ
2012 ಹಾಕಿದ್ರು. 2012 ಅಲ್ಲಿ
12 is restitution.
ರೆಸ್ಟಿಟ್ಯೂಷನ್ ಹೌದು ರೆಸ್ಟಿಟ್ಯೂಷನ್.
ಗೋಪಾಲ ಸಾಹೇಬ್ ಬರೆದಿದ್ದಾರೆ ನೋಡಿ ನಿಮ್ಮ ಉತ್ತರ ನಿಮ್ಮ ಆರ್ಗ್ಯುಮೆಂಟ್ ಗೆ. It is a legal recourse is available to the wife.
ಅದೇ ಅಂತ
ಅಲ್ಲ ನಾನು
right.
ಆಮೇಲೆ 2 ಮಕ್ಳು ಇದಾವು, 5,000 ರೂಪಾಯಿ ಕೊಟ್ರೆ ಮಕ್ಕಳಿಗೆ ಬದಿಕ್ಷಣದ ಹೆಂಗೆ?
ಆಮೇಲೆ then the court passed an order my lord directly deduction from his account. ಮತ್ ಲಾಸ್ಟ್ ಮಂತ್ ಇಂದ ಅವರು ಅವ್ರ ಆಫೀಸರ್ಸ್ ಹೇಳಿ ಅದನ್ನು ಬಂದ್ ಮಾಡಿಸಿದ್ದಾರೆ. ಫ್ರಮ್ ಲಾಸ್ಟ್ ಮಂತ್ my lord ಡೈರೆಕ್ಟ್ ಅಕೌಂಟ್ ಇಂದ ಬರ್ತಿತ್ತು, ಅದು ಬಂದಾಗಿದೆ ಈಗ.
ಆಗಿದೆನೋ ಇಲ್ಲ ಪ್ರೂವ್ ಅಷ್ಟೇ. ಕ್ರುಯಲ್ಟಿ ಬಗ್ಗೆ ಏನು ಹೇಳ್ಬೇಕಾ ನೀವು?
Cruelty ಬಗ್ಗೆ lordship not my respect submission is not the she filed the multiple cases against the respondent and her not the aged parents.
ಇಲ್ಲಿ ಪ್ಲೀಡಿಂಗ್ ಇಲ್ಲಿ ತೋರಿಸಬೇಕು.
Pleading the record shows that not the
will not take cognizance which if it is not pleaded.
Pleadings ಅಲ್ಲಿ ಇದೆ ನಿಮ್ದು.
I have produced the records before the trial court lordship. I have produced the records before the trial court lordship.
Sir, we once again we request.
But those documents are not considered lordship.
Please read the
Pleadings. Pleadings.
False case is filed against me which I exonerated later. My employment I have lost because of her false allegation. It amounting to cruelty. Show that. If it is not there, not there.
I will argue that
Merely asking we will not be able to.
ನಿಮ್ಮ petition ಎಲ್ಲಿದೆ ರೀ?
Not have the petition at present to lordship.
She has never led marital life ಅಂತ ಅನ್ಕೊಂಡು ಹೇಳಿರಿ. ಎರಡು ಮಕ್ಳು ಯಾಕದು?
2004, my lord, their marriage was solemnized, your lordships. Till 2011, they are not the staying with, 2012 disputal bantu, lordships.
Mr. What happened to this exhibit P6? Memorandum of this thing. Whether any department inquiry is conducted? She has made a false complaint to your employer. Whether any action is taken on?
Taken on the sister of this respondent, suspension ಮಾಡಿದ್ರು ಅವ್ರನ್ನ. Suspension ಮಾಡಿ ಇದರಲ್ಲಿ ಇಟ್ಟಿದ್ರು ಅವ್ರಿಗೆ.
ಯಾರ ಮೇಲೆ?
The respondent, the sister of this respondent, your lordships.
Where you have pleaded that?
I will produce that document, your lordships.
You.
ಗೊತ್ತಂತಿಲ್ಲ. Suspension ಮಾಡಿ ಇಟ್ಟಿದ್ರು.
Sir, it is
ಸ್ವಲ್ಪ
not proceedings ಅಲ್ಲ ರೀ.
ಇದು ಸ್ವಲ್ಪ ಅರ್ಥ ಮಾಡ್ಕೋಬೇಕು. It's a question of marriage.
Please, your lord.
ನಿಮ್ಮ ಪ್ಲೀಡಿಂಗ್ಸ್ ಏನ್ರ ಬೇಕಲ್ಲ, ಬೇರೆ ಅದ್ ನಮ್ಗೆ ನೋಡ್ರಿ ಅಂತ ಹೇಳಿ ನಾವು ನೋಡ್ತೇವೆ ಅದನ್ನೆಲ್ಲ. ನಿಮ್ ಪ್ಲೀಡಿಂಗ್ಸ್ ಅಲ್ಲಿ ತೋರ್ಸಪ್ಪ, ಎಲ್ಲಿದ್ದೀರಪ್ಪ ತೋರಿಸಿ ನೋಡೋಣ.
Readings ಅಲ್ಲಿ ಬಂದಿಲ್ಲ, your lords. But my lord,
ಅದೇ ಹೆಂಗ ಅದ್ರ ಹೆಂಗ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ರೆ?
Piecemeal evidence can be considered like writ in the appeals.
ಡಾಕ್ಯುಮೆಂಟ್ ಇದ ಸೂಟ್ ಅಲ್ಲಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ, ಪಿಟಿಷನ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ, ಬಟ್ ಇದರಲ್ಲಿ ಬಂದಿಲ್ಲ ಅಷ್ಟೇ.
The consequences of submitting the representation. What happened on that?
Representation policy ಕೊಟ್ಟರೆ ಬೇರೆ ಎಂಪ್ಲಾಯರ್ ಗೆ that comes to create a section is time.
Judgments. False and action is taken.
ಯಾವ ಇದನ್ನ ಎವಿಡೆನ್ಸ್ ಕೊಟ್ಟಾರೆ ನೀವು ಇದನ್ನ ಅಲಿಗೇಷನ್ಸ್ ಮಾಡಿದ್ರಿ ಇವರಿಗೆ? ಎಕ್ಸಿಬಿಟ್ ಪಿ ಸೀರೀಸ್
Yes, my lord, exhibit P series.
P5 and P6. P5 and P6.
What is your client doing?
My lord, she is a housewife, my lords. Her father and brothers are taking care of her.
ಆ ಕ್ರಿಮಿನಲ್ ಕೇಸ್ಗಳೆಲ್ಲ ಏನದು?
My lord,
You withdrew all those cases?
ಇಲ್ಲ, ಅದು ಒಂದು ಕ್ವಾಶ್ ಆಯ್ತು ಅಗೇನ್ಸ್ಟ್ ದಿ ಇನ್ಲಾಸ್. ಹಸ್ಬೆಂಡ್ ವಿರುದ್ಧ ಕ್ವಾಶ್ ಆಗ್ಲಿಲ್ಲ. And then since all
ಹಾಕಿದ ಕೇಸ್ಗಳವು
ನಾನು ಹಾಕಿದ ಕೇಸ್ since
ಅವರ
all
ಗಂಡನ ಅಣ್ಣ ತಮ್ಮಂದ್ರ ಮೇಲೆ ಅಕ್ಕಂಗಿಯರ ಮೇಲೆ ಆ ಗಂಡನ ಅಕ್ಕಂಗಿಯರ ಗಂಡಂದ್ರ ಮೇಲೆ ಅವ್ರ ತಂಗಿಯಂದ್ರ ಮೇಲೆ ಎಲ್ಲಾರ ಮೇಲೂ ಕೇಸ್ ಹಾಕ್ಬಿಡ್ರಿ.
ಅಂದ್ರೆ ಇವರೆಲ್ಲ ಅಂದ್ರೆ ಅಕ್ಕನ ಮಗಳ ಎಲ್ಲಾ ರಿಲೇಟಿವ್ಸ್ ಎಲ್ಲಾ ಅಲ್ಲೇ ಇರೋದು ಹಾಗಾಗಿ ಅದ್ ಮಾಡಿದ್ರು. ಆಮೇಲೆ ಹಸ್ಬೆಂಡ್ ವಿರುದ್ಧ ಕ್ವಾಶ್ ಆಗ್ಲಿಲ್ಲ. ಮತ್ತೆ ಎಲ್ಲಾ ವಿಟ್ನೆಸ್ ಗಳು ರಿಲೇಟಿವ್ಸ್ ಇರೋದ್ರಿಂದ
ಅದು ಕ್ವಾಶ್ಮೆಂಟ್ ಆರ್ಡರ್ ಎಲ್ಲಿದೆ?
ಕ್ವಾಶ್ಮೆಂಟ್ ಆರ್ಡರ್ my lord
ಕೊಡಿ. ಮತ್ತೆ ನೀವು ಅವರಿಗೆಲ್ಲ ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಹಾಕಿ ಅವ್ರನ್ನ ಹರಾಸ್ ಮಾಡಿದ್ರೆ ಏನ್ ಮಾಡ್ತಾನೆ ಗಂಡ?
Exhibit P4, my lords. Exhibit P4.
P4
Yes.
ನೀವು ಪಾರ್ಟಿ ಇದ್ರ ಅದಕ್ಕಿಲ್ಲ?
ಅದಕ್ಕೆ ನಾನು ಪಾರ್ಟಿ ಇದ್ದೆ, my lords.
ನೀವು ಇದ್ರ?
ಇದ್ದೆ.
ಇವರೇ ಪಾರ್ಟಿ?
Yes. Respondent, complainant was a respondent too.
ನೋಡಿ ಅವರೆಲ್ಲ ಗಂಡನ ಅಕ್ಕಂಗಿರು ಅಣ್ಣ ತಮ್ಮಂದ್ರು ಎಲ್ಲರೂ ಬೇರೆ ಬೇರೆ ಊರಲ್ಲಿದ್ರು. ಅವ್ರ ಮೇಲೆಲ್ಲ ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಹಾಕಿರಿ ನೀವು. ಹಿಂಗ್ ಬರ್ದಾರಿಲ್ಲ ಹೈಕೋರ್ಟ್ನಲ್ಲಿ. ಅಂಡ್ ಯು ಆರ್ ಎ ಪಾರ್ಟಿ ಟು ದಿಸ್ ಪ್ರೊಸೀಡಿಂಗ್.
Yes.
ಯು ಆರ್ ಸಫರ್ಡ್. ಈ ಗಂಡನ ಮೇಲೆ ಸಿಟ್ಟಿತ್ತು ಅಂದ್ರೆ ಗಂಡನ ಮೇಲೆ ಕೇಸ್ ಹಾಕೋಬೇಕಿತ್ತು. ಗಂಡನ ಮೇಲೆ ಏನು ಕಾನೂನಿನ ಪ್ರಕ್ರಿಯೆ ಇದೆ ಅದನ್ನೆಲ್ಲ ತಗೋಬಹುದು. ಗಂಡನ ಅಣ್ಣ ತಮ್ಮ ಅಕ್ಕ ತಂಗಿ ಎಲ್ಲರ ಮೇಲೆ ಹಾಗೆ ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಹಾಕಿದ್ರೆ ಅದು ದಟ್ ಇಟ್ ಸೆಲ್ಫ್ ಅಮೌಂಟ್ಸ್ ಟು ಎ ಕ್ರೂಯಲ್ಟಿ. ಇಟ್ಸ್ ಓನ್ಲಿ ಟು ಹರಾಸ್ ದಿ ಹಸ್ಬೆಂಡ್. There is a finding ಈಗ.
Yes.
There is a finding at para 6.
Yes.
The High Court said, the other bench said, the complainant having implicated the entire family members of the husband of the complainant, even though they are residing in different towns, would indicate an intention to harass them and not out of any genuine grievance against them ಅಂತ finding ಇದೆ.
My lords, judgment is there, my lords, that I have not appealed, but my lord, if I may make a submission, my lord, since it is a marriage within the relation only, my lords, my lord, it was not just a marriage between both of them, it was, my lord, both the families were also, my lords. And then, my lords, when the dispute arose between the family, my lords, the entire, my lord, it is actually not the dispute as I am told, it is between the husband and wife. It was a
ಬೇರೆಯವ್ರ ಮೇಲೆ
dispute arose between the elders, and then the fight started, and then, my lord, everybody got involved. It was something of that kind, my lords.
ಏನಿಲ್ಲ. She has harassed the husband and husband's relatives. There is a finding. Finding recorded by the coordinate bench, the learned single judge.
Yes, they are
And
all
you are a party.
relatives. Yes, they are all relatives, my lords. Since everybody, my lord, very close relation, my lords. Very close relation, my lords. And she was thrown out, my lord, because his father got annoyed with my father for some reason.
She doesn't have anything means.
I was thrown out, my lord, because his father got annoyed with my father for some
You
reason.
had engaged a lawyer.
Yes.
And very lawyer of great standing,
Yes,
high
yes.
standing.
Yes, yes.
And you have done all that.
Yes.
ಮತ್ತೆ ಆ ರೀತಿ ಗಂಡನ ಅಣ್ಣ ತಮ್ಮಂದ್ರಿಗೆ ಅಕ್ಕಂಗಿರಿಗೆ ಎಲ್ಲರಿಗೂ ಹರಾಸ್ ಮಾಡುವಂತವ್ರಿಗೆ ಮಾಡಿದ್ರೆ ಗಂಡ ಕ್ರೂಯಲ್ಟಿ ನಾಟ್.
That's not appealed, my lord, it was left there. That judgment was not appealed, my lord, it was.
It has attained finality now.
It has attained finality.
That goes against you.
She has left it there only, my lords. She did not pursue it further. And, my lords, some ill advice, my lords. And she was always ready to join him, my lords. If my lord, that was allowed, all this would not have, because MC petition was filed.
ಕಸ್ಟಡಿಗೆ ಏನಾರ ಹೋಗಿದ್ರ ಯಾರಾದ್ರೂ ನಿಮ್ ಕಡೆಯವರು? ಪೊಲೀಸ್ ಕಸ್ಟಡಿ ಆಗಿತ್ತಾ?
Not aware of that, not.
ಅರೆಸ್ಟ್ ಆಗಿದ್ರೇನ್ರಿ ಕ್ರಿಮಿನಲ್ ಕೇಸ್?
ಅರೆಸ್ಟ್ ಆಗಿದ್ರ?
I will not be.
ಏನ್ರಿ ಯಾರು ಇಂಥವ್ರ ಚಲೋತ್ನ ನಡೆಸ್ಬೇಕು. ಮ್ಯಾರೇಜ್ ಪ್ರಶ್ನೆ ಇಲ್ಲ.
ಎಕ್ಸಿಬಿಟ್ ಅಮೆಂಡ್ ಮಾಡ್ಬೇಕು, ಪ್ಲೀಡಿಂಗ್ ಮಾಡೋದಿಲ್ಲ. ಏನ್ ಹೇಳಲ್ಲ ಪ್ಲೀಡಿಂಗ್.
ಎಕ್ಸಿಬಿಟ್ T4 ಮಾಡ್ಯಾರೆ. ಈ ಫೈಂಡಿಂಗ್ ಇದೆ ಅಲ್ಲಿ. She has arrested ಅನ್ನೋ ಫೈಂಡಿಂಗ್ ಇದೆ. And she has the finding is recorded. When she is a party, she has engaged a lawyer. ಅದ್ ಹೆಂಗ್ ಓವರ್ಕಮ್ ಮಾಡೋದು ನಾವು? ಈ ಫೈಂಡಿಂಗ್ ಇದೆ, ಏನ್ ಮಾಡ್ಬೇಕು? It has attained finality. You are a party.
Yes.
You had engaged a very senior lawyer, member of the bar.
Yes.
This harass ಇಲ್ಲ 2013 ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಬಿಟ್ಟ. ಫ್ಯಾಮಿಲಿ ಕೋರ್ಟ್ಸ್ ಯಾಕೆ ಕೊಡಿ? ಅವ್ರು ಆ ಊರಲ್ಲೂ ಇಲ್ಲ.
ಇಲ್ಲ, ಎಲ್ಲ ಮೊದಲು
ಬೇರೆ ಬೇರೆ ಊರಲ್ಲಿ ಇದ್ದಾರೆ ಅಂತ ಬರ್ತಾರೆ.
ಅವರು ಆ ಊರಲ್ಲಿ ಇಲ್ಲ. ಬಟ್ ಲಾರ್ಡ್
ಆಮೇಲೆ ಮಾವ 5 ವರ್ಷ, ಅತ್ತೆಗೆ 82 ವರ್ಷ. ಅವ್ರು ಹೆಂಗ್ ಹರಾಸ್ ಮಾಡ್ತಾರೆ?
Lord, the dispute started by them only, my lords, with my father and my mother.
ಅಷ್ಟೆಲ್ಲ ವಯಸ್ಸಾದವನ್ನ ಜೈಲಿಗೆ ಹಾಕಿಸಿ ಟ್ರಯಲ್ಗೆ ಒಳಪಡಿಸಿ ಮಾಡೋದು ಹಿಂಗೆ ನಾವು ಇದು ಮಾಡೋದು ಅದನ್ನೆಲ್ಲ ಅದು ಕ್ರೂಯಲ್ಟಿನ ಆಗತ್ತದು. ಆಮೇಲೆ ಅಷ್ಟೆಲ್ಲ ನಿಮಿಷ ಕೇಳ್ಕೊಳ್ಳಿ. ನಮ್ಮ ತಂದೆ ತಾಯಿಗೆ, ಅಣ್ಣ ತಮ್ಮಂದರಿಗೆ, ಅಕ್ಕಂಗಿಯರಿಗೆ ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಹಾಕಿ ಅವರನ್ನ ಕ್ರಿಮಿನಲ್ ಟ್ರಯಲ್ಗೆಲ್ಲ ಒಳಪಡಿಸೋದಿದೆಯಲ್ಲ, ಇಟ್ಸ್ ಎ ರಿಯಲ್ ಕ್ರೂಯಲ್ಟಿ. ಅಂಥವ್ರ ಜೊತೆ ಜೀವನ ಹೆಂಗ್ ಮಾಡ್ತಾನ ಗಂಡ? ಸಹಬಾಳ್ವೆ ಮಾಡಕ್ ಆಗೋದೇ ಇಲ್ಲ. As maybe as possible. Summary procedure. ನಿಮ್ಮ ಈಗ ಮೇಜರ್ ಆಗಿದಾರಲ್ಲ ಮಕ್ಕಳು 16-18 ವರ್ಷ.
ಮಗ ಮೇಜರ್ ಆಗಿದ್ದಾನೆ.
ಅವ್ರೇನ್ ಹೇಳ್ತಾರೆ?
ಮಗಳು. That my lord, that they have been brought up by the wife only, mother only. They are always with the mother and they have been brought up by the mother only. ಅಂದ್ರೆ only my lord
ಅವ್ರು ಏನ್
aspect
ಹೇಳ್ತಾರೆ?
is,
ಈ ಕೇಸಿನ ಬಗ್ಗೆ ಗಂಡ ನಮ್ಮ ಅಪ್ಪ ಅಮ್ಮ ಜೊತೆಗಿರ್ಬೇಕು ಅಂತ ಬಯಸ್ ಎಲ್ಲಿದ್ದಾರೆ ಅವರು?
my lord, I'll keep them present. my lord.
ಯಾವ ಊರಲ್ಲಿ ಇದೆ?
ಅವ್ರು ಕೆರೂರು, ಬಾಗಲಕೋಟ್ district.
ಬಾಗಲಕೋಟ್ ಡಿಸ್ಟ್ರಿಕ್ಟ್.
I'll keep them present, my lord.
Resolution is one aspect. Permanent element.
ಒಂದು ಎಲಿಮಿನಿ ಏನಾದ್ರು ಕೊಡ್ಬೇಕಲ್ಲ?
Please, Your Lordship.
ಏನು ಎಷ್ಟು ಕೊಡ್ತೀರಿ?
ಮದುವೆ ಹೆಂಗಲ್ ಮಾಡೋದು?
Consult my client not be-
ಹೆಣ್ಮಗು ಇದೆ.
16 ವರ್ಷದ
ಯಾರು ಮಾಡೋದು?
ಗರ್ಲ್.
ಟೀಚರ್ ಅಲ್ವಾ ನೀವು?
ನಾವು ಟೀಚರ್ ಅವರು ಪ್ರೈವೇಟ್ ಸ್ಕೂಲ್ ವರ್ಕ್ ಮಾಡ್ತಿದ್ರು ನಾವು ದಿ ಪ್ರೆಸೆಂಟ್ ಅಪ್ಲೈಂಟ್ ಆಲ್ಸೋ ಇಸ್ ವರ್ಕಿಂಗ್ ಇನ್ ಪ್ರೈವೇಟ್ ಸ್ಕೂಲ್ ಟೀಚರ್.
My lord, when
She's a
there was no
graduate.
economic source, brother found something and
ಎಲ್ಲ ಮಾಡಿ ಅರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಬಾರ್ದು. ಸೈಲೆಂಟ್ ಇರ್ಬೇಕು, ಸ್ವಲ್ಪ ವೈನ ಬರ್ತಾ ಇದೆ. ಏನ್ ಮಾಡ್ತೀರಾ? ಕರೆಸ್ತೀರಾ ಅವ್ರಿಗೆ?
ಪ್ಲೀಸ್
ಯಾವತ್ತು?
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಎನಿ ಡೇಟ್ ಮೇಕ್ ಅವಿಲ್ಲ ಕರೆಸ್ತಾರೆ.
ಅಲ್ಲ ಕರ್ಸಿ ಮುಂದೆ ಎಲಿಮಿನಿ ಇಸ್ಕೊಳ್ಳಿ ಅಷ್ಟೇ. ಈಗ ಇಷ್ಟೆಲ್ಲ ಮಾಡಿದ್ಮೇಲೆ ಗಂಡ ಬಾ ಅಂದ್ರೆ ಹೆಂಗ್ ಬರ್ತಾನೆ? ಗಂಡನ್ನ ಪ್ರೀತಿಯಿಂದ ಗೌರವದಿಂದ ಕಂಡ್ರೆ ಗಂಡನ್ ಕರೀಲಿಕ್ಕೆ ಬರ್ತದೆ. ಗಂಡನ್ ಹರೇಸ್ ಮಾಡಿಬಿಟ್ರೆ ಅವ ಹೆಂಗ್ ಸಹಬಾಳ್ವೆ ಮಾಡ್ಲಿಕ್ಕೆ ಮಾಡೋದು ಹೆಂಗ? ಇಂಪಾಸಿಬಲ್. ಸೂಟ್ ಹಾಕೊಂಡ್ರಿ ವೆಲ್ ಅಂಡ್ ಗುಡ್, ಇಟ್ಸ್ ನಿಮ್ ರೈಟ್, ನಿಮ್ದು ಆಲ್ ರೈಟ್. ಈ ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಮಾಡಿ ಗಂಡನ ತಂದೆ ತಾಯಿ ಅಣ್ಣ ತಮ್ಮ ಅಕ್ಕ ತಂಗಿ ಮೇಲೆ ಎಲ್ಲ ಅವ್ರು ಬೇರೆ ಊರಲ್ಲಿದ್ದಾರೆ. ಅತ್ತ ಮಾವ 85, ಅತ್ತೆ 82. ಅವ್ರೇನ್ ಅರೆಸ್ಟ್ ಮಾಡ್ತಾರೆ? ಅವ್ರಿಗೆ ಅರೆಸ್ಟ್ ಮಾಡಕ್ ಆಗ್ತದ?
actually, as my lord, the dispute started by them only, my lords, with my father and my mother. In fact, your lordship may also kindly see the age difference is 15. The age difference between both of them is 15 years, my lord. ಇವರೇ ಎಲ್ಲ ಹೇಳಿ ಇವರೇ ಮದುವೆ ಮಾಡಿಸಿ ಆಮೇಲೆ ಅವ್ರವ್ರ ನಡುವೆ ಏನೋ ಒಂದು ಡಿಸ್ಪ್ಯೂಟ್ ಬಂತು ಅಂತ ಹೇಳಿ it has reached this stage.
Cruelty ಇದೆ.
It has reached
judgment is very badly written is one thing.
Yes.
We will make it good by our reasoning. Because there is abundant material against you.
No, that's the only reason, and it was not quashed against the husband.
ಎಲಿಮಿನಿ ಕೊಡ್ರಿ ಎಷ್ಟು ಬರಿಬೇಕು? ನಾವು ಬರ್ದ್ಬಿಡ್ತೇವೆ ಮತ್ತೆಲ್ಲ ಕೇಳಿ ಮಾಡಿ ಮಾಡಕ್ಕಾಗಲ್ಲ. ಹೆಂಡತಿ ಬೇಡ ಅಂದ್ರೆ ಹೆಂಡತಿ ಬದುಕ್ಬೇಕಲ್ಲ.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಡೇಟ್
ನೋ ಡೇಟ್ ವಿಲ್ ಬಿ ಗಿವನ್. 2:30 ಬಂದ್ಕೊಂಡು ಹೇಳ್ಬೇಕು. ಮತ್ತೆ ಬರೀ ಇದೇ ಟೈಮ್ ನಲ್ಲಿ ಜೀವನೆಲ್ಲ ಹಾಳಾಗಿ ಹೋಗ್ತದೆ. ಟೈಮ್ ತಗೊಳ್ಳೋದು ಲಿಟಿಗಂಟಿಗೆ
ಫ್ರೈಡೆ ನಾನು ಕೇಳ್ಕೊಂಡಿದ್ ಮಾಡ್ತೀವಿ. ಅಟ್ಲೀಸ್ಟ್ ಫ್ರೈಡೆ
2:30 ಬರ್ರಿ. ಟೈಮ್ ಕೊಡಲ್ಲ ನಾವು, ಹಿಯರ್ ಮಾಡಿ ಆಗಿದೆ. ಇಲ್ಲ ನಾವು
ಇಲ್ಲ ಸೆಕಾಸೈಡ್ ಮಾಡಿ ರಿಮಾಂಡ್ ಮಾಡ್ಬೇಕಾದ್ರೆ
ಮತ್ತೆ 10 ವರ್ಷ ನಡೀತದೆ.
ನಿಮ್ಗೆ ಕಷ್ಟ ಆಗತ್ತೆ.
10 ವರ್ಷ ನಡೀತದೆ.
ಕೇಳ್ಕೊಂಡು ಹೇಳ್ತೇನೆ.
2:30
ಜಜ್ಮೆಂಟ್ ಬರೀಬೇಕು ಇವತ್ತು.
ಕನ್ಸಲ್ಟ್ ಪ್ಲೀಸ್.
ಮ್ಯಾರೇಜ್ ಕೇಸಸ್ ಆದ್ರು, ಮ್ಯಾರೇಜ್ ಡೈವೋರ್ಸ್ ಕೇಸ್ಗಳು ಬೇಗನೆ ಮುಗಿಬೇಕು.
ಫೋನ್ ಮುಖಾಂತರ ಕನ್ಸಲ್ಟ್
ಮೆಮೊ ಹಾಕಬೇಕು, ಇಷ್ಟು ಕೊಡ್ತೇವೆ ಅಂತ.
ಇಮಿಡಿಯೇಟ್ಲಿ 2:30 ಬರ್ಬೇಕು. ಹೇಳಿ ನಿಮ್ದು ಕ್ಲೈಂಟ್ ಬರಕ್ಕೆ ಹೇಳ್ರಿ ಅವರಿಗೆ.
ಟೀಚರ್ ಈಸ್ ಗವರ್ಮೆಂಟ್ ಸ್ಕೂಲ್ ಟೀಚರ್.
ಮಕ್ಕಳು ಪಾಪ ಮಕ್ಳು ಏನ್ ಮಾಡ್ಯಾವಪ್ಪ? ಈಗ ನಿಮ್ ಭಿನ್ನಾಭಿಪ್ರಾಯ ಇರೋದು ಹೆಂಡತಿ ಜೊತೆ, ಹೌದಾ? 2 ಮಕ್ಕಳನ್ನ ಹಡ್ಕೊಂಡ್ರಿ ನೀವು, ಮತ್ತ ಅವಳು ತೊಡೆ ಮೇಲೆ ಹಾಕಿ ಹೋಗ್ಬಿಟ್ರಿ. ಅವಳು ಎಂತದೇ ಮಾಡಿ ಮಕ್ಕಳ ಸಂಬಂಧ ನೋಡಪ್ಪ, ನಿನ್ ಜೊತೆ ನನ್ಗೆ ಸರಿ ಇಲ್ಲ, ಆದ್ರೆ ಮಕ್ಕಳಿಗೆ ನಾನು ಏನ್ ಕೊಡೋದು ನಾ ಕೊಡ್ತೇನೆ, ಈ ಅಮೌಂಟ್ ಅನ್ನು ಉಪಯೋಗಿಸು, ಸರಿಯಾಗಿ ಬೆಳೆಸು, ಅವರಿಗೆ ಒಳ್ಳೆ ಬಟ್ಟೆ ಹಾಕು, ಸ್ಕೂಲಿಗೆ ಕಳಿಸು, ಪುಸ್ತಕ ಕೊಡಿಸು ಅಂತದ್ ಎಲ್ಲಿದೆ? ಆ ಕಾಂಡಕ್ಟ್ ಇಲ್ಲೇ ಇಲ್ಲ. ಹೆಂಡ್ತಿ ಹಿಂಗ್ ಮಾಡಿದ್ಲು ಅನ್ಕೊಂಡು ಎಲ್ಲ ಅವಳ ಮೇಲೆ ಭಾರ ಹಾಕಿ ಹೋಗ್ಬಿಟ್ರೆ ಹೆಂಗೆ? ಏನೋ ತಪ್ಪಾಗಿರ್ಬೋದು, ಬಟ್ ಹೆಂಡ್ತಿಗೆ ಸಂಬಂಧಪಟ್ಟಂಗೆ ತಪ್ಪಾಗತ್ತೆ. ಮಕ್ಳೇನ್ ಸಂಬಂಧ? ಮಕ್ಳಿಗೆ ಏನ್ ಕನ್ಸದ ತೋರಿಸಿರಿ ನೀವು? ಏನು ತೋರಿಸಿಲ್ಲ. ಮತ್ತೆ ಅದು ಕ್ರುಯಲ್ಟಿನ ಆಗತ್ತೆ, ನಿಮ್ದು ಕೌಂಟರ್ ಕ್ರುಯಲ್ಟಿ ಆಗತ್ತೆ. ಬೇಗ ಹೇಳ್ಬೇಕು. 2:30
ಪ್ಲೀಸ್.
ಟೈಮ್ ಕೊಡಲ್ಲ ನಾವು, ಕೇಸ್ ನಡೆಸಬೇಕು. 2:30 ಬರೀ.
Cell number 47, my lords.
2:30 ಟೈಮ್ ಕೊಡಲ್ಲ ನಾವು. We do not give time.
Parties are present.
Present. ಬರ್ 2:30 ಬರ್ತೀವಿ. ವೀಕ್ ಇದೆ ನೀವು ಹೇಳ್ತಾ ಇರೋದು ವಾಯ್ಸ್ ಇಟ್ಕೊಳ್ಳಿ.
Let's matter pertaining to principal Bangalore, my lord. Your lordship was pleased to allow the writ petition holding it was covered by a judgment of Honorable Apex Court. But in fact, it was not covered, my lord. Therefore, the respondent company has filed an application seeking to
Review.
my lord, that
Review.
application is filed for recalling
ರಿವ್ಯೂ ಹಾಕೋಬೇಕು.
that
ಮೆರಿಟ್ ಮೇಲೆ ನೀವೇನ ಟಚ್ ಮಾಡೋದಿದ್ರೆ ರಿವ್ಯೂ ಬೇಕಾಗ್ತದೆ. ಅಪ್ಲಿಕೇಶನ್ ಯಾವುದಕ್ಕೆ? ಅಪ್ಲಿಕೇಶನ್ ಹೆಂಗೆ? ಯು ಹ್ಯಾವ್ ಟು ಫೈಲ್ ರಿವ್ಯೂ. Order 47 rules 1 and 2 are held applicable to writ petition also. Review ಹಾಕೋಬೇಕು.
please.
ಇಲ್ಲ ಪಾಸ್ ಓವರ್ ಮಾಡಿ ನೋಡೋಣ ಬಂದ್ರು ಬರ್ತು. ಹಾ
My lordship, for the petitioner, my lordship.
ಹಾ
EP, my lord. I have dispensed all the office objections, my lordship.
objection dispense
Comply ಮಾಡಿದ್ದೀನಿ, my lord.
ಕಂಪ್ಲೈ ಮಾಡಿಲ್ವಾ?
ಮಾಡಿದ್ದೀನಿ, my lord.
ಮಾಡಿದ್ದೀರಾ?
ಮಾಡಿದ್ದೀನಿ, my lord. ಮಾಡಿದ್ದೀನಿ, IA ಹಾಕಿದ್ದೀನಿ, my lord. Dispensation.
What is to be dispensed now?
Typed copies of those, ಇದು, my lordship. ಅದು ನಾನು ಅಂಡರ್ಟೇಕಿಂಗ್ ತಗೊಂಡಿದ್ದೀನಿ, my lordship.
ಅಲ್ಲ ಅದು ಹಾಕ್ಬೇಕಾಗ್ತದೆ ಬೇಕಾ ಟೈಮ್ ಕೊಡನಂತೆ.
ಅದಕ್ಕೆ ಡಿಸ್ಪೆನ್ಸೇಷನ್ಗೆ IA ಹಾಕಿದ್ದೀನಿ, my lordship.
ಡಿಸ್ಪೆನ್ಸ್ ಮಾಡಕ್ ಬರಲ್ಲ.
ಅಲ್ಲ ಅದನ್ನ
ಟೈಮ್ ಮಾಡಬೇಕು.
ಅಂಡರ್ಟೇಕ್ ಮಾಡ್ತೀನಿ, ಇದು ಅಂಡರ್ಟೇಕಿಂಗು ಹಾಕಿದ್ದೀನಿ, my lordship. ಅದು ಟೈಪಿಂಗ್ ಕಾಪಿನ ಸಬ್ಮಿಟ್ ಮಾಡ್ತೀನಿ ಆಮೇಲೆ ಅಂತ.
ಅಷ್ಟು ಟೈಮ್ ಕೊಡ್ತೇವೆ, ಯಾವತ್ತು ಹಾಕ್ತೀರಿ ಹೇಳಿ?
ಅಲ್ಲ, my lordship, ಅದಕ್ಕೆ ಡಿಸ್ಪೆನ್ಸೇಷನ್ಗೆ ಅವಕಾಶ ಇದೆ, my lordship. ಇದೆ, my lordship. ಇದೆ, my lordship.
ಎಲ್ಲಿ ತೋರಿಸಿ.
ಇದು ಬೆಂಗಳೂರಿನಲ್ಲೆಲ್ಲ ಮಾಡಿದೀವಿ, my lordship.
Don't say what in England what is happening. Show the rule. Show the rule.
Dispensation of translated copies.
ನೀವಿದೆ ಅಂತೇಳಿ ನಾ ಇಲ್ಲ ಆಗ್ತೇನೆ. ನಿಮ್ಮನ್ನ ಕನ್ವಿನ್ಸ್ ಮಾಡೋ ಅಗತ್ಯ ಇಲ್ಲ. ನೀವು ನಂಗೆ ಕನ್ವಿನ್ಸ್ ಮಾಡಿದ್ರೆ ಆರ್ಡರ್
kindly pass over, my lordship. I'll get the much obliged.
ಎಲ್ಲರಿಗೂ ಗೊತ್ತರ ಇದೆಯಲ್ಲ ಹಿಂಗ ಮ್ಯಾಟ್ರಸ್ ಇದೆ ಅಂತ. ಯಾರು ಬರ್ತಾನೆ ಇಲ್ಲ.
One submission. My name is also reflecting on what basis my senior had filed this review petition, my lord. I will go through and make submission by the next date. By the next date, I will make submission after getting instruction from my senior, my lord. Yes.
Call when this judge sits single.
Please.
On request of court, see, HCGP Shri so. Yes, brother.
Yes, my lord. The very briefly facts to tell, my lord. The intelligence authorities visited my business premises, my lord. And they seized the books of accounts. And next day also they seized the books of accounts. Then I had my sister concern, which is called HVK Marketing, which deals in Gutka, my lord. It is a separate firm, registered under the act, filing return, facing the assessments. Their stock was included here. And then without giving further opportunities, and he asked me to produce the books of accounts. Books of accounts were in his custody. And he passed a protective assessment order under section 38, my lord. Yes, my lord. Protective assessment can be passed as per the TTK healthcare, the president of this honorable court, who can run away, who has a immobile property, who has something else. Protective assessment cannot be passed, and regular assessment has to be passed. But instead, she passed the protective assessment, created a 40 lakh rupees demand, my lord. Then as per the section 38 provision, this protective assessment has to be passed by the assessing authority by obtaining prior permission of the same joint commissioner who issued him the assignment for inspection, my lord. And very strangely in the provision, we have to approach him also for cancellation of the protective assessment. And
Filed, you had filed 2019.
Yeah. Yes, ma'am.
You have filed it in 2018.
Yes, my lord.
Petition was filed.
Yes, my petition was filed, my lord, on 10/12/2012, my lord.
Challenging
Yes, my lord.
the order dated 9/6/2011.
Yes, my lord. I have challenged the annexure L, my lord.
Petition in 2018.
No, he passed the endorsement rejecting my application for the first time, on 157 page, my lord. Annexure L, my lord, on 20th/6/2018.
26/2000.
18. Annexure L, my lord, 157 of the documents. He did not give me opportunity of hearing, my lord.
But
There is
when we
a,
come to page 23, 33. Read
Yes.
para 3.
yes, my lord, order of the honorable court. Yes, my lord. In third para, my lord, the honorable court observed that 10/12/2012 made under section 38(5)(b).
Para 3.
Yes, my lord.
Of the order.
Having already been rejected on 3/5/2015, my lord. So 2015, it was not rejected, my lord. Some other new joint commissioner came in, there were transfers. And he issued me one reminder, you produce the books of account within 7 days. Then I have, in the writ petition, I explained that I went to his office, he was not available. Then he said that we'll fix up the time and date, then you come down. Then he was transferred down. So no joint commissioner. In the writ petition, I have explained, my lord, at page number.
No, these things cannot happen orally. He should have sent a notice to you, or you should have sent a letter to him saying that it has happened like this.
No,
Please read 3, para 3.
Yes, my lord, under submission is
Please read. When court says-
3/5/2015, my lord.
When court says
It
read,
is,
you have to
it is,
read.
it is not a rejection order.
When court says read, you have to read.
May I read it, my lord?
Yes, para 3.
Yes, my lord. The impugner order specifically states that assessment order was made in absence of books of accounts.
Read fully.
Yes, my lord. Books of accounts are seized with him. Despite repeated notices, it did not choose to produce. It also states about his application dated 10/12/2000 made under section 31 by having already been rejected 3/5/2015, my lord. So that 3/5/2015 is not endorsement of my rejection, my lord. 18 is a rejection.
Do you have that
Yes, my lord.
endorsement, 2000?
Yes, my lord.
10/12/2000, sorry, 3/5/2015.
3/5 at page number, my lord. Annexure yes 151, my lord.
151.
Annexure H 152.
152.
152 Annexure H, my lord. Endorsement 3/5/2013. A typed copy is also there, sir, my lord. Only I had sought to remand the case to him, my lord, for because I did not have an opportunity to explain, because the seized books were relating to my sister concern. They had accounted everything else.
This is dated?
Dated 3/5/2013, my lord.
Not
Annexure H, my lord.
3/5/2015.
3/5/2015.
Which is referred to in para 3 of my order.
There is no 3. I tried to locate the documents, my lord, in writ petition. There is no document as such. It is 3/5. Typed copy is wrongly mentioned as 8/5/2013. Then in the records, in the writ petition also, there was no.
Kindly come to.
Yes, my lord.
Annexure H, page, sorry, G at page 157.
Yes, my lord.
157.
Yes, my lord.
This is the opportunity was given to you. You are given opportunity to produce acknowledgement
No, he
receipt for the
said
said application within 7 days.
My lord, opportunity, earlier endorsement, he asked me, I went there. There is a change of joint commissioners in 7 years.
All right. Then come to 3/5/2013. Annexure H. Final opportunity is given to represent your case either personally or through your representative.
2013, my lord.
Correct.
Then I went there. Books of accounts are with their custody intelligence. I don't have any books of accounts. But my sister concerned stating that inspection report I have produced, I have given them.
When did you go?
My reply, my lord, my reply to the original authority at page number. It is in writ petition, my lord.
Page it.
ಇದಕ್ಕೆ enclosed ಮಾಡಿಲ್ಲ writ petition 14, the original writ petition copy, my lord, at page number 14, that is paragraph 26 and 27, I have written, my lord. Whole explanation is given.
That's all right. But when then again come to 8/5/2013 endorsement at page 159.
Yes, my lord.
So many notices have been sent to you.
My lord, I have filed the appeal. Then books of accounts were in the custody of the intelligence authority. They have seized the books of accounts. Then it is their custody. Something I have produced stating about stock difference about the gutka, which is my sister concern. I have filed all the purchase invoices, everything else. That was intimated to the assessing authority, my lord. That is inspection authority. It is not a regular assessment, my lord. It is a protective assessment. Therefore, justice require, my lord, the demand may be given. Give me opportunity. I will prove that those transactions not to me in the interest of justice, my lord.
Notice ಆಗಿಲ್ಲ ಅನ್ನೋದು. Joint Commissioner of Commercial Taxes ಯಾರು? HCGP is requested to accept notice for first respondent. First respondents. ನೋಡ್ಕೊಳ್ಳಿ ಅವ್ರು ಏನ್ ಹೇಳ್ತಾರೆ ಅಂತ. Okay?
Yes.
Of course, this matter when the judge of this court sits single. This judge sits
Oblige.
single. Yes. ಏನು ಕೊಡಿ. Of petition for non-compliance, these objections at serial number so and so and so. Recalling the peremptory order, no? Peremptory order ಮಾಡಿತ್ತಾ? Issue notice. Notice ಆಗಬೇಕಾಗ್ತದೆ, but ಮೊದಲು notice ಆಗಿರಲಿಲ್ಲ. This court, while peremptory order dated 1/6/2022 had dismissed the review petition for non-compliance of office objections. First, the petitioner has filed this application seeking recall of the said order. First, application is supported by a narrative affidavit which explains as to why the office objections pointed out, remained uncomplied. First, there is an assurance to comply the office objections immediately, if the peremptory order is recalled and matter is restored to the board. First, in matters like this, such assurances suffice. First, next, in the above circumstances, the delay is condoned and application seeking recall having been favored, the order dated 1/6, peremptory order dated 1/6/2022 stands recalled. And as a consequence, the petition is restored to the board. First, petitioner to comply with office objections within an outer limit of 2 weeks. Filling which, the order now made would revive as phoenix. Yes. Okay, 4 weeks time granted to comply with office objections. First of all, the requirement of compliance being mandatory, the application seeking dispensation supported by the affidavit cannot be favored, and accordingly it is disposed of. 29. Not well. But 2 weeks, 2 weeks. Next. 20. Huh? 30. 30. ಏನು? ಲೂಕಸ್ ಮತ್ತೆ ಅವ್ರಿಗೆ ನೋಟಿಸ್ ಕೊಟ್ರೆ ಆಯ್ತಾನ ಈಗ? ನೋಟಿಸ್ ತೊಳಿ ಯಾರು?
ಏನದು ಲೋಕಸ್ ಹೋಗ್ಬೇಕು ಇಳಿಬೇಕು? ಆಯ್ತು
ಹಾಕಿ
ರಿಕ್ವೆಸ್ಟ್ ಲಿಸ್ಟ್ ಆನ್
ಲಿಸ್ಟ್ ಇದ್ರ ಜೊತೆ ಕನೆಕ್ಟೆಡ್ ಮಾಡಿದ ಜೊತೆ ನಾವು ಕೂಡ ಪ್ರಶ್ನೆ ಬರೋದಿಲ್ಲ. ಉಳಿಯೋದಿದ್ದು ಕೂಡ ಬೇಕಾಗಿಲ್ಲ. 47 ಬಂದಾರ? ಹಾ, ಕಾಂಪ್ರಮೈಸ್ ಆಗಿದೆಯಾ? ಇಲ್ಲ. ಏನಿದು ಬ್ಯಾಟ್ರಿ ನೆನಪಿಲ್ಲ ನಂಗೆ. ಏನಿದು? ಡಿವೋರ್ಸ್. ನೀವ್ಯಾರಿಗೆ? ವೈಫ್, ಹಸ್ಬೆಂಡ್, ಯು ಆರ್ ಫಾರ್ ವೈಫ್. ಕುಡಿ. ಅಲ್ಲ ಏನ್ ಮಾಡ್ಬೇಕು? ಪಾರ್ಟಿ ಇದ್ರೆ ನಾವೇನೋ, ನೀವೇನಾದ್ರೂ ಪಾರ್ಟಿ ಕಾಂಪ್ರಮೈಸ್ ಮಾಡ್ಕೊಳ್ಳಂಗಿದ್ರೆ ನಾವೇನಾದ್ರು ಪ್ರಯತ್ನ ಮಾಡ್ಬೋದು. ಏನಾದ್ರು ಆಗ್ತದಾ?
ಅವ್ರು ರೆಡಿ ಇದ್ದಾರೆ.
ಕಾಂಪ್ರಮೈಸ್ ರೆಡಿ ಇದ್ದಾರಾ? ಏನ್ ಕಾಂಪ್ರಮೈಸ್? ಬನ್ನಿ. ಹಾ,
ಡಿಸ್ಮಿಸ್ಡ್. ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ. 2021 ಮದುವೆ ಆಗಿದೆ.
2021ಗೆ ಮದುವೆ ಆಗಿದೆ. 3 ವರ್ಷ.
ಮಕ್ಕಳಿದಾರ?
ಮಕ್ಕಳಿದಾರ?
ಮಗು ಇದೆ.
ಮಗು ಇದೆ.
ಎಸ್ ಮಿಸ್ಟರ್ ಕುಮಾರ್ ಮುಂದೆ ಬನ್ನಿ. ಅಲ್ಲಿ ವಕೀಲರ ಹತ್ರ ಬನ್ನಿ. ಎಷ್ಟು ಬೇಗ ಯಾಕೆ ಬೇರೆ ಆಗ್ತಾ ಇದೀರಾ? ಕಾಣಂಗ್ ಬನ್ನಿ. ಕಾಣ್ಬೇಕು.
ಇವ್ರಿಗೆ ಕಾಣ್ಬೇಕಲ್ಲ, ನೀವು ಮೈಕಿಗೆ ಬನ್ನಿ.
ಸಾಹೇಬ್ರು ಇದ್ ನೋಡಿ ತಾರೀಖ್, ನೀವು ಮದುವೆ ಆಗಿದ್ದ ತಾರೀಖ್ ನೋಡ್ಬಿಟ್ಟು ಯಾಕೆ ಇಷ್ಟು ಬೇಗ ಅಂತದೇನು ವ್ಯತ್ಯಾಸ ಬಂತು, ಜೊತೆ ಇರ್ಬೋದಲ್ಲ ಅಂತ ಅಂತಾರೆ.
ಇಲ್ಲ ಸರ್, ನನಗೆ ನನ್ನ ಹೆಂಡತಿ ನನ್ನ ಪಾಪು ಬೇಕ್ರಿ. ಅವಳು ಜೊತೆಗೆ ಬಂದು ಜೀವನ ಮಾಡಕ್ ಆಗಲ್ಲ ಅಂತ ಅಂದ್ರಿ. ಬಾಡಿಗೆ ಮನೆ ಮಾಡಿದ್ದೆ ಸರ್, ಬಾಡಿಗೆ ಮನ್ಯಾಗೂ ಜೀವನ ಮಾಡಿಲ್ರಿ. 2 ತಿಂಗಳ ಇದ್ರಿ. ಅಲ್ಲಿನ ನನ್ನ ಮುಸ್ರಿ ಕಸ ಹೊಡೆದ ಅವೆಲ್ಲ ಸಾಮಾನು ಮಾಡೋದಾಗಲ್ಲ, ಆಳ್ ಹಚ್ಚಿ ನೀನ್ ಮಾಡ್ಕೊಂತೀನಿ ಅಂತಂದು ಹೇಳಿದ್ರಿ. ಆಯ್ತು ಅಂತಂದು ಹೇಳಿ ಬಾಡಿಗೆ ಮನಿನ ಮಾಡಿದೆ. ಎಲ್ಲದ ಅವಳಿಗೆ ಏನ್ ಸೌಕರ್ಯ ಬೇಕು ಕಾಲೇಜು ಕಲಿಸಿದೆ, ಎಲ್ಲದ ಮಾಡಿದೆ ಸರ್. ಅವ್ರ ತಾಯಿಯರ್ದು ಅವರು ಮನೆ ಏನಾಗಿರ್ಬೇಕು, ನೀನು ನಾವ್ ಇಲ್ಲಿ ಇದ್ರ ಆಗಂಗಿಲ್ಲ ಅಂತಂದು ಹೇಳಿ ನನ್ನ ಬಹಳ ಹರಾಸ್ಮೆಂಟ್ ಮಾಡ್ಕೊಂಡು ಕೆಲ್ಸಕ್ಕೆ ಹೋದಲ್ಲಿ ಬಂದು ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಕಂಪ್ಲೇಂಟ್ ಎಲ್ಲ ಕೊಟ್ಟು ಬಹಳ ಇದು ಮಾಡಿದ್ರು ಸರ್.
ಯಾರಿಗೆ ಕೊಟ್ಟು?
ನನಗೆ.
ಅರೆಸ್ಟ್ ಆಗಿದ್ರಾ?
ಅರೆಸ್ಟ್ ಅಂದ್ರೆ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ರಿ.
ಕಂಪ್ಲೇಂಟ್ ಏನಂತ ಕೊಟ್ರು?
ಬಡಿತನ ಅಂತಂದೇಳಿ ಸರ್. ಬಡಿತನ, ಚಿತ್ರಹಿಂಸೆ ಕೊಡ್ತಾನಂತಂದೇಳಿ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ದೀರಿ. ನಾವು ಗುರು ಹಿರಿಯರೆಲ್ಲ ಕರ್ಕೊಂಡು ಮನೆಗೆ ಹೋದ್ವಿ. ಇಲ್ಲಪ್ಪ ನೀವು ಕೋರ್ಟ್ ಮುಖಾಂತರ ಬರ್ಲಿ, ನನ್ನ ಮಗಳು ಬಾಳೆ ಮಾಡಕ್ ನಂಗೆ ಇದೆಲ್ಲ ಅಂತಂದು ನಾನು ಎಷ್ಟೋ ಸಲ ಕನ್ವಿನ್ಸ್ ಮಾಡಿದರೆ, ಇವಳು ಕಾಂಟ್ಯಾಕ್ಟ್ ಮಾಡಕ್ ನೋಡಿದೆ ಸರ್. ಬಟ್ ಇಲ್ಲ, ನಾನು
ಹೊಡೆದು ಬಡ್ದು ಮಾಡಿದ್ರೆ ಯಾವ ಹೆಣ್ಮಕ್ಳು ಜೊತೆಗೆ ಇರ್ತಾರೆ? ಈಗ ಹೊಡೆದು ಬಡ್ದು ಮಾಡಿದ್ರೆ ಯಾವ ಹೆಂಡತಿ ಜೊತೆಗೆ ಇರ್ತಾರೆ?
ಇಲ್ಲ ಸರ್, ಹೊಡೆದಿಲ್ಲ ಸರ್.
ಅವ್ರು ಸುಳ್ಳು ಯಾಕೆ ಹೇಳ್ತಾರ? ಅವ್ರು ಕಾರಣನ ಇಲ್ದಂಗೆ ಪ್ರೀತಿಯಿಂದ ಇದ್ರು ಸಹಿತ ಸುಳ್ಳೆ ಹೊಡೆದೇ ನಿಂತ ಹೇಳ್ತಾರ ಯಾರಾದ್ರು?
ಇಲ್ಲ ಸರ್, ಹೊಡೆದಿದ್ದು ಬಡಿದು ಮಾಡಿಲ್ಲ ಸರ್.
ನಾವು ಸುಳ್ಳು ಯಾಕೆ, ಹೆಣ್ಮಕ್ಳು ಈಗ ಸುಳ್ಳು ಯಾಕೆ ಹೇಳ್ತಾರೆ? ಹೆಂಡತಿ ಯಾಕೆ ಸುಳ್ಳು ಹೇಳ್ತಾಳಪ್ಪ?
ಇಲ್ಲ ಸರ್.
ಏನು ಲಾಭ ಅವಳಿಗೆ? ಗಂಡ ಸುಳ್ಳು ಹೊಡೆದ್ರೆ ಹೇಳಲ್ಲ ಅವ್ರು ಇನ್ನು ಅಂತದು ಹೊಡೆದಾಗನೇ ಹೇಳ್ತಾರ ಅವ್ರು.
ಇಲ್ಲ ಸರ್,
ಎಲ್ಲ ಬೇರೆ ಹೆಂಡಂದ್ರೆ ಇಷ್ಟ ಜನ ಇದ್ದಾರಲ್ಲ, ಎಲ್ಲರಿಗೂ ಹೆಂಡತಿ ಗಂಡ ಎಲ್ಲ ಯಾರಿಗೂ ಹೊಡೆದು ಬಿಡೋದು.
ಯಾವಾಗ್ಲೂ ನಾ ಕೈ ಮಾಡಿಲ್ಲ ಸರ್. ಇಲ್ಲಿ ಇದ್ಕೊಂಡು ಹೇಳ್ತಾನಲ್ರಿ, ಕೈ ಮಾಡಿ ಯಾವಾಗ್ಲೂ ಹೊಡೆದಿಲ್ಲ ಸರ್. ಯಾವ್ದೇ ತರದ ಇದು ಮಾಡಿಲ್ಲ ಸರ್. ನನ್ನ ಹೆಂಡತಿ ನನ್ನ ಮಗಳು ಬೇಕಂತಂದು
ಇವಾಗ ಸರಿಯಾಗಿರುತ್ತೆ.
ಮಗು ಇದೆ
ಈಗ ನೋಡಿ ಸರ್, ಇಲ್ಲಿ ಹೊರಗಡೆ ನನ್ನ ಮಗು ಬೇಕಂತಂದು ಎತ್ಕೊಳಕ್ ಹೋದ್ರು ಸರ್, ಕೋರ್ಟ್ ಮುಖಾಂತರ ಆರ್ಡರ್ ತಗೊಂಬ ಅಂತ ಹೇಳ್ತಾರ್ರಿ ಇವ್ರು. ನನ್ನ ಮಗ ಅಲ್ಲೇನ್ ಸರ್ ಅವ್ರು
ಕೋರ್ಟಿಗೆ ಬಂದಿದ್ದಕ್ಕೆ ಮತ್ ಕೋರ್ಟ್ ಏನ್ರ ಅನ್ಬಾರ್ದು ಅನ್ನೋದಕ್ಕೆ ಹಂಗೆ ಹೇಳಿರ್ತಾರ. ಮಗು ಗಂಡ ನೋಡ್ಬಾರ್ದ?
ಪ್ರೆಗ್ನೆಂಟ್ ಇದ್ದಾಗ
ಆ?
ಕುಡಿದ್ ಬಂದು ನನ್ಗೂ ಕುಡಿಸಿ ವಾಂತಿ ಮಾಡ್ಸಿ ಯಾರು ಇರ್ತಾರ್ರಿ ಅವ್ರ ಜೊತೆಗೆ?
ಆಯ್ತಾಯ್ತು.
ನನಗ್ ಕಂಪ್ನಿ ಕೊಡು ನೀವು ಅಂತ ಹೇಳ್ತಾರ್ರಿ ಅವ್ರು. ನಾ ಒಬ್ಬವನ್ ಹಾಕನ್ ಕುಡಿಯಕ ಅಂತಂದು ಹಾಸ್ಪಿಟ್ಲಿಗೆ ತೋರ್ಸಲ್ಲ ಅಂತ ಹೇಳ್ತಾರ್ರಿ. ನಿಮ್ಮ ಅಪ್ಪನ್ ಕಡೆ ದುಡ್ಡು ಇಸ್ಕೊಂಬ, ಬಾಡ್ಗಿ ಕಟ್ಟಕ್ ಆಗಲ್ಲ ನನಗ, ಬಾಡ್ಗಿ ಮನಿ ಮಾಡಕ್ ಆಗಲ್ಲ ನನಗ. ಅವ್ರ ತಾಯಿದು ಆಸ್ತಿ ಐತ್ರಿ, ಹೆಸರಲ್ಲೇ ಅವ್ರ ತಾಯಿ ಹೆಸರಲ್ಲೇ ಐತ್ರಿ ಆಸ್ತಿ. ಅದ್ರ ಸಂಬಂಧ ನಮ್ ಮನಿಗೆ ಅವ್ರ ಮನಿಗ್ ಸ್ವಲ್ಪ ಜಗಳ ಆಗಿತ್ರಿ. ಅವ್ರ ತಾಯಿ ಹೇಳ್ತಾರ್ರಿ ನಮ್ಮ ಅವ್ರ ಅಣ್ಣಂದು ಅವ್ರ ಅಕ್ಕಿದು ಅವ್ರ ಮಕ್ಳು ಚಾಕ್ರಿ ಮಾಡ್ಬೇಕಂತ್ರಿ ನಾನು. ಅಂದ್ರಷ್ಟೇ ಈ ಮನೆಗಿರಿ, ಇಲ್ಲಾಂದ್ರ ಮನಿ ಬಿಟ್ಟು ಹೋಗು, ನನ್ ಮಗನಿಗೆ ಇನ್ನೊಂದ್ ಮದ್ವಿ ಮಾಡ್ತಾನ ನಾನು. ಮನೆ ಬಿಟ್ಟು ಕಳ್ಸಿದ್ರಿ, ಇವ್ರು ಕಳ್ಸ್ಯಾರಿ. ಇಲ್ಲ ಅಂದ್ರೆ 1000 ಜನ ರೊಕ್ಕ ಕೊಟ್ರೆ 1000 ಜನ ಸಿಗ್ತಾರ ಅಂತ ಹೇಳ್ತಾರ ಇವ್ರು.
ಸರ
ರೊಕ್ಕ ಕೊಟ್ರೆ ನೀ ಇಲ್ಲ ಅಂದ್ರೆ 1000 ಜನ ಸಿಗ್ತಾರ ಅಂತ ಹೇಳ್ತಾರೆ.
ಮನಿ ಬಿಟ್ಟು ಒಟ್ಟ ಯಾವಾಗ್ಲೂ ಕಳ್ಸಿಲ್ಲ ಸರ. ಇವ್ರು
ಟ್ರೈ ಮಾಡೇನ್ರಿ, 4 ತಿಂಗಳು ಇದ್ದನ್ರಿ. ಇವ್ರ ಮನ್ಯಾಗ ವಾರಕ್ 3 ಸಲ ನನ್ ಮುಂದ ಕುಡ್ದಾರಿ. ಅವ್ರಿಗೆ ಏನ್ ಬೇಕು ಏನಿಲ್ಲ ಅದಕ್ ತಿನ್ನಕ್ ಅದ್ರ ಜೊತೆಗೆಲ್ಲ ನಾನು ಮಾಡ್ಕೊಟ್ಟನ್ರಿ. ಖುಷಿಯಿಂದನೇ ಮಾಡ್ಕೊಟ್ಟೇನಿ, ಯಾಕಂದ್ರೆ ಅವ್ರಿಗೆ ಖುಷಿ ಆಗತಿ ಅಂತ. ಅದಾಗಿನ ಮೇಲೆ ಹಾಸ್ಪಿಟ್ಲಿಗೆ ತೋರ್ಸಲ್ಲ, ನಾನು ನಿನ್ ಜೊತೆಗ್ ಬರಲ್ಲ, ನಿಮ್ ತಾಯಿ ಕರ್ಕೊಂಡ್ ಹೋಗು ಅಂದ್ರ. ಅದಾಗ್ ಮನಿ ಬಿಟ್ಟು ಹೋದ್ರಿ. ನಾ ಮನಿ ಬಿಟ್ಟು ಹೋಗಿಂದಾನು
ನಿಜ ಅದು. ಈಗ ಒಂದ್ ಮಗು ಬೇರೆ ಇದೆ ನಿಂಗೆ, ಹೌದಾ?
ಇಲ್ಲರಿಪ್ಪ, ಅಷ್ಟ್ ಏನು ಮಾಡ್ಲಿದಂಗ ಅಷ್ಟೆಲ್ಲ ಮಾಡ್ಯಾರಿ. ಇನ್ ಇಷ್ಟೆಲ್ಲ ಆಗಿನ ಮೇಲೆ ಹೋಗಿ ಏನು ಉಪಯೋಗನೇ ಇಲ್ರಿ ಅಲ್ಲಿ.
ಅಂದ್ರೆ ಈಗ ಗಂಡ ಬೇಡ ಬೇಡ ಅಂತ
ಬ್ಯಾಡರಿ ನನಗ. ಈ ಪ್ರೆಗ್ನೆಂಟ್ ಇದ್ದಾಗ ಒಂದ್ ಮೆಸೇಜ್ ಮಾಡಿದ್ರ ಒಂದ್ ರಿಪ್ಲೈ ಇಲ್ಲ, ಕಾಲ್ ಮಾಡಿದ್ರ ಕಾಲ್ ಇಲ್ಲ ರೀ. ಮಗು ಹುಟ್ಟಿಂದಾನು ಕೋರ್ಟ್ನಾಗ ಇದ್ರು ಒಂದ್ಸಲ ನೋಡಕ್ ಬಂದಿಲ್ರಿ ಅವ್ರು.
ಯಾಕೆ ಹಂಗ್ ಮಾಡ್ತಿದ್ರು? ಒಂದು ರಿಪ್ಲೈ ಕಳ್ಸಕ್ಕೆ ಅಲ್ಲಪ್ಪ, ಮೆಸೇಜ್ ಬಂದಾಗನೆ ಒಂದು ರಿಪ್ಲೈ ಕಳ್ಸಕ್ಕಾಗಲ್ವಾ? ಇದೆ ನಾನು ಇಂತ ಬಾರ್ನಲ್ಲಿ ಇದೆ, ನೀ ಬರ್ತೀನಿ, ಬೆಟ್ಟ ಹಾಕೊಂಡ್ ಬರ್ತಾ ಇದ್ದೇನೆ ನಾನು, ಇರು ನೀನು ಒಂದು ರಿಪ್ಲೈ ಕಳ್ಸಕ್ ಬರಲ್ವಾ?
ಇಲ್ಲ ಸರ್, ಇವ್ರ ಅಣ್ಣಾರ್ ಕೂಟ ಕಾಂಟ್ಯಾಕ್ಟ್ ಅದ್ರಿ, ಇವ್ರ ಅತ್ತಿಗೆ ಮರ್ ಕೂಟನು ಕಾಂಟ್ಯಾಕ್ಟ್ ಅದನ್ ಸರ್. ಅವ್ರು ಬರಾಕ್ ಹೋಗ್ಬೇಡ್ರಿ ನಮ್ ಮನಿಗೆ, ಹಾಸ್ಪಿಟ್ಲಿಗೆ ಬಂದಪ್ಪ ಅಂತಂದ್ರ ನಮ್ಮವ್ವ ನಿಮ್ ಕೂಟ ಜಗಳ ಮಾಡ್ತಾಳ, ನಿಮ್ಮಿಂದ ಜಗಳ ಆಗದ್ ಸರಿ ಇಲ್ಲ ಅಂತ ಅವ್ರ ಅಣ್ಣಾರ ಅವ್ರ ಅತ್ತಿಗೆ ಮರ ಅದ್ರ ಸರ್.
ನಾಳೆ ನಿಮ್ ಇಬ್ಬರು ಜಗಳದಲ್ಲಿ ಆ ಕೂಸಿಗೆ ತೊಂದರೆ ಆಗ್ತದೆ ಮತ್ತೆ ಅಲ್ವಾ? ಸುಮ್ನದು ಸ್ವರ್ಗದಲ್ಲಿ ಇತ್ತು, ಅದ್ನ ನಿಮ್ ಬೇಕಾಗಿ ಇಲ್ಲಿ ಕರ್ಸ್ಕೊಂಡ್ ಮೇಲೆ ಸರಿಯಾಗಿ ನೋಡ್ಕೋಬೇಕು.
ಎಲ್ಲಾ ಚೆನ್ನಾಗೈತ್ಲಿ ರೀ, ಎಲ್ಲಾದ್ರು ಚೆನ್ನಾಗೈತ್ಲಿ. ನನ್ ಕೂಟ ಎಲ್ಲಾದ್ರು ಇದ್ ಮಾಡಿದ್ಲ. ಅವ್ರವ್ರ ಮನಿಗ್ ಬಂದ್ ಬಾಡಿಗೆ ಮನಿ ಮಾಡದಾಗ ಬಂದ್ ಮಗಳನ್ನ ಸಹಿತ ಕರ್ಕೊಂಡ್ ಹೋಗ್ಬಿಟ್ರಿ.
ಅವ್ರಿಗೆ ಏನ್ ಉಪಯೋಗ ಮಗಳು ಕರ್ಕೊಂಡು ಹೋಗುದು?
ಅವ್ರಿಗೆ ಅದಾರಿ ಉಪಯೋಗ ಇರೋದು. ಅಂದ್ರ ಅವ್ರ ಅಪ್ಪಾರು ಇದಕ್ ಬಿದ್ದಾರಿ, ಅಂದ್ರ ಮನ್ಯಾಗ ಯಾರು ಇಲ್ಲ ಕೆಲ್ಸ
ಮಾಡೋದು. ಹಂಗೆಲ್ಲ ಮಾಡ್ಬೇಡ್ರಿ. ಏನೋ ಒಂದ್ಸರಿ ಗಂಡನ ಮೇಲೆ ಸಿಕ್ಕ ಬೈಬೇಕು, ಬಿಟ್ಟು ಬಿಡ್ಬೇಕು, ಅದನ್ನೇ ಹಿಡ್ಕೊಂಡು.
ಅವ್ರು ಕೈ ಮಾಡಿದ್ರ ಯಾರು?
ಮಗು ಇದೆ, ಸ್ವಲ್ಪ ಅರ್ಥ ಮಾಡ್ಕೊಳಮ್ಮ. ಒಲ್ಲೆ ನೀನು ಗಂಡನ ಮನೆಯಲ್ಲಿ
ಎಷ್ಟಂತ ಟ್ರೈ ಮಾಡ್ಬೇಕ್ರಿ?
ಟೈಮ್ ಕೊಟ್ಟು ನೋಡಿ
ಇನ್ನೊಂದ್ಸರಿ ಟ್ರೈ ಮಾಡಿ.
ಬ್ಯಾಡರಿ.
ಏನೋ ಏನ್ ಆಗತ್ತೆ ನಾವೆಲ್ಲ ವಾಚ್ ಮಾಡ್ತಾ ಇರ್ತೀವಿ ಇಲ್ಲಿ ಕೋರ್ಟ್. ಇನ್ನೇನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ.
ಒಲ್ಲೆ ಅಂತಾರಲ್ಲಪ್ಪ.
ಬಾಳ ಟ್ರೈ ಮಾಡಿ ನನ್ ಮಗುನವ್ರ ಬೇಕಲ್ ಸರ, ನನ್ ಮಗುನವ್ರ ಇದು ಮಾಡ್ರಿ.
ಹೆಣ್ಮಗುನೋ ಗಂಡ್ ಮಗುನೋ?
ಮಗು ಇರೋದ ಕಷ್ಟ ಬಂದಾರಿ, ಇಲ್ಲಾಂದ್ರ ಬರ್ತಿದ್ದಿಲ್ಲ.
ಹೌದ್ ಸರ್,
ಮಗು ಇರೋದ ಕಷ್ಟ ಬಂದಾರಿ, ಹೆಂಡತಿ ಬೇಕು ಅಂತ, ಇಲ್ಲಾಂದ್ರ ಬರ್ತಿದ್ದಿಲ್ಲ ರೀ.
ಇಲ್ಲಿ ಏನೋ ಒಂದ್ಸರಿ ಹೆಂಡತಿ ಮೇಲೆ ಪ್ರೀತಿ ಬರ್ತದೆ, ಆಮೇಲೆ ಮಗುನ್ ಮೇಲೆ ಪ್ರೀತಿ ಬರ್ತದೆ, ಹಿಂಗೆ ಇರ್ತದ ಆಲ್ಟರ್ನೇಟ್.
ಇಷ್ಟೆಲ್ಲ ಆದ್ಮ್ಯಾಗ ಈಗ 1 ಮಂತ್ ಹಿಂದ್ಗಡೆ ಹಾಸ್ಪಿಟ್ಲಿಗೆ ತೋರ್ಸೇನಿಲ್ಲ ಕೇಳ್ರಿ ಸರ್. ಅವಳ ಕಡೆಯಿಂದನೇ ಕೇಳ್ರಿ ಸರ್. ನಾ ಹಾಸ್ಪಿಟ್ಲಿಗೆ ಬಂದೇನೇ ಇಲ್ಲ ಅಂತ ಕೇಳ್ರಿ. ಮನ್ ಬಂದೇನಿ ಸರ್. ಕೇಳ್ರಿ ಬೇಕಾದ್ರೆ ಸರ್. ಪಂಡಿತ್ ಹಾಸ್ಪಿಟ್ಲ್ ಕರ್ಕೊಂಡು ಕೇಳ್ರಿ ಸರ್. ಮಗಗ್ರಿ
ಸಾಮಾನ್ಯ ಅಷ್ಟೇ ರೀ. ಪ್ರೆಗ್ನೆಂಟ್ ಇದ್ದಾಗ ಒಂದ್ ಸ್ವಲ್ಪ ಹೊಳ್ಳಿ ನೋಡಿಲ್ರಿ. ಅವ್ರ ಶೋರೂಮ್ ಮುಂದ ಹೋದ್ರೂನು ರೀ, ಹುಟ್ಟೋವರೆಗೂ ಅಷ್ಟೇ. ನನ್ ಮಗು ಹುಟ್ಟಿದ ಮೇಲೆ ಅವ್ರ ಮಗು ಅಂದ್ರೆ ಹೆಂಗ್ರಿ?
ಅಲ್ಲ, ನಾವು ಇಲ್ಲಿ ಕೇಸ್ ಇಡ್ತೇವೆ, ಕ್ಲೋಸ್ ಮಾಡಲ್ಲ. 1 ವಾರ ಜೊತೆ ಹೋಗಿ ಬರ್ತೀರಿ.
ಇಲ್ರಿ, ನಾನು ಹೋಗಲ್ರಿ.
ಹಂಗ್ ಮಾಡ್ಯಾರ.
ಭೀಷ್ಮ ಪ್ರತಿಜ್ಞೆ ಮಾಡ್ದಂಗೆ
ನಾವು ವಾಚ್ ಮಾಡ್ತೇವೆ ಅವ್ರ ಮೇಲೆ ಎಲ್ಲ. ಪೊಲೀಸ್ ಕಳಿಸ್ತೇವೆ. ಪೊಲೀಸರು
ಅವಾಗಷ್ಟೇ ಚಲೋ ಇರ್ತಾರ್ರಿ ಅವ್ರು.
ಹಂಗಲ್ಲ, ಅವ್ನ ಮ್ಯಾಗ ಮತ್ತೆ ವಾಚ್ ಇಡ್ತೇವೆ. ಪೊಲೀಸರು ಅದೇ ನಿಮ್ಗೆ ಹೇಳಿ ಬರಲ್ಲ, ಅವ್ರು ನಮ್ಗೆ ಹೇಳಲ್ದ ಬರ್ತಾರೆ. ನೋಡ್ದು ವಾಚ್ ಮಾಡ್ತಿರ್ತಾರೆ.
ಮತ್ತ ಹಂಗಾರ ಮಗುನ್ ಕೊಡ್ಬೇಕಾಗ್ತದೆ. ಸ್ವಲ್ಪ ರಜಾ ಬಂದಾಗ ಮಗುನ್ ಜೊತೆ
ಅವ್ರಲ್ಲಿ ತಿರ್ಗಾ ನೋಡಂಗಿಲ್ರಿ. ಅವ್ರ ಕೋರ್ಟಿಗೆ ಬಂದ್ರು ನನ್ ಮಗ ಹೆಂಗದಾನ ಅಂತ ನೋಡಂಗಿಲ್ರಿ ಅವ್ರು.
ಮಗ ಎಲ್ಲಿದೆ ಈಗ? ಮಗು ಎಲ್ಲಿದೆ?
ಇಲ್ಲೇ ಅದಾನ್ರಿ,
ಒಂದ್ ರೌಂಡ್ ಮಗುನ್ ಕರ್ಕೊಂಡು ಇಬ್ರು ಒಂದ್ ರೌಂಡ್ ಹೋಗೋರಿ. ನಾವು ಇನ್ನೊಂದ್ ತಾಸು ಇರ್ತೇವಿ, ಜಸ್ಟ್ ಒಂದ್ ರೌಂಡ್ ಹೋಗಿ ಬರ್ರಿ. ಹಂಗೆಲ್ಲ ಮಾಡ್ಬಾರ್ದು. ಅದು ಸಿಟ್ನಲ್ಲಿ ಇದೆಯೇನೋ, ಹೊಡೆದಾನ ಮಾಡ್ಯಾನ ಅನ್ನೋದು ಸಿಟ್ನಲ್ಲಿ ಇದೆಯಾ? ಏನೋ ಒಂದ್ಸರಿ ಕ್ಷಮ ಮಾಡ್ಬಿಡು ಗಂಡನ.
ಇಲ್ರಿಪ್ಪ, ಸಾಕಾಗೈತ್ರಿ ನನ್ಗ ಅವ್ರ ಜೊತೆಗೆ ಇದ್ದಿದ್ದು.
ಈ ಒಂದ್ ರೌಂಡ್ ಯಾಕೆ ಹೋಗ್ರಿ,
ಮಲ್ಕೊಂಡನ್ರಿ.
ರೌಂಡ್ ಹೋಗಿ ಬರ್ರಿ. ಮಗುನ್ ಜೊತೆ ಹೋಗ್ಬೇಕು ಇಬ್ರು.
ಮಲ್ಕೊಂಡನ್ರಿ.
ಎಬ್ಬಸ್ ಏನಾಗತ್ತೆ? ಏನ್ ಮಕ್ಕಳಿಗೆ ನಿದ್ದಿಗಳಿಗೆ ಯಾಕೆ ಮಲಗಿಸಿ?
ಮೇಡಮ್ ಚೇತನ, you ensure that, let him also have interaction with the child. Please, please, sometime,
Sorry.
1 hour, please.
The only thing is that
ಏನೋ
your
substitute
lordship, she
ಬಂದಂಗಿದೆ
is
ಅವ್ರಿಗೆ.
scared that he may also
Madam,
ask
madam.
her to.
Madam, it is your duty now, convince.
Please,
ಓಯ್,
please.
Insert.
ಮಾತಾಡಿ.
Please,
ಮಗು ಇದೆ.
come back.
ಅಪ್ಪೇನ ಈ ಹೊಡೆದು ಬಡದು ಮಾಡಿದ್ದಕ್ಕೆ ಇಷ್ಟು ಸಮಸ್ಯೆ ಆಗಿದೆ ನೀನ್ ಅಂತ ದಡ್ಡ
ದೇವರಳ್ಳಿ
ನೀನು.
ಸರ್ ಹೊಡೆದಿಲ್ಲ ಸರ್, ನಾನು ಕೇಳ್ಬೇಕು ಇಲ್ಲ ನಾನು ಕೈ ಮಾಡಿಲ್ಲ. ದೇವರಳ್ಳಿ ಕೈ
ಹಂಗ್
ಮಾಡಿಲ್ಲ
ಮಾಡ್ತಾರೆ
ಸರ್,
ಹೆಣ್ಮಕ್ಳು
ಮಾಡಿಲ್ಲ
ಯಾರಾದ್ರು?
ಸರ್ ನಾನು. ನನ್ನ ಮಗನ ಮ್ಯಾಗ ಆಣಿ ಮಾಡಿರ್ತೀನಿ, ಧರ್ಮಸ್ಥಳ ಮಂಜುನ
ಏ
ಮ್ಯಾಗ ಆಣಿ
ಮನೆಯ
ಮಾಡಿರ್ತೀನಿ.
ಮಕ್ಕಳ ಮೇಲೆ ಮಾತ್ರ ರಾಣಿ ಮಾಡ್ಬೇಡ್ರಿ
ಇಲ್ಲ ಸರ್,
ಯಾರು.
ನಾವು ಹೊಡೆದಿಲ್ಲ ಸರ್.
ಅದನ್ನೊಂದು ಅಲೋ ಮಾಡಲ್ಲ.
ಸರ್
ಮಕ್ಕಳ ಮೇಲೆ ಮತ್ತೆ ನಮ್ಮ ಮೇಲೂ ಮಾಡ್ಬೇಡ್ರಿ.
ನಮ್ಮ ಅಪ್ಪಾಜಿ ಮ್ಯಾಗ ಆಣಿ ಮಾಡಿರ್ತೀನಿ ಸರ್, ನಾ ಒಟ್ಟ ಹೊಡೆದಿಲ್ಲ ಸರ್, ದೇವರಾಣಿ ಹೊಡೆದಿಲ್ಲ ಸರ್.
ನೋಡ್ದಂಗೆ ಹಿಂಗೆ ಹೇಳ್ತಾಳ ಹೆಣ್ಮಗಳು.
ಇಲ್ಲ ಸರ್, ನಾವು ಹೊಡೆದಿಲ್ಲ. ನಂಬ್ರಿ
ನೋಡಿ ಸ್ವಲ್ಪ ಹೊಡೆದು ಗಿಡದು ಮಾಡಂಗ್ ಇದೀಯಾ ನೀನು?
ಇಲ್ಲ ಸರ್.
ಹೋಗು, ಮಗುನ್ ಕರ್ಕೊಂಡು ಹೋಗಿ ಒಂದ್ ರೌಂಡ್ ಹೋಗ್ರಿ ಇಬ್ರು. ಹೋಗ್ರಿ ಹೋಗಿ, ನೀನು ಹೋಗಮ್ಮ. ಹೋಗ್ರಿ ಮೇಡಮ್,
Madam, ಸ್ವಲ್ಪ ensure ಮಾಡಿ, please.
ನೀವು ಹೋಗ್ರಿ. ಜೊತೆಗೆ ಇಬ್ಬರಿಗೂ ಸ್ವಲ್ಪ ಅಡ್ವೈಸ್ ಮಾಡಿ
thing is, your lordship,
ಮಾಡ್ಬೇಕು. ಇವನ್ನೆಲ್ಲ
The only
ತುಂಬಾ
thing she is
argument
scared
ಮಾಡೋದಲ್ಲ
about
ಇದು.
You come back and tell them, please. Go with them.
ಅಡ್ಡೆಡ್ ಸ್ವಲ್ಪ ಏನೋ ಸ್ವೀಟ್ ಗೀಟಿ ಅಂದ್ರೆ ಕೊಡಿಸಿ ಕಳಿಸ್ರಿ, ಸರಿ ಆಗ್ತಾರೆ. ಹೊಸವ್ರು ಮಾಡಿ ಹೊಡೆದಾನವನು ಅದಕ್ಕೆ ಹಂಗೆ ಮಾಡ್ತಾಳು. ಹುಡುಗ ಹೊಡೆದಾನು ಇಲ್ಲಪ್ಪ, ನಾ ಹೆಣ್ಮಗ್ಳು ಯಾಕೆ ಹಂಗೆ ಮಾಡ್ತದೆ ಪಾಪ.
Paying for the respond number 1.
ಹಾ, ಎಲ್ಲಿ ನಿಮ್ ಫ್ರೆಂಡ್?
ಬರಲ್ವಾ?
ಇಲ್ಲ 2017 ಮ್ಯಾಟರ್, 2017 ಕೇಸ್ ಕರೆದಾಗ ಬರಲ್ಲ.
ಬೆಳಿಗ್ಗೆನೂ ಇರ್ಲಿಲ್ಲ ಅದು. ಏನ್ ಮಾಡೋದು?
ಏನ್ ನಾವ್ ಹೆಂಗ್ ಕೆಲಸ ಮಾಡೋದು ಹೆಂಗೆ? 2017 ಇದೇನು ಡೆತ್ ಆಗಿದೆಯಾ?
No, my lord, injury, case of injury. My lord,
ನೋಡಿ ನಾವು ಹೆಂಗೆ ಅದಕ್ಕೆ ನಮ್ಮ ಮಾನ್ಯ ರಾಷ್ಟ್ರಾಧ್ಯಕ್ಷರು ಹೇಳಿದ್ದು, ಬರೀ ಅಜರ್ಮೆಂಟ್ ಕೊಟ್ಕೋತ ಹೊರಟಿರಿ ನೀವು, ಹಂಗ್ ಮಾಡಬಾರ್ದು, ಇಂಜಸ್ಟಿಸ್ ಆಗ್ತದೆ ಕ್ಲೈಂಟ್ಸ್ ಲಿಟಿಗಂಟ್ಸ್ಗೆ ಅಂತ. ಅದ್ರ ನೀವಿಲ್ದಂಗ್ ನಡ್ಸಕ್ ಬರಲ್ಲ, ಕಾನೂನಲ್ಲಿ ಅಲೋ ಇಲ್ಲ. ನೀವಿಲ್ದಂಗ್ ನಡ್ಸಕ್ ಬರ್ತದೆ, ಇವ್ರ ಇಲ್ದಂಗ್ ನಡ್ಸಕ್ ಬರಲ್ಲ ನಮ್ಗೆ.
There is no representation for the appellant. It's the last chance. At least 1 ವಾರ ಬರಲ್ಲ ಅಂದ್ರೆ ಅದು ಬರ್ದಾಗ.
ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆರ್ಡರ್
Yes, yes, I have secured it.
ಏನಂತ ಹೇಳ್ತಾರ ಅವರು?
It is more in the format of the general issued to their employees when he was appointed as an assistant. Pay scale, pay scale ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳಿ ಹೇಳ್ತಾರೆ. Doesn't speak about pay protection.
ಪೇ ಪ್ರೊಟೆಕ್ಷನ್ ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳಿಲ್ಲ. ಅದ್ರ ಬಗ್ಗೆ ಇಲ್ಲ.
ಇಲ್ಲ. It says, my lord, you are appointed in this scale ಅಂತ ಹೇಳಿ. I'm sorry, my lord, the copy issued is little bit. Second point, my lord.
On a monthly basic salary of rupees so and so.
Yes, yes.
In the scale of so and so.
Yes.
Plus such other allowances as may be admissible under the rules in force from time to time.
So, what this annexure B, which is the personal manual, it is the rule book for the insurance companies. I'll clarify only one thing, my lords. Adrinda I am.
ಅಲ್ಲ, ಇನ್ನೊಂದ್ ಸರಿ ಸೆಂಟೆನ್ಸ್ ಇನ್ನೊಂದ್ ಸರಿ ಹೇಳಿ. Annexure B ಅಂತ.
Annexure B is the personal manual, which my lord is the rule book for the insurance companies. Page number 42, if my lords are taking the contempt petition.
ಇಲ್ಲಿ ಅಪೀಲ್ ನಲ್ಲಿ ಇಲ್ಲ ಅನ್ನೋದು.
ಅದು ಅವ್ರ ಕಾಪಿ ನನ್ನ ಹತ್ರ ಇಲ್ಲ, ನನ್ನ ಕಾಪಿ ಅವ್ರ ಹತ್ರ ಇಲ್ಲ. I'm sorry. ನಂದ್ರಲ್ಲಿ ಮಾರ್ಕ್ ಮಾಡಿದ್ದೇನೆ. It is easy for me to refer. I'll just only in one sentence, sir. I'll clarify. What my learned senior friend has argued is all regarding pay. Pay is only one component from what has to be given to me as the pay protection. Only 3.1, my lords may kindly see. 3.2.
Page number
42. My lords have
pay fixation.
Yes.
On re-employment.
Yes, I'll read it once again for the purpose of this thing. Basic salary of re-employed ex-serviceman shall be fitted at the minimum of scale in which he is appointed.
Correct.
However, if the gross salary as per Y below at the minimum of scale does not produce an amount equal to or more than the last round's gross salary as per
Additional
X.
increments ಕೊಡಬೇಕಾಗ್ತದೆ. Equalize ಮಾಡಕ್ಕಾಗ್ತದೆ.
One more I'll add, my lord. My lords may kindly see X. What it includes is A. A is pay. 3.2 ಅಲ್ಲಿ X ಕೆಳಗಡೆ A ಅಂತಿದೆ.
3.2 ದಲ್ಲಿ
3.2 ದಲ್ಲಿ X is the last round gross salary in defense services.
Pay As
defined in paragraph 3(9) of the Department of Personnel and Training OM dated so and so. That is the annexure A ಒಳಗಡೆ what is pay ಅಂತ ಹೇಳಿ define ಮಾಡ್ತಾರೆ.
ಅದೆಲ್ಲ include
ಅದನ್ನ subsequently ಇವ್ರು as per that 7/2/2014 circular ಪ್ರಕಾರ what is pay ಅಂತ define ಮಾಡಿದ್ರು. That is only one component which has to be paid to me. Now what they say is that is the only component we are going to pay to you. That cannot be admissible. There are up to G ವರೆಗೂ ಇದೆ. There are other components which have to be considered. Allowance may kindly see there. Dearness allowance, additional dearness allowance, interim relief, city compensatory
A
allowance.
to G.
Yes, A to G. Adana they have to transform it into Y below. Only for one month, Y also may kindly be seen. Y gross salary in our industry shall be aggregate of the following. Basic salary in the scale in which ex-serviceman is re-employed, dearness allowance, house rent allowance, city compensatory allowance.
ಇಷ್ಟನ್ನು ಕೊಟ್ರೆ ಅದು ಸ್ಯಾಲರಿ ಆಗ್ತದೆ.
ಅವ್ರು ಏನ್ ಹೇಳ್ತಾ ಇದ್ರು ಪೇ ಗ್ರೇಡ್ ಪೇ ಬ್ಯಾಂಡ್ ಪೇ ಇನ್ ಬ್ಯಾಂಡ್ ಏನ್ ಹೇಳ್ತಾರೆ ದಟ್ ಈಸ್ ಓನ್ಲಿ ಒನ್ ಕಾಂಪೊನೆಂಟ್ ಆಫ್ ದಿ ಎಂಟೈರ್ ಥಿಂಗ್ ದಟ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಪೇ ಟು ಮಿ ಪೇ. ಅವ್ರು ಅದು ಬೇರೆದನ್ನ ಕನ್ಸಿಡರ್ ಮಾಡ್ತಾ ಇಲ್ಲ. ಅದಕ್ಕೆ ಮೈ ಲಾರ್ಡ್ಸ್ ಇಫ್ ಮೈ ಲಾರ್ಡ್ಸ್ ಪರ್ಮಿಟ್ ಐ ಹ್ಯಾವ್ ಆಲ್ಸೋ ಮೇಡ್ ಒನ್ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ವಿಚ್ ಅಕಾರ್ಡಿಂಗ್ ಟು ಮಿ ಮೈ ಲಾರ್ಡ್ ಸೂಟ್ಸ್ ದಿಸ್ ಪರ್ಸನಲ್ ಮ್ಯಾನುವಲ್ ದಿಸ್ ಥಿಂಗ್. ಐ ಹ್ಯಾವ್ ಸರ್ಡ್ ಎ ಕಾಪಿ ಆಫ್
ಇನ್ ಬ್ಯಾಂಡ್ ಗ್ರೇಡ್ ಪೇ DA ಮೂರನ್ನಷ್ಟೇ ಇಟ್ಕೋತಾ ಇದ್ದಾರೆ.
If the counter affidavit is seen they take only that thing. So my lords may kindly see my last drawn salary at page number 77.
ಅಲ್ಲಿ ಒಂದು there was a some kind of agreement between army officers association on the one side and the defense department, the secretariat of the central government on the other. ಅಲ್ಲಿ ಕೆಲವು assurances ಕೊಟ್ಟಾರೆ ಅದು ತಗೊಂಬನ್ನಿ. ಆ ಅಶ್ಯೂರೆನ್ಸ್ ಗೆ ಕಾಂಟ್ರರಿ ಆಗಿ ಇಶ್ಯೂ ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ. ಅಲ್ಲೇನಿದೆ ಅಶ್ಯೂರೆನ್ಸ್ ಅಂದ್ರೆ ಟು ಮೈ ವೇಗ್ ಮೆಮರಿ ಇಟ್ ಕೆನಾಟ್ ಬಿ ಲೆಸ್ ದ್ಯಾನ್ ಇನ್ ಎನಿ ಇವೆಂಟ್.
The protection.
I spoke to concerned person also to know what is the legal position. I did not tell this case, that case, but I discussed with person who that Colonel Neelendra Singh ankondu gottirbeku. He has written so many books on your defense services. I spoke to him. So he says there is an understanding, I am using his word, there is an understanding between center and the association of defense people, where the defense man after retirement or discharge, if re-employed in defense one thing, even there it cannot be less. In other than defense is another, even there it cannot be less than that. It not come bani.
PSUs.
Ashte case. We have understood. ಏನು ಆರ್ಗ್ಯೂ ಮಾಡಬಾರ್ದು, ಅದು ನೋಡ್ಕೊಂಬಂದು ಹೇಳ್ಬೇಕು ಅಷ್ಟೇ.
In the annexure E, my lord, because of this is a confusion, in order to resolve the confusion, my lord, annexure E, my lord.
ಅಲ್ಲ, ಈ ಪಾಲಿಸಿ, suppose if there is such a policy arrangement between the center and the ex-defense people, that binds you. ಅದಕ್ಕೆ ನೋಡ್ಕೊಂಬಂದು.
In fact, this annexure B is the result of that policy understanding only. That's why they say you have to match it in this manner ಅಂತ.
ಹೋಗಿ
ಅದನ್ನು ನೋಡ್ಕೊಂಬನ್ನಿ. ಅದನ್ನು
ನೋಡ್ಕೊಂಬನ್ನಿ. ನೋಡಿ, ಅವತ್ತು ನಾಡ್ದು ಸೋಮವಾರ ಮತ್ತೆ ನಿಮ್ ಕೈಯಿಂದ ಸಿಟ್ಟಿಂಗ್ ಮಾಡಿಸ್ಬೇಕು ನಾವು ಅಷ್ಟೇ.
ಅಲ್ಲ ಸಾರಿ, ಇಲ್ಲ ಇದೇ ವಾರ
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ನಲ್ಲಿ ಯಾವ ತರ
13th my lords may have it. 12th or 13th.
ಅಲ್ಲ, even I had to get some clarification from HOHO Kolkata regarding this one.
Then 17th
ಹಾಕೋಣ.
Yes,
18th my lord, 18th. ಯಾಕಂದ್ರೆ ಅದು 16th 17th again there will be confusion.
May I place this on record? One small calculation I have made. ಅಂದ್ರೆ reply to the counter affidavit ಅಂತ ಮಾಡಿದ್ದೀನಿ.
Counter affidavit ಏನು ಬೇಡ, don't know the issue.
It is my calculation ಅಷ್ಟೇ. Please.
ಅವ್ರಿಗೆ ಒಂದು ಕಾಪಿ ಕೊಡಿ.
ಕೊಟ್ಟಿದ್ದಾರೆ. I already served. Oblige.
ಗೈಡ್ಲೈನ್ಸ್ ಎಷ್ಟಿದೆ? ಅದು 2,500 ಲಕ್ಷ ಫಾರ್ ಇರಿಗೇಟೆಡ್ ಲ್ಯಾಂಡ್ ಫಾರ್ ದ ಇಯರ್ 9-10. ಅದು 2,54,000 ಕೊಟ್ಟಿದ್ದಾರೆ ಅವರು ರೆಫರೆನ್ಸ್ ಕೋರ್ಟ್.
ಬಟ್ ಬರೀ ಮಾರ್ಕೆಟ್ ನಲ್ಲಿ we cannot keep our common sense in cold storage.
Yes.
ಯಾವ ವ್ಯವಹಾರ ಅದ್ರ ಪ್ರಕಾರ ಆಗ್ತದೆ, ಗೈಡ್ಲೈನ್ ವ್ಯಾಲ್ಯೂ ಪ್ರಕಾರ. There are judgments in fact. There are judgments on, in fact no transaction takes place based upon these guideline values ಅಂತ judgments ಇದಾವೆ. ಒಂದು ಫಿಗರ್ ಹೇಳ್ರಿ.
Even there is a judgment, my lord, at the
ಮತ್ತು ಅದ್ನ ಪ್ರಕಾರ ಗೈಡ್ಲೈನ್ ವ್ಯಾಲ್ಯೂ ಮೆನ್ಷನ್ ಮಾಡಿರಿ ನೀವು.
ಇದೆ, ಇದೆ.
Is of 2013.
2013-14, my lord.
Now,
As per this-
therefore,
ಅಂದ್ರೆ
if that becomes the
irrigated
yardstick.
lands ಗೆ ಇದಿಷ್ಟು ಇದು
Guideline,
dry lands.
now which year is, relevant year is 2009.
At 2009, my lord, as per the Supreme Court judgment, that guidelines values has to be considered only for the collecting the stamp duty, that cannot be considered for the determination of land
ಯಾವುದು?
and acquisition.
ಬಿಡಿ. Exactly contrary judgment ಓದ್ದೆ ನಾನು.
In the paragraph number 9 and 12, my lord.
Paragraph number?
Paragraph number 9, my lord. 9 and 12.
Para 9. ಯಾವುದು?
4,50,000 ತೋರಿಸ್ತಾ ಇದೆ.
ಅಲ್ಲ ಇದು ಇಲ್ಲಿ ಈ ಕಡೆ ಲಾಸ್ಟಿಗೆ ತೆರೆ ಅಂತ ಇದೆ. ಅಲ್ಲಿ 2,60,000. ಇಫ್ ಇಟ್ ಈಸ್ ಫುಲ್ಲಿ ಇರಿಗೇಟೆಡ್ ಲ್ಯಾಂಡ್ ಅಂದ್ರೆ 2,60,000 ಅಂತ ಮಾಡಿ.
4,50,000 ಎದಕ್ಕದ? ಖುಷ್ಕಿ. ಡ್ರೈ ಲ್ಯಾಂಡಿಗೆ
ಅದು
ಖುಷ್ಕಿ.
ಖುಷ್ಕಿ ಡ್ರೈ ಲ್ಯಾಂಡ್.
ಖುಷ್ಕಿಗೆ ಜಾಸ್ತಿ ಇದ್ದು ಇರಿಗೇಷನ್ ಕಡಿಮೆ ಇರ್ತದ ಅವ್ರು.
ಅಲ್ಲ ಭಾಗ ಏನಿದೆ?
ಅಲ್ಲ
ಭಾಗ ಇತ್ತಂದ್ರೆ ಗಾರ್ಡನ್
ಬಾವಿ ಹಳ್ಳ.
ಇರಿಗೇಟೆಡ್ ಲ್ಯಾಂಡ್.
ಅದು 45,000. 45,000. ಡ್ರೈ ಲ್ಯಾಂಡ್ 45,000. ಇಟ್ ಇಸ್ ನಾಟ್ 4 lakhs.
ಇಷ್ಟು ಕಡಿಮೆ ಇದೆ.
ಹೌದು.
ಅದು ಮ್ಯಾಕ್ಸಿಮಮ್
ಮ್ಯಾಕ್ಸಿಮಮ್ ಇಸ್ 50.
ಭಾಗ
6 ಹೌದು.
1,40,000.
ಹೌದು. ಸೊ ಫಾರ್ ಇರಿಗೇಟೆಡ್ 2,60,000 ಅಂತ ಇದೆ.
What is the evidence? No evidence only.
Lord, that exhibit fee 21, that consent award, my lord, even today we are ready for that consent award amount.
ಕನ್ಸೆಂಟ್ ಅವಾರ್ಡ್ ನಲ್ಲಿ ನೀವು ಕನ್ಸೆಂಟ್ ಕೊಡ್ಬೇಕಿತ್ತು ಹಂಗಿದ್ರೆ.
my lord.
ಕೊಟ್ಟಿಲ್ಲ ಅನ್ನೋದಕ್ಕೆ ಅವ್ರಿಗೆ ಕನ್ಸೆಂಟ್ ಕೊಟ್ಟ ನಿಮ್ ಕೊಟ್ಟಿಲ್ಲ.
It is for the purpose of the railway, it is some other acquisition, not this.
ಕನ್ಸೆಂಟ್ ಅವಾರ್ಡ್ ಇದ್ದಾಗ ಕನ್ಸೆಂಟ್ ಅವಾರ್ಡ್ ಅನ್ನು ಬೇಸ್ ಮಾಡಿ ಇಟ್ಕೊಳ್ಳಿಕ್ಕೆ ಬರಲ್ಲ ಅಂತ ಬೇಕಾದಷ್ಟು ಜಡ್ಜ್ಮೆಂಟ್ಸ್ ಇದೆ.
ಇದು acquisition ಅಲ್ಲ ಇದು. ಬೇರೆ acquisition railway.
ರೈಲ್ವೇಸ್ ದಟ್ಸ್ ವಾಟ್ 254
ಇಲ್ಲ 450. 250
254 7,350 ನಾವು ಮಾಡಿದಾರೆ.
2,50,000. 54,000. ಮತ್ತೆ ಯಾವ ಬೇಸಿಸ್ ಲಿ ಮಾಡಿದ್ದಾರೆ?
ಆ ರೀತಿ ಅಲ್ಲ ಅದು ಮೀನಿಂಗ್.
Please,
Para 12
in the paragraph number 9 and 12.
That's all right. But generally that's one of the, yardsticks operated by all other statutes also. Other statutes also operate on guideline value. ಆ ಅರ್ಥದಲ್ಲಿ ತಗೋಬೇಕಿತ್ತ. ಹಿಂಗ ಆ ರೀತಿ ಗಾಸ್ಪೆಲ್ ಟ್ರೂತ್ ಅಂತ ಹಂಗಲ್ಲ ಹೇಳಿದ್ದು. ನಾಟ್ ಎಸ್ ಎ ಥಂಬ್ ರೂಲ್. ಆರ್ಡಿನರ್ಲಿ ಇಟ್ ಇಸ್ ಮೆಂಟ್ ಫಾರ್ ಕಲೆಕ್ಟಿಂಗ್ ಸ್ಟಾಂಪ್ ಡ್ಯೂಟಿ ಅಂತ.
ಇಲ್ಲ 29 ಲಕ್ಷ ಮಾಡಿದ್ದಾರೆ.
ನಂಬರ್ 3
ಅವನ್ನೆಲ್ಲ ತಗೊಂಡು ಬರೋದೇ ಅದೆಲ್ಲ ಫೀಟ್ನಾಗಿದೆ. ನೀವು ಕಂಪೇರೇಬಲ್ ಸ್ಟ್ಯಾಟಿಸ್ಟಿಕ್ಸ್ ದೇ ಆರ್ ಇನ್ ಫೀಟ್.
It is in the square feet, my lord, even though, and there is no other scale statistics are available, that time that a bit appropriate,
ವ್ಯಾಲ್ಯೂ ಇದೆ.
that appropriate deduction to be deducted, my lord.
2,60,000. ಅಲ್ಲ ತೆರೆ ಅಂತ ಇದೆ ಅಲ್ಲ, 2 ಕಾಲಮ್ ಮಾಡಿದ್ದಾರೆ. ಲಾಸ್ಟ್ ಕಾಲಮ್ ನಂಬರ್ 6.
ಭಾಗ ಆಯ್ತಂದ್ರೆ
ಭಾಗ ಇದಕ್ಕಿಂತ ಪೂರ್ವ ಹೌದು, ತೆರೆ.
It is a 2,80,000.
ಗಾರ್ಡನ್ ಲ್ಯಾಂಡ್, ಇರಿಗೇಟೆಡ್ ಲ್ಯಾಂಡ್.
ಅದೇ ಸೀರಿಯಲ್ ನಂಬರ್ 3 ಇಲ್ಲಿ ಲಾಸ್ಟಿಗೆ ತೆರೆ ಮತ್ತು ಅಲ್ಪ ತೆರೆ ಮತ್ತು ಪೂರ್ತಿ ತೆರೆ ಅಂತ ಇದೆ.
ಅಲ್ಪ ತೆರೆ ಅದು 1 ಲಕ್ಷ ಇದೆ.
ಅಲ್ಲಿ ನೆಕ್ಸ್ಟ್ ಫುಲ್ ಇಫ್ ಇಟ್ ಇಸ್ ಫುಲ್ಲಿ ಇರಿಗೇಟೆಡ್ ದೆನ್ 2,60,000.
1,60,000 ಇದೆ.
ಇನ್ ಬೆನ್ನೂರು 1,60,000.
ಇವರು ವಿಲೇಜ್
ಬೆನ್ನೂರು ಇದೆ 1,00,000.
Kannur village.
1,60,000 ಅಲ್ಲ?
ಹೌದು 1,00,000.
ಮ್ಯಾಕ್ಸಿಮಮ್ 160.
ಹೌದು.
ಅದೆಲ್ಲ ಸೇರಿಬಿಟ್ಟು ಭಾಗ ಆಯ್ತದ ಲಾಸ್ಟ್ ಆಗಿದ್ರೆ ನೋಡಿ 140.
It is 1,40,000.
ಕೊಟ್ಟದ ಹೈಯರ್ ಆಯ್ತಲ್ಲ ಮತ್ತೆ.
To consider that at the consent award, my lord, in all 19 villages, they have fixed that amount.
ನೀವು ಕನ್ಸೆಂಟ್ ಕೊಡ್ಬೇಕಿತ್ತು.
ಬೇರೆ ಅಕ್ವಿಸಿಷನ್ ಅದು ಏನು ಇದಕ್ಕೆ ಸಂಬಂಧ ಇಲ್ಲ.
My lord, even today also we are not claiming any interest and any statutory benefits on that amount.
That is in foot unit.
Please.
ಫುಟ್ ಯೂನಿಟ್ ನೇ ಮಾಡ್ಯಾರ. ಯಾಕಂದ್ರೆ ಕನ್ವರ್ಟೆಡ್ ಇದೆ, ಲೇಔಟ್ ಏನೋ ಆಗಿರ್ತದೆ, ಈರೆಲ್ಲ ಇರುತ್ತೆ. ಇದು ಏಕರೇಸ್ನಾಗಿದೆ ಇದು.
Oh, my lord, in that award also there are all are agriculture land and Kushki lands.
They are consent awards. Had you given consent, same benefit you would have got, but
Yes.
you did not give. Therefore,
Yes.
somebody has given that benefit, you give me, that may not be the legal argument. ಹಂಗೊಂಡು ಮಾಡ್ಯಾರ ಜಸ್ಟಿಸ್ ಸಪ್ರೆ ಸಾಹೇಬ್ರ ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ.
There is a judgment, my lord.
3 lakhs ಮಾಡೋಣ.
Please.
Okay.
I'm sorry, my lord.
Ah.
In figure 9, in the writ appeal notice may be ordered.
Respond number 1, I may be directed to take notice.
Shri Dharwad accepts notice
Respond number 1.
for response number 1.
2 to 4, my lords, the central government advocate.
ಕನ್ವಿ ಯಾರು ಇವರಿದ್ರಲ್ಲ ವೆಂಕಟೇಶ್ ಇದ್ದಾರೆ.
Venkatesh Karve.
Venkatesh Karve, Mr. Venkatesh Karve.
ಅಪೇರ್ ಆಗಿದ್ರಲ್ಲಿ.
Writ petition ನಲ್ಲಿ my lord, Mr. Kanvi appeared.
ಅವ್ರ ಹೆಸರು ನೋಡಿ.
ಅಲ್ಲಿ ನೋಡಿ ಯಾರು ಅಪೇರ್ ಆದಂಗೆ ಇಲ್ಲ ನಾವು
Kanvi ಅವರು appear ಆಗಿದ್ದಾರೆ.
ಆಗಿದಾರ
ಯಾರು ನೋಡಿದೆ ನಾ ಹೆಸರು.
ಹೌದಾ ಅವ್ರ ಹೆಸರು ಹಾಕೊಂಡ್ಬಿಡಿ ಅಷ್ಟೇ.
Mr. Sanjay Kategari appeared, my lords, for 4 to 6.
ಸಂಜಯ್ ಕಟಗೇರಿ 4 and 6. 4 to 6 4 and 6
ಅಲ್ಲ ಇದ್ರ ಒಳಗಡೆ they are 2 to 4.
2 to 4
ಅಲ್ಲಿ 4 to 6 ಇದೆ.
ಸಂಜಯ್ ಕಟಗೇರಿ ಅವ್ರಿಗೆ ಒಂದು ಕಾಪಿ ಕೊಡಿ.
ಕೊಡ್ತೀನಿ. Please.
ಈಗಾಗಲೇ ಅದ್ರ ಮೇಲೆ ರೂಲಿಂಗ್ಸ್ ಇದಾವು, ಅದನ್ನ ಹುಡ್ಕೊಂಡ್ ಬರ್ಬೇಕು. ಆಲ್ರೆಡಿ ದೇರ್ ಆರ್ ರೂಲಿಂಗ್ಸ್, ನಂಗೆ ಅಷ್ಟು ಟೈಮ್ ಇಲ್ಲ ಅನ್ನೋದು ಹುಡ್ಕೋದಾಗ್ಲಿಲ್ಲ.
There are 2 judgments of the Supreme Court.
ತೋಮನಿ
One by Justice Bopan also is there, my lord, today.
Through whom I contacted my client to lordships, my lord, and sincerely advise him to pay my lord some reasonable amount to lordships. Initially, he said, no, 10 lakhs to lordships.
ಇನಿಷಿಯಲಿ ಅದು ಬಿಡಿ, ಲಾಸ್ಟಿಗೆ ಎಷ್ಟು ಹೇಳ್ದ?
15 lakhs, no, he is agreeable. 15 lakhs to lordships.
ಹೆಂಗ್ ಸಾಧ್ಯ?
ಅದಕ್ಕೆ ನಾನು ಹೇಳಿದೆ, ನಿನ್ ಮಕ್ಕಳು ಕೊಡ್ತಾ ಇದ್ದಪ್ಪ, ಬೇರೆ ಮಕ್ಕಳು ಹೆಂಡತಿ ಕೊಡ್ತಾ ಇದ್ದಿ, ಇನ್ನೋರು ಸ್ವಲ್ಪ
ಎರಡು ಮಕ್ಕಳು ನೋಡಿ, ಮಕ್ಕಳ ಮೇಲೆ ನಿಮ್ಗೆ ಸಿಟ್ಟಿಲ್ಲ,
ಹೌದೌದು,
ಮಕ್ಕಳ ಮೇಲೆ ಪ್ರೀತಿನೇ ಇದೆ.
ಅಲ್ಲ ಅದನ್ನ ಅಡ್ವೈಸ್ ಮಾಡಿದ್ದೇನೆ.
ಅದು ಇಲ್ಲ
ಇಲ್ಲ ಮಕ್ಕಳ ಮೇಲೆ ಪ್ರೀತಿ ಇದೆ,
ಕೊಡಿ ಮತ್ತೆ ಪ್ರೀತಿ ಪೊಕಟೆ
ಅದನ್ನೇ ನಾನು advise ಮಾಡಿದೆ.
ತಗೋಬೇಕಾಗ್ತದೆ.
ಅಲ್ಲ ಅದಕ್ಕೆ ಅಡ್ವೈಸ್ ಮಾಡಿ, ಇಲ್ಲ 10 lakhs ಆಗದ, ನೀವು ಮೋರ್ ಯು ಪೇ ಸಮ್ ಮೋರ್ ಅಮೌಂಟ್ ಅಂದೆ. ದೇ ಅಗ್ರಿ 15 lakhs ಒಪ್ಕೊಂಡಿದ್ದಾರೆ ಸ್ವಾಮಿ.
15 ಏನ್ ಬರ್ತದೆ ಈಗ?
In the presence of party president ಹೇಳ್ತೇನೆ, ಅವರು in the presence of party it may be no.
ಎನಿವೆ ಇಂಥ ಕೇಸ್ನಲ್ಲಿಯೂ ನಿಮ್ ಕಾಂಟ್ರಿಬ್ಯೂಷನ್ ಇರುತ್ತೆ.
ಹೌದು ಹೌದು,
ಯಾವ ವೈಫು ಆ ರೀತಿ ಬಿಟ್ಟು ಹೋಗೋದೇ ಇಲ್ಲ. ಅದು ಆ ಕಲ್ಚರ್ ಅಲ್ಲ ನಮ್ಮ ಮಣ್ಣಿಂದು. ನಮ್ಮ ಮಣ್ಣಿನ ಕಲ್ಚರ್ ಬೇರೆ ಇದೆ. ಯಾರು ಎಲ್ಲೋ ಏನೋ ಒಂದು ಮಾಡಿರ್ತೀರಿ ಅನ್ಕೊಂಡು ಅವರು ಬಿಟ್ಟು ಹೋಗಿರ್ತಾರೆ, ಒಂದು ಸ್ವಲ್ಪ ಜಾಸ್ತಿ ಅವರು ಇನ್ನೂ ಸ್ವಲ್ಪ ಇದನ್ನ ಮಾಡಿರ್ತಾರೆ.
ಹೋಗ್ತೀರಾ ನಿಮ್ಮವ್ರು ಮಾತಾಡಿದ್ರ?
ಇಲ್ಲಿ ಮಾತಾಡ್ದೆ ಅವರು, ಇವರು ಡ್ಯೂ ಈಗ 5.5 lakh ಇದೆ. ದೇರ್ ದ ಡ್ಯೂ ದಟ್ ದೇ ಆರ್ ಸಪೋಸ್ ಟು ಪೇ ಮೇಂಟೆನೆನ್ಸ್ ಅದೇ 5.5 ಲಕ್ಷ ಇದೆ. ಆಮೇಲೆ ಆ ಹುಡುಗ ಈಗ ಇಂಜಿನಿಯರಿಂಗ್ ಕಾಲೇಜ್ ಸೀಟ್ ತಗೊಂಡಿದ್ದಾನೆ, ಸೀಟ್ ತಗೊಂಡಿದ್ದಾನೆ.
You have not paid that money also.
According to my it is 2 lakhs and out ಬರ್ತದೆ.
ಆಯ್ತು, ಅದನ್ನ ಕೊಡ್ಬೇಕಾ?
ಮತ್ತೆ ಸ್ಯಾಲರಿ ಡಿಡಕ್ಷನ್ ಆಗ್ತದೆ. Till today it is direct in the salary lordships.
ಎಲ್ಲಿಂದ ಡಿಡಕ್ಷನ್ ಆಗಿದೆಯಾ?
ಆಗ್ತದೆ, ಮತ್ತೆ ಆಗ್ತಾ ಇದೆ.
2019 ಇಂದ ಡಿಡಕ್ಟ್ ಆಗ್ತಿದೆ. ಅದ್ರ ಹಿಂದಿಂದು 5 ವರ್ಷದ್ದು ಅವ್ರು ಕೊಟ್ಟಿಲ್ಲ. ನಂಬರ್ 1. ನಂಬರ್ 2, ಈಗ ಅದು ಡಿಡಕ್ಟ್ ಆಗ್ತಾ ಇದ್ದನ್ನು ಅಲ್ಲಿ ಬಿಒ ಆಫೀಸ್ ಅಲ್ಲಿ ಇನ್ಫ್ಲೂಯೆನ್ಸ್ ಮಾಡಿ ಸ್ಟಾಪ್ ಮಾಡಿಸಿದ್ದಾರೆ.
ಕ್ಲೈಂಟ್ ಅನ್ನ ಇಲ್ಲಿ ಪ್ರೆಸೆಂಟ್ ಇಡ್ರಿ, ಬರ್ಕೊಳ್ಳಿ. We will arrest him and we will allow the petition also. ಬರ್ಕೊಳ್ಳಿ. Counsel for the appellant wife submits that dues to a sum of rupees 2,50,000 approximate 2 lakh.
According to me it's 5 lakh around, my lords.
Rupees 5 lakh.
According to my calculation 2 lakh lord ಬರ್ತದೆ.
5 lakh is due and the husband has not paid it. First, learned counsel appearing for the respondent husband says that about a sum of rupees 2 lakh plus is due. ಯಾವಾಗ ಪೇ ಮಾಡ್ತೀವಿ? ನಾಳೆ ಪೇ ಮಾಡ್ಬೇಕದ್ನ.
Day after tomorrow, Friday lord. On Friday present ಲಕ್ನ ಅಡ್ವೈಸ್ ಮಾಡ್ತಪ್ಪ.
Same shall be paid within before the next date of hearing. call this matter on 17th.
Please.
The respondent husband is put to warning that in the event the amount due is not remitted to the bank account of the appellant wife, he runs the risk of arrest and detention.
17th party may present in the month. 17th.
ಅವ್ರು ಬಂದ್ರೆ ಮೋಸ್ಟ್ ವೆಲ್ಕಮ್. ಬೇರೆ ನಾವು ಪಾರ್ಟಿ ಸಲುವಾಗಿ ಅಷ್ಟು ಟೈಮ್ ಕಳೆದು ಬಿಟ್ರೆ ಬೇರೆ ಕೇಸ್ಗಳು ನೋಡ್ರಿ 15-14 ಮಂದಿ ನಿಂತ್ಕೊಂಡೇವಿ.
It is better to
ಬರೇ
not the-
ಮೆಟ್ರಿಮೋನಿಯಲ್ ನಲ್ಲೇ ಹೊಂಟದ ನಮ್ದು ಫ್ಯಾಮಿಲಿ ಕೋರ್ಟ್ ಆದಂಗ ಆಗಿದೆ. ಹೋಗಿ ಹೇಳಿ ಅವರಿಗೆ ಅವ್ರು ಕೊಡ್ಲಿದ್ರೆ ಮಾತ್ರ ನಾವು ವಿಲ್ ಡೈರೆಕ್ಟ್ ಹಿಸ್ ಅರೆಸ್ಟ್ ಅಂಡ್ ವಿಲ್ ನಾಟ್ ಲೀವ್ ಯು. ವೇರ್ ಅಮೌಂಟ್ ಈಸ್ ಡ್ಯೂ, ಫಸ್ಟ್ ಥಿಂಗ್ ಯು ಶುಡ್ ಡೂ ಇಸ್ ಪೇ ಇಟ್, ದೆನ್ ಆರ್ಗ್ಯೂ ಯುವರ್ ಮ್ಯಾಟರ್.
It's better candidate let them present before the party also.
The parties are directed to be present before the court on the said day.
Please, your lords.
Okay.
The complaint.
Appear for city corporation. This is with regard to my lords, formation of the road without acquisition of the land. Earlier round of litigation, my lords, petitioners had approached this honorable court before learned single judge for consideration of their representation. And learned single judge had directed to consider their representation in accordance with law. Accordingly, my lords, thereafter contempt was initiated. In the meanwhile, one of the previous commissioner of the city corporation, notes, without noticing certain facts, had sent a proposal to the state government to seeking permission of the state government for acquisition of the road. Facts of the case are this, my lords. Belagavi city was chosen under the, my lords, smart city project.
ಅದೆಲ್ಲ ಬಿಡಿ.
ಇಲ್ಲ
ಆರ್ಡರ್ ಕಂಪ್ಲೈ ಆಗಿದೆಯಾ ಇಲ್ಲ? ಈ ಆರ್ಡರ್ ಬೇಕು ಅಂದ್ರೆ ನೀವು ಚಾಲೆಂಜ್ ಮಾಡಿ.
ಎಸ್, ಅದಕ್ಕೆ ಸ್ವಲ್ಪ ಯಾಕಂದ್ರೆ
You have filed a revive application, my lord. Since earlier point of time,
that is what
you have filed affidavit.
I'm coming to that also, my lords. I'm coming to that. Before that,
Para number 3 of the order passed by this honorable court.
Before that, my lords.
And last occasion also they have given.
ಏನೋ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. You should allow, he is very good gentleman. The concession to the friendship you should allow first, please.
Lords, what has happened?
Camaraderie.
What has happened is, my lords, this road was formed by the smart city corporation without the consent of the district administration, state government, or city corporation Belagavi, my lords. And there was, my lords, proposed road in the CDP. It was not at all a road. Despite of that, my lords, smart city corporation had formed the road, and they are also party to this contempt proceedings, my lords. They are also party. And in this case, earlier commissioner had sent a proposal under wrong notion that, my lords, this is road formed by the corporation. This is one aspect.
When that happened?
This was happened, my lords, in the year 2022, my lords. In the year 2022, my lords.
2022,
my lords. Two. And thereafter, one more thing, what is we noticed is, my lords, in the CDP road, proposed road is also, my lords, it is very straight road. But smart city has completely deviated the road.
ಅದೆಲ್ಲ
ಅಲ್ಲ,
ಪ್ರೈವೇಟ್ ಲ್ಯಾಂಡ್
ಹೌದು,
ಪ್ರೈವೇಟ್ ಪರ್ಪಸ್ ಯೂಸ್ ಆಗಿದೆಯಾ ಇಲ್ಲ?
ಅದನ್ನೇ ಅವರು ಡಿವಿಯೇಟ್ ಮಾಡಿ, ಇವನ್ ಇನ್ಫ್ಯಾಕ್ಟ್ ದೇ ಹ್ಯಾವ್ ಡಿವಿಯೇಟೆಡ್ ದಿ ಸಿಡಿಪಿ ರೋಡ್ ಆಲ್ಸೋ, ಪ್ರಪೋಸ್ ಸಿಡಿಪಿ ರೋಡ್ ಆಲ್ಸೋ ದೇ ಹ್ಯಾವ್ ಡಿವಿಯೇಟೆಡ್ ಇಟ್.
ಅವ್ರಿಗೆ ವಾಪಸ್ ಕೊಟ್ಬಿಡಿ ಲ್ಯಾಂಡ್.
ಇಫ್ ದಟ್ ಈಸ್ ಸೋ, ಮೈ ಲಾರ್ಡ್ಸ್, ನಾವು
ಅಲ್ಲ ಈಗಾದ್ರೂ ಕೊಟ್ಬಿಡಿ.
Please,
file an undertaking.
ಇಲ್ಲ, undertaking also, that also I will file, my lords. That also I will file. Some, my lords, 1 week's time of breathing time will be granted because for narrating entire facts.
There is an order of the court.
Yes, certainly, my lords.
Any narration.
We have to.
Any narration which runs counter to the judgment of a court,
please,
is no narration to us. He does not want story. He wants his land back. In the alternative, he wants the money for his land. ನೀವು ಆ ಆಫೀಸರ್ ತಪ್ಪು ಮಾಡ್ಯಾನೆ, what he wants to do. He says, ನನ್ನ ಕುರಿಗಳನ್ನು ಅವ್ರು ತಗೊಂಡು ಹೋಗ್ಯಾರಪ್ಪ, ಕುರಿ ದುಡ್ಡು ಕೊಡಿಸ್ರಿ, ಇಲ್ಲ ಕುರಿ ವಾಪಸ್ ಕೊಡ್ರಿ ಅಂತ ಹೇಳಿ.
May I seek on Tuesday?
ಅಲ್ಲ, ಅದಕ್ಕೆ ಪರ್ಪಸ್ ಹೇಳಿ. ಟ್ಯೂಸ್ಡೇ ಅಲ್ಲ, ಇನ್ನು ವೆನಸ್ಡೇ ಕೊಡೋಣ, ಮತ್ತೆ ಕ್ಯಾಲೆಂಡರ್ ಏನದೇನು ಇನ್ಎಕ್ಸಾಸ್ಟಿಬಲ್ ಇರ್ತದೆ, ಇನ್ನೊಂದು ದಿವಸ ಕೊಡೋಣ ಅಂತ. ಯಾವ್ದ್ರ ಸಲುವಾಗಿ ಹೇಳಿ?
Only
ಆರ್ಗ್ಯುಮೆಂಟ್ ಅಲ್ಲ.
ಅಲ್ಲ, for the whether we can hand over it to my lords now itself. hand over the land ವಾಪಸ್.
And opus and for the damage and all this.
ಅದೆಲ್ಲ ಮತ್ತೆ ಕೊಡ್ಬೇಕಲ್ಲ, ಅದನ್ನು
For that, my lords,
ಈಗ suppose if the robber returns the robbed item, he is liable to pay for that. Robbery does not come to an end once the stolen or robbed goods are returned to the owner. ಇಷ್ಟು use ಮಾಡಿರಿ ನೀವು.
my lords, what has happened? One more thing, my lords. Similarly placed persons had approached this honorable court in other writ petitions. This honorable court directed the Deputy Commissioner Belagavi to hold the enquiry whether this was done by the city corporation or smart city corporation, and direct the, my lords, person who has done this to pay the compensation. Accordingly, my lords, Deputy Commissioner held the enquiry, wherein Deputy Commissioner held that it is work done by the smart city corporation and they are liable to pay the compensation. Against that order, my lord, smart city had approached this honorable court in the writ petition. Writ petition is dismissed. That has attained finality, my lords.
ಏನು ಉಪಯೋಗ, ಇವ್ರಿಗೇನು ಉಪಯೋಗ ಅದರಿಂದ?
ಇಲ್ಲ, this is how, and in fact, all work is done by them.
ಯಾಕೆ ಇಷ್ಟೆಲ್ಲ ಆರ್ಗ್ಯುಮೆಂಟ್ ಅಂತ ನಂಗೆ ತಿಳಿತಾ
ಇಲ್ಲ, I wanted to bring the facts, that's all.
Very well.
Please.
Many facts you can bring to our notice is one thing.
Please.
Question is, the citizen has lost his property.
How?
And property is a constitutional guarantee.
True, my lords. Certainly.
Constitutionally guaranteed.
Certainly.
If you take that property without due process of law, it is called land robbery. It is called land robbery. Macaulay did not coin that word, but we will coin that term. Macaulay confined it to only articles and movable property.
Certainly.
There can be robbery of private land also by
Certainly.
government and governmental authority.
In fact, my lords, in fact, what has happened is,
that is one thing.
Please.
Why we closed the earlier proceeding, contempt proceedings?
Earlier contempt proceeding. Yes, my lord.
Affidavit is given.
Affidavit is given by
Have
the
you taken action against the officer who gave the affidavit?
No,
Perhaps you have given him promotion also.
assistant commissioner. Assistant commissioner.
Is he opposite?
ಇಲ್ಲ, he is not our officer. Assistant commissioner.
All right. Did you tell others, ನೋಡಿ ಈ ರೀತಿ ಕಂಟೆಂಪ್ಟ್ ಇದರಲ್ಲಿ ಹಿಂಗೆ ಹಾಕಿದ್ದಾರೆ, ಅದು ತಪ್ಪಿದೆ, ಅದನ್ನ I want to resile from that affidavit, kindly permit us to withdraw the affidavit. ಏನಾದ್ರೂ ಒಂದು ಪ್ರೊಸೀಡಿಂಗ್ ಆಗಿದೆಯಾ? ಆ ರೀತಿ ಎಲ್ಲ ಹೇಳ್ಬೇಡಿ. ನೆಕ್ಸ್ಟ್ ಡೇಟಿಗೆ ಒಂದು ಡೇಟ್ ಕೊಡ್ತೀನಿ.
With your lordship's permission, my lord.
ಹಾ.
With your lord, last time what they have submitted before the honorable court may please be considered. They have said that corporation is going to hold the meeting of the general body and take approval for 20 crores, and they said that 20 crores is approved. They have taken this date to deposit that amount and show to before this honorable court.
Everything I want. Everything, my lord. I have placed the, my lord's resolution before this honorable court. That is on record.
ಏನಂತ ರೆಸಲ್ಯೂಷನ್ ಪಾಸ್ ಆಗಿದೆ?
What has happened, my lords? 20.
ಯಾಕೆ ಹೇಳ್ತೀರಿ? ರೆಸಲ್ಯೂಷನ್ ಕಾಪಿ ಕೊಡಿ.
I have produced, my lords.
ಎಲ್ಲಿದೆ?
Already it is along with the memo I have produced. It is not that I have not produced. ಇಲ್ಲ, open court 2980.
ಅಲ್ಲಿ ನೋಡಿ ನಿಮ್ಮ affidavit ನಲ್ಲಿ we will acquire this property in accordance with law ಅನ್ಕೊಂಡು ಹೇಳಿ.
Dr. ರುದ್ರೇಶ್ ಗಾಳಿ. On oath he has said.
Yes,
Please read para 6.
ಹೌದು, ಹೇಳಿದ್ದಾರೆ.
ಮತ್ತೆ ಈ ಆರ್ಗ್ಯುಮೆಂಟ್ ಬೇರೆನಾ?
ಇಲ್ಲ, ಆರ್ಗ್ಯುಮೆಂಟ್ ಅಲ್ಲ. ಇಲ್ಲ, ಕಾಂಟ್ರರಿ ಅಂತಲ್ಲ. ಇಲ್ಲ, ಕಾಂಟ್ರರಿ ಅಂತಲ್ಲ. I wanted to bring the entire facts and my lord seek the leave of this honorable court. That is why I wanted to clarify each and every fact, my lords. This is how what has happened. One more thing, this aspect, my lords. Another aspect, my lords.
ನಿಮ್ಮ ನೀವು ಅವತ್ತು ಲಾಸ್ಟ್ ಟೈಮ್ ಹೋದಾಗ ಹೇಳಿದಾಗ
ಹೌದು
Mr. KL Patil is writing, just we refreshed our memory.
Yes, my lords.
ರೆಕಾರ್ಡ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀವಿ.
ಇಲ್ಲ, entire thing was not recorded. It was oral.
And record now everything is recorded. Everything is recorded now.
Yes, he is right in saying so, my lords. He is right, my lords.
All right. What happened to that?
Yes, my lords. Subsequently, my lords, we noticed this entire road is deviated, and it was not at all done by us. It was not at all at our instance.
Mr. Patil, KL Patil.
My lord, yes, my
will
lord.
you be happy to take the land back with damages?
Yeah, but which damages? That's the lord. Let them pay, give it with damages. Because they are playing, my lord. They are playing with the court. One time they say we will take, we want 3 months. One time 6 months. They have taken approval of the government also.
With that regard, whether we can, my lords, hand it over on.
Whether
ಅಂದ್ರೆ how to
argument
ಮಾಡಂಗಿಲ್ಲ. Argument ಮಾಡಂಗೇ ಇಲ್ಲ. Argument ಮಾಡಂಗೇ ಇಲ್ಲ, sir. I will say.
We have heard this matter at length. on two occasions. On two occasions. First, it's a case involving arguments and arguments and arguments. First, that will not yield any milk to the victorious litigant, the complainant in the CC. First, two entities, both being governmental, are passing on the buck. But first, that is not a happy thing to happen in a welfare state which has taken the land in question sans acquisition process. First, we do not call it right now as a robbery of the land of the citizen. First, in KT Plantations versus State of Karnataka, the apex court said no private land can be taken for public purpose without paying compensation. In as much as private property is, right to private property is guaranteed to the persons. Persons or citizens? Persons. Constitutionally guaranteed. Person, under Article 300 capital A. First. Next paragraph. The contempt proceedings were dropped acting upon the affidavit of an assistant commissioner sworn to on so and so, specifically stating that the acquisition proceedings would be now initiated so that in lieu of land, the owner thereof would get the recompense. First off. Now, only cock and bull story is being told to us. And we do not buy it. First off. At this stage, Mr. K.L. Patil, learned counsel appearing for the complainant, assisted by Sri Sidhu so and so, submits that he does not want any other headache with the authorities, semicolon, whatever has happened, happened. Now, let the authorities revert the land. Revert the land. First, panel counsel appearing for the land, coupled with damages
And
for
preserving
it for all these years.
Yes.
All these years. First off, there is a sense in this submission. First off. Next paragraph. At this stage, the panel counsel appearing for the answering respondent seeks some accommodation to confer with his client and come back. Call this matter on Tuesday. Tuesday?
One more
Same day, no further arguments are agreed to be not advanced.
One more submission.
Yes.
One, to avoid technicalities, new commissioner's name may be implemented so that he can file an affidavit, my lords, because now the person who was commissioner is changed, my lords.
We notice that we are told at the bar that now the new commissioner of Belgaum City Corporation, there is a new incumbent in the office of the commissioner of Belgaum City Corporation. The earlier incumbent having demitted, left the office. First off. Therefore, we direct the complainant to array the new commissioner by name as respondent number.
Number 2 ನೇ ಇದೆ.
ಅಲ್ಲಿ replace.
ಅವ್ರನ್ನೂ ಇಡ್ತೇವೆ ನಾವು.
Please.
ಅವ್ರನ್ನ ಬಿಡಲ್ಲ.
Number 4.
Respondent number 4. Respondent number 4. First off, learned panel counsel Chetan on our request accepts notice for.
He is present.
He is present also.
He is present here.
Yes, yes. His presence is ordered already.
Accepts notice in the presence of, in the personal presence of the said commissioner before the court.
Please.
ನಮ್ಮ ಡಿಸ್ಕಷನ್ ಎಲ್ಲ ನೋಡಿರಿ ನೀವೀಗ ಅರ್ಥ ಆಗಿದೆ. ನಾವೇನ್ ಮಾಡ್ತೀವಿ ಅನ್ನೋದು ಅರ್ಥ ಆಗ್ತದಾ?
His presence may noted.
Who is present ಅಂತ ಬಂತ?
Please. Oblige. Assistant Commissioner is also present.
Assistant Commissioner is also present. We have noted the presence of Assistant Commissioner also.
Please.
Who has issued the who has issued the notification, my lord?
Let us see. Okay.
Yes.
Assistant Commissioner, Shri so and so is personally present, and it is he who had issued a earlier notification, Assistant Commissioner.
Land acquisition notification subsequent.
All. Call this matter on Wednesday. The Commissioner shall be present, personally present before the court on that day.
Please.
Yes.
Notice on I-1 of 24 as well as on May.
ಏನ್ ಶಟ್ರ ಇದು?
Filed my lord application for
The
getting the interim order. my lord.
order, interim order has been passed after hearing the both the parties. And first respondent, my lord, seeking for her promotion to the post of Anganwadi worker from the post of Anganwadi helper. Helper to Anganwadi worker. She made a representation. Her representation was rejected on the ground that she is not having the requisite qualifications. And that order has not been challenged. In the meantime, the government, in pursuance of the government order, enabling the married
Transfer order alva ಅದು.
transfer order, my transfer order has been questioned by her. On the ground that, she made a request for promotion. And learned single judge passed an order saying that directing the authorities to consider the representation made by her for promotion and set aside the order of my transfer from one place to another place without any assigning any reasons. Why
ಎಷ್ಟು ನೀವು ಟ್ರಾನ್ಸ್ಫರಬಲ್ ಜಾಬ್ ಇದು?
it's it is as a one time measure in view of the government policy which enables the married lady to transfer to her to her marital place. Well, that what made, and that order has been challenged by her on the ground that she is entitled for the promotion to the Anganwadi worker. Well, it is
May I make- Lord, the respondent one.
ಅಲ್ಲ ನಿಮ್ ಪ್ರಮೋಷನ್ ಏನಿದೆ ಕನ್ಸಿಡರ್ ಮಾಡ್ಕೊಳ್ಳಿ.
Please, please.
ಇವ್ರನ್ನ ಡಿಸ್ಲಾಜ್. Why are you disturbing his apple cart?
Please, my lord. My lord, the respondent one, my lords, appointed as a Anganwadi helper in 2012. My lords, 2022 a notification was issued for promotion. I made a representation, my lord. My application was rejected on the ground that I am not passed in general science and general maths in SSLC exam.
That is quashed now.
That is, my lord, please. Now, my lords, on that ground, my lords, it was rejected. Then, my lords, again I made a representation requesting to, this would not be ground to, my lords, reject my application. Thereafter, my lords, Annexure L, the concerned authority has, my lords, informed me that you go approach the state government and clarify whether I am entitled or not. Please, my lord. Then, my lords, Annexure L was, my lords, issued that, my lords, I have to be considered as a promotion. In the meantime, he has been transferred to the my place, my lord,
Not-
where I
Are you
have to be promotion,
Are you promoted?
not promoted, my lord.
Let them consider you wherever vacancy arises, they will post
Lord,
you.
Anek
Why
jari-
he should be disturbed?
Annexure L, please, my lord, for a moment.
ಎಂತದ್ರಿ ಏನಿದೆ ಎಂತಕ್ಕೆ what kind of
Page 65, my lord.
ಸಪೋಸ್ ಇದನ್ನ ಕ್ವಾಶ್ ಮಾಡ್ತೀರಿ ಟ್ರಾನ್ಸ್ಫರ್ ಕ್ವಾಶ್ ಮಾಡಿರಲ್ಲ ನಾಳೆ ಫಾರ್ ಎನಿ ರೀಸನ್ ದೇ ಡೋಂಟ್ ಗಿವ್ ಯು ಪ್ರಮೋಷನ್ ಎಟ್ ಆಲ್
ಅದಕ್ಕೆ
ವಾಟ್
ಇವ-
ಶುಡ್ ಹ್ಯಾಪನ್ ಟು ದಟ್
Now, my lords, they have considered it, my lord. Interim order, my lords.
ಕನ್ಸಿಡರ್ಡ್ ಅಂಡ್
And to that particular post, my lord, there is no vested right.
ಅದೇ ಕನ್ಸಿಡರೇಷನ್ ರೈಟ್
For any post, my lord, available.
Anticipated promotion or
how you can upset his apple cart ಅಂತ
Because, my
ನಾನು
lord,
ಕೇಳ್ತಾ ಇದ್ದೀನಿ.
during pendency of my application, my lord, this promotion was taken.
All right.
Transfer has
What-
taken place.
what is your right?
But it was, my lords, clarified the state government that I am entitled, my lords, the Annexure L, my lord.
ನೋಟಿಸ್ ಹಾಕಿದ್ದು ಆಗಿದೆಯಾ
ಇಲ್ಲ ಆಗಿದೆ. Interim order has also been issued.
ಎಂಟ್ರಿ ಮಾಡಿದೆ ಬಿಡಿ ಮತ್ತೆ ಎಂಜಾಯ್ ಮಾಡಿ
My lord,
ಅಡ್ಮಿಟ್ ಕಾಲ್ ಇನ್ ಯೂಶುವಲ್ ಕೋರ್ಸ್
my lord,
How
page
can you
number
be upset?
20, 21, one.
ಅದು come after reading
ಅಲ್ಲ, ಅದರಲ್ಲಿ one para, my lord.
what is your right
ಅಲ್ಲ, ಅದರ
to
learned single
upset
judge
him?
order.
I will not read. You tell it. You are there to argue the matter. ಎಲ್ಲ ನಾವು ಒದಕೆ ಮಾಡಂಗಿದ್ರೆ ನೀವೇ ಅದಕ್ಕೆ ಬೇಕು ಬಾರಿಗೆ
Please.
question is in service law your right is to have your case considered, nothing beyond that. Number one, it may rectify, it may not also. How can you upset the position of this lady? How? Where is the basis for that? Post in usual course.
Interim order, kindly. please.
Interim order to continue.
That post is still vacated, my lord.
ಯಾವ್ದು?
Where the, my lord, the.
Or he will occupy that. Na?
ಅಲ್ಲ, ಅದು.
Let, my lord, the government may consider, my lord,
where
I am not coming in the way. From, I am transferred from one to place.
Pendency.
It has been clarified.
my promotion is now considered, wherever vacancy is post me there.
ಏನೇನ್ aspects ಇದಾವ ಅಂತ ಏನ್ ಗೊತ್ತಾಗುತ್ತೆ ಅಲ್ಲಿ ಏನೇನಿದೆ ಅವ್ರು ಅಷ್ಟು ಬೇರೆ ಇರಲ್ಲ ಅದು.
What, my lord, my
ಹೌದು,
friend is
ಅವ್ರು
saying.
consider ಮಾಡಿ
ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ,
Under the rules, my lord, the Anganwadi worker, if he is retired or vacancy ಆದ್ರೆ, the persons who are working in a helper ಅಂತ ಅವ್ರನ್ನೇ instead of appointing a new appointment.
ಅಪ್ಗ್ರೇಡ್ ಮಾಡಿಬಿಡ್ತಾರೆ.
ಅವ್ರನ್ನೇ ಮಾಡಂತ ರೂಲ್ಸ್ ಇದೆ.
ಮತ್ತೆ ಇವ್ರಿಗೆ ಇವ್ರನ್ನ ಯಾಕೆ ಡಿಸ್ಟರ್ಬ್ ಮಾಡ್ತಾ ಇದ್ದೀರಿ?
ಅದ್ರಲ್ಲಿನು ಅದೇ ಅಂಗನವಾಡಿ ಸೆಂಟ್ರಿಗಲ್ಲ ಮತ್ತೊಂದು ಅಂಗನವಾಡಿ ಸೆಂಟ್ರಿಗೆ ಪ್ರಮೋಷನ್ ಕೇಳ್ತಾ ಇರೋದು.
Annexure A, my lord, for.
Who are residing within the kilometers of 3 kilometers ಅಲ್ಲಿ ಯಾವುದೇ ಅಂತಂದ್ರೆ ಅದ. According to him, she made a representation that there is one post for vacant, consider promoting to as Anganwadi worker ಅಂತ. That was rejected on the ground that she is not fulfilled the condition. Qualified ಅಂತ. Meanwhile, we have given a transfer, J. Shetty sir. That was challenged.
Spousal transfer ಅನ್ನೋದು.
Yes,
Spousal transfer ಅದು. Spousal.
Yeah. Meanwhile, that is the reason we have transferred her. Meanwhile, she challenged rejection of her candidature. The learning single is allowed the writ petition.
We don't understand the logic at all. What is that logic? ಅದಕ್ಕೊಂದು ಸಂಬಂಧನೇ ಇಲ್ಲ. Correlative ಇಲ್ಲೇ ಇಲ್ಲ ಅಲ್ಲಿ.
ಅದೇ post ಗೆ now she is claiming as a promotion.
No, you can't say that.
That is not.
You can't say that. You can seek promotion. Is another thing. Where you should be posted, that is decided after the. ಅದೇ ಹೇಳೋದು.
Promotion ಬೇರೆ ಕಡೆ.
ಅದೇ ಹೇಳೋದು ಇಲ್ಲ. Anticipated promotion base ಮೇಲೆ.
We remain as a Anganwadi helper only, my lord. Now I am aged about.
The pendency of this appeal shall not come in the way of candidature of contesting respondent being considered for promotion or otherwise.
There is one observation by the lord, sir.
Promotion and posting to any other place than the one occupied by the appellant herein. Okay.
Earlier workplace is pending, my lord. Still is vacant post, my lord.
ಏನಿಲ್ಲ brother.
ಅದಕ್ಕೆ ಕೊಡಿ ಅಂತ.
I appear for appellant, my lord. This is wife's appeal, my lord.
Wife's appeal.
Challenging the ex parte divorce decree passed by the trial court, my lord.
Ex parte is granted.
Please,
Delay, yeah?
please, my lord.
Notice.
Notice
ಯಾರು ಸರ್ವಾಗಿರೇನು? SS ನಿರಂಜನ್.
ಯಾವ್ದು estimate?
ನಿರಂಜನ್ condone ಮಾಡಿ.
Except in the caution, delay of 261 days in preparing the appeal is condoned. Interim order ಏನ್ ಕೊಟ್ಟಿದಾರ? ಏನಾಗಿದೆ?
Please.
Entry ಮಾಡಿದೆಯಾ?
Please, my lord.
ಇದೆಯಾ interim order ಕೊಟ್ಟಿದಾರ?
Please, please,
Granted?
please.
All parties. New act,
Appellant, your lordship.
new act.
New
CR
act.
is engaged with other court, your lordship.
Here, my lord, a connected batch of appeals have been disposed of before this honorable court. Identical cases, my lord.
Dispose of ಆಗಿದೆಯಾ?
ಆಗಿದೆ. The lordship was pleased to dispose of.
ಏನು enhancement
ಹೌದು.
ಕೊಟ್ಟೇವನ?
ಹೌದು.
Learned counsel for the appellant submits and learned HCGP atones that in a substantially similar matter, that is MFA number 104699 of 2023 LAC between
Main appeal is
main
para to
print my print this order. Print this order. All right.
Yes.
ಅದು ಹೆಂಗಿದೆ ಅದೇ ರೀತಿ
GA on exception notice for all.
GA accepts notice.
ನೋಡು ಡಿಲೇ ಇದೆ, ಅದು ಇಂಟ್ರೆಸ್ಟ್ ವೇವ್ ಮಾಡಬೇಕು.
Condone by denying the interest.
Identical order.
Except in the portion being 798 days between the appeal is condoned by denying the interest in the case of appellant succeeding in the appeal.
Order sheet ನಲ್ಲಿ.
Please.
This is same order, you have to reproduce. But this has to be the same thing to check, numbers and all.
Print my
Appellant.
ಹಾ ವಿದ್ಯಾ ಮೇಡಮ್
Yes, I beg of you.
ಏನಿದೆ? You had challenged grant of occupancy also earlier
Yes, Mullahs, I had.
and it was
I had
rejected.
Mullahs in the year 2000, Mullahs by filing Mullahs WP Mullahs 3161,691 of 2000.
That is
Before
rejected.
this honorable court.
Where is that order?
That order I have placed before this honorable court.
74.
Annexure,
74.
page 74, ink page 74, annexure F. ಮಾಡ್ತೀನಿ. Annexure F. Plus the relevant portion at ink page 75, where this court Mullahs has dismissed on the ground holding that you have no locus standi to question it.
So that order will not come in the way.
Yes. Yes, now Mullahs respondent number 2, plus without adjudicating the matter, plus considering the materials, Mullahs documentary and oral statement Mullahs made before him.
All right, we understand. We will tell you the scheme of the act because I have dealt with that Naria judgment I wrote. Under
Yes,
section 44(1), tenanted land as on 1374, agriculture in nature, would vest in the state. So far as vesting is concerned, there is no issue between.
No issue.
It has vested in the state. You are the person who is granted occupancy.
I'm the tenant, my lord.
That's what,
Registered
who has been granted occupancy.
in 1981.
One second. Form 7 you had filed. Application in Form 7 came to be allowed. Occupancy has been granted. Okay. In respect of that, you filed Form 7A
Yes.
seeking grant of the land.
yes, Mullahs, grant.
Where is the land for grant?
No, Your Lordship, may kindly see. I was in possession of the land in question. In fact, Mullahs, before the assistant commissioner also.
That makes
Plus
sense.
a report, a spot inspection report is.
Where is the land for grant? Read section 77 capital A.
Yes.
Buddy. Please see that.
Yes.
48 capital A, read with 44, 45 is
Yes.
grant of occupancy. 77A is not grant of occupancy, but grant
Yeah,
of land itself.
Oh, adral
Now, where is
conferment
the
of
land
occupancy,
available?
here it is grant of land.
Yes.
Yes.
Please read for a
Yes.
moment. Buddy. For making grant, land should avail.
Yes. You just read it.
Read.
Notwithstanding anything contained in this act.
Satisfied after holding such inquiry, deem fit that a person was immediately before so and so was possession and cultivation of land
Yes.
not exceeding 1 unit which has vested in the state,
Yes.
being entitled to be registered
Yes.
under that is 45 to 49, 45 or 49, that relates to 48A only. You did not apply,
Yes.
but you continued in possession.
Yes.
Where did you continue in possession?
Look,
You
Your
should
Lordship.
continue in possession
Yes.
as on which date? What,
As one-
77A is
date
with
of-
effect from
This matter, my lord.
Appointed date is 1374.
No.
As on date of, my lord,
As on-
77A, my lord. As on date of,
27. Yes.
Which is that date?
because, my lord, 1374 itself, I was granted.
Which is the date when 77A is brought on the statute book?
Yes, sir. That is, my lord, the
Yes.
You were
15
not
to
in possession of.
1999, 15 to 1999.
Therefore, you are not
23
in
of
possession.
1998.
You are not in possession.
Plus, Your Lordship, may kindly see, here is a case where, plus, form number 7 was, plus the respondent number 4, who is the so-called tenant, and respondent number 5 are plus the first cousins.
The question
no,
is not
plus-
that. How, where
plus
are you in the
by-
possession of the
plus,
land?
If I am able to show, plus persuade your lordships and my lords show that, in fact, he is not the tenant.
How can that
And
be?
it
How
could,
are you, who should
plus the
decide?
very order passed by the tribunal is without jurisdiction. If I am able to show.
No, that has to be challenged. No, you are challenged and you have failed.
No, no, Your Lordship, kindly see, I have got a fresh cause of action because the liberty is reserved for pursuing my lords, my application in form 7E.
It is not a cause of action. If
Now-
liberty is reserved,
Yes.
it is not a cause of action.
Plus, the first, plus, my writ petition was rejected only on the ground of locus.
Maybe.
Plus, in
That
fact,
you should have challenged.
plus, in fact, my lords, here is a case where, plus fraud has been played on the tribunal.
No,
If I am,
That you have to go before
plus
the
fraud
tribunal.
vitiates everything.
Not that way.
Plus,
Not that,
on the
that was
fa-
the statement which Lord Coke made in very long centuries ago. It is only
No,
very,
no.
very
Yes.
broad proposition, not that way.
Plus, if the fraud, if fraud is apparent on the face of the
You had
Plus,
challenged.
may just say few facts, my lords, leading to this. Respondent number 5, who is the landlord, he, my lords, presents form number 7 on behalf of respondent number 4. Could your lordships kindly see annexure C, my lords?
No,
He
how that-
presents it,
Form 7.
form 7, annexure C.
Yes.
Then, my lords, in
Land
the
is
order
granted
at
to the
annexure
tenant.
C, my lords, if your lordships could see, the order passed by the tribunal, where,
Now you mean to say,
yes,
the Tahsildar, the Assistant Commissioner competent authority, whoever is competent authority, depending upon notification, he should upset land tribunal order
no,
and allow your 7A application.
no, plus, he ought to have, if my lords, he ought to have adjudicated by application in form number 7A.
How?
My lords, on the materials placed before him, and my lords, ultimately, my lords, he could have, he ought to have assigned the reasons.
Not necessary.
He
Now,
ought to,
all right, now we are asking you.
yes,
As on this 77A was brought on statute book, you should have continued in possession.
I was in possession.
Where have
To
you?
show, my lords, your lordship may kindly see para 5 of my writ petition.
Correct. But
I
why
have
did you,
placed-
you should have got protection
Yes.
at the hands of the learned single judge in your challenge to 7, form
Yes.
7 order,
Yes.
tribunal's order. You
Yes.
had challenged and failed,
Now, let's-
whatever be the reason.
Well, subsequently, now I have challenged both before this court in this writ petition. In the present writ petition, plus after rejection of my application in Form 7A, only on the ground. Plus, could your lordship permit us to read Annexure E, my lords? The order passed by the Assistant Commissioner on Form 7A.
Okay, he cannot pass order because land is with the other tenant. And you have challenged that order and you have failed also.
That order is challenged even now.
Manager of Malad.
In the present writ petition also had challenged it.
Which order?
That order was granting occupancy rights in.
You had
his favor.
challenged and failed.
That time it was Millard's on, it was challenged. It was rejected on the ground that you have no locus.
Correct.
Now,
Again you
in
will
view of
challenge.
the fresh cause of action, I have challenged both the orders.
How can that be? You have suffered an order, no?
Plus, could your lordships kindly see, Millards, the order passed by respondent number 2. May I just read that portion of
I
it?
read, we have no other job than reading at all. We read midnight oil, lot of midnight oil we burn. We hear you because you should be heard in the matter. Any love. Any love. Otherwise, nothing.
Idralli, what has happened was injustice is caused to him. Millards, your lordship may kindly see, here is a case where the land tribunal could not have Millards granted occupancy rights. If I am permitted to read
That
Millards
you
annexes.
failed.
ಅಲ್ಲ ಅದರಲ್ಲಿ ತಹಸೀಲ್ದಾರ್ ಹೇಳ್ತಾರೆ ಆಸ್ ಆನ್ 1374 RTC ಇಲ್ಲ ಅವ್ರ ಹೆಸರಲ್ಲಿ ಇಲ್ಲ ಅವ್ರು ಕಲ್ಟಿವೇಟ್ ಮಾಡ್ತಾ ಇಲ್ಲ
Allah correct. But you failed in the challenge.
and yes I had challenged it
You have
but
failed
then
also.
Millards, because of the fresh cause of action,
Which is that cause of action?
Millards, I got a cause of action because the liberty was reserved.
Liberty is
Writ
no
petition
cause
was
of
reserved.
action. There are any number of
Millards,
Justice Dhawan.
otherwise,
of,
Millards,
Allahabad High Court
otherwise,
has said, where court reserves liberty, it should not be
yes,
construed as
otherwise,
cause of action.
otherwise, Millards, there was no point in Millards reserving the liberty.
But this intra-court appeal seeks to lay challenge to a learned single judge's order dated so and so, whereby appellant's WP number so and so has been negative. First off, in the said WP, the appellant had called in question the order of the Assistant Commissioner passed under section 77 capital A of the Karnataka Land Reforms Act 1961. First off. Next paragraph. Learned advocate counsel appearing for the appellant vehemently submits that the occupancy right was granted to the contesting respondents way back in the year 1981 under section 48 capital A of the act and that the appellant had challenged the tribunal's order in WP number 36191 of 2000 and that a learned single judge of this court negatived the challenge wide order dated 20 February 2001. First off. Semicolon. Learned counsel also submits that the said challenge was negatived not on merits of the matter but on the locus standi and the locum of the appellant. Semicolon. Liberty having been reserved, comma, that itself constitutes and therefore the Assistant Commissioner would not have rejected the application filed in Form 7 capital A by her client. First off, many relevant factors having not been noticed by the learned single judge as also by the Assistant Commissioner earlier, there is a plethora of infirmities in the impugned order warranting interference of this court. First off, learned HCJP appearing for the official respondents and learned counsel appearing for the contesting respondent resist the appeal on the submission that the challenge to the land tribunal's order granting occupancy way back in the year 1981 having failed, comma, the land would remain with the person to whom the land tribunal had granted occupancy and therefore no land avails for in favor of the appellant at all. First, counsel, they also notify to the court that the provisions of section 77A were brought on to the statute book with effect from
15/2/1999.
One,
15/2/1999.
19.
dated
15/2/1999.
15/2/1999, and this court in a catena of decisions has held that the minimum requirement is that the applicant in Form 7 capital A has to be in occupation of, in the cultivation of the subject land. First of, so contending, they seek dismissal of the appeal. First, having heard the learned counsel for the parties and having perused the appeal papers, we decline indulgence in the matter, broadly agreeing with the submission made on behalf of the respondents. First of, Section 48 capital A was brought onto the 1961 Act with the effect from 1/3/1974, Wide Amendment Act 1 of 1974, semicolon. It provided for grant of occupancy to a person who holds the agricultural land on lease as on 1/3/1974. First, there is a big process for grant of occupancy at the hands of the tribunal. First, the fact that the tribunal had granted occupancy to the contesting respondents way back in the year 1981 is not disputed, and it cannot be. First, it is so because the appellant himself had laid a challenge to the order of the land tribunal in WP number 3619/1 of 2000 that came to be rejected on
20th
February
20th of February 2001.
20th February 2001. First up, rejection may be on XYZ reasons, semicolon, but rejection remains a rejection in view of decision of the apex court in AR 1992, SC 111, paragraphs 5, 6, 7, Sec 7. First, which says an order may be hypothetically a nullity, semicolon, unless some person challenges it properly and it is set aside in such challenge, the same would continue for all ostensible purposes. First, since it does not have a brand of invalidity on its forehead. First, the apex court went a step further, saying that even when the brand of invalidity is plainly visible on the forehead, still it will be most impeccable of the orders. First, next paragraph. The vehement submission of learned counsel for the appellant that the grant of liberty by the learned single judge in WP number 3619/1 of 2000 itself is a cause of action, and therefore the assistant commissioner and the learned single judge grossly erred in negativing the claim for the grant of the land in respect of which occupancy has been granted to the contesting respondent herein,
had also
cannot
challenged
be
the earlier
accepted. Cannot be accepted as long as the occupancy order has remained intact, having the seal of writ court. First stop. Next paragraph. The other contention of learned counsel for the appellant that a fraud has been played by the contesting respondent in collusion with the landowner, in hand in glove with the landowner, does not merit consideration at this length of time. First up, the oft-quoted statement of Lord Edward Coke that inverts fraud vitiates everything into brackets is too broad a proposition. Full stop. Its invocability and application depend upon several factors, which aspect has been discussed by the apex court in P. Changala Varaya Naidu versus so and so, so and so. Full stop. Merely quoting fraud vitiates everything cannot yield any milk. Full stop. After all, it is not like a mantra. Semicolon. Somebody who is aggrieved by the fraud has to take up appropriate proceedings before the appropriate authority and within the reasonable period. First up, in the above circumstances, we we are of the considered view that this appeal is unmeritorious and therefore is liable to be and accordingly dismissed. Courts having been made easy. ಇದು ನೋಡಿ, ಇದು ಮೀಟಿಂಗ್ ಇದೆ. ಒಂದು ಫ್ಯಾಮಿಲಿ ಕೋರ್ಟ್ ಪಾಸ್ ಓವರ್ ಮಾಡಿದ್ದು ಕೊಡಿ. Yes, what happened?
Now he is ready to take her back. She requires some time to think over and make a submission.
She has agreed to go back. ಮತ್ತೆ ಹೊರಗಡೆ ಹೊಡೆದು ಎಲ್ಲಿದ್ದಾನ ಅವನು? ಎಲ್ಲಿ ಕರೀರಿ? ನೋಡು ಈಗ ಹೆಂಗ್ ಮುಖ ಅರಳಿದೆ ನಿಂದು. ಹೊಡೆದು ಬಡದು ಮಾಡಿದ್ರೆ ಏನ್ ಮಾಡ್ತಾರೆ ಹೆಣ್ಮಕ್ಳು? ಗೊತ್ತಾಗಲ್ವಾ ನಿಂಗೆ? ಮತ್ತೆ ಪೊಲೀಸರೆಲ್ಲ ವಾಚ್ ಮಾಡ್ತಿರ್ತಾರ ಅಷ್ಟನ್ನು. ಅವಳಿಗೆ ಹೊಡೆದು ಬಡದು ಮಾಡಿದ್ದಕ್ಕೆ ಪಾಪ ಲೇಡಿ ಹಂಗೆ ಹೇಳ್ತಾ ಇದ್ದ. ಇಲ್ಲಪ್ಪ ಸುಖ ಸುಮ್ಮನೆ ಯಾಕೆ ಹೇಳ್ತಾಳು ಅವಳು ನಿನ್ ಮೇಲೆ? ಏನಿಲ್ಲ. ಮತ್ ನೀನ್ ನೋಡಿದ್ರೆ ಹಂಗ ಅನಿಸ್ತದೆ, ಹೊಡಿ ಈಗ ಕಾಣ್ತೀಯ ನೀನು. ಪಾಪ ನಾವ್ ಹೇಳಿದ್ವಿ ಅನ್ಕೊಂಡು ಮಗನ್ ನಿನ್ ಕೈಯಲ್ಲಿ ಕೊಟ್ಟು ಆ ಹೆಣ್ಮಗಳು ಒಂದ್ ಸ್ವಲ್ಪ ಪ್ರೀತಿಯಿಂದ ಗೌರವದಿಂದ ನಡ್ಕೋಬೇಕು ಹೆಂಡತಿ ಜೊತೆ. ಅಲ್ಲಿ ಕುಡ್ದು ಬಂದ್ಕೊಂಡು ಹೊಡೆಯೋದು ಬಡಿಯೋದು ಮಾಡಿದ್ರೆ ಏನ್ ಮಾಡ್ಬೇಕು ಹೆಣ್ಮಕ್ಳು? ಬಹಳ ಒಳ್ಳೆ ನೀನು ಮಾತಾಡ್ಬೇಡ ಹಂಗೆಲ್ಲ. ಮಗುನ್ ಕೈಯಲ್ಲಿ ಇಟ್ಕೊಂಡು ಮಗು ಶಾಪ ಕೊಡ್ತದ ನಿನಗೆ. ಯಾವತ್ ಕರಿಬೇಕು? ಹೋಗ್ತೇನಮ್ಮ ಈಗ? ಅವ್ರ ಜೊತೆ ಹೋಗ್ತೀಯಾ? ಹೋಗ್ಬಾ. ಏನ್ರ ಆಯ್ತು ಅಂತ ನಮ್ಗೆ ಬಂದ್ ಹೇಳಿ. ನೋಡ್ ನಾವೇನ್ ಮಾಡ್ತೇವೆ ಅವನಿಗೆ ಅಂತ. ಹೋಗ್ಬಾರ್ದು ಅಂತ ಡಿಸೈಡ್ ಮಾಡ್ಕೊ. ಯಾರು ಹೇಳಿದಾರೆ ನಿಂಗಿದೆ ಹೋಗ್ಬೇಡ ಅಂತ? ಅಮ್ಮ ಹೇಳ್ಯಾರ? ಯಾರು ಏನೇ ಡಿಸಿಷನ್ ತಗೊಂಡಿಯಾ? ಚಿಕ್ಕ ಡಿಸಿಷನ್ ಅದು. ಎಲ್ಲಿ ತಂದೆ ತಾಯಿ ಇದಾರ? ಎಲ್ಲಿದ್ದಾರೆ? ನೆಕ್ಸ್ಟ್ ಡೇಟಿಗೆ ಕರ್ಕೊಂಡ್ ಬರ್ತೀರಾ? ಹುಷಾರಿಲ್ಲ. ಯಾರ್ಯಾರಿದ್ದಾರೆ? ಅಮ್ಮ, ಅಪ್ಪ, ಅಣ್ಣ ಎಲ್ಲ 3 ಜನರಿಗೆ ಹುಷಾರಿಲ್ವಾ? ಕರ್ಕೊಂಡ್ ಬರ್ಬೇಕು ನೆಕ್ಸ್ಟ್ ಡೇಟಿಗೆ. ತಂದೆ ತಾಯಿನ ಕರ್ಕೊಂಡ್ ಬರ್ಬೇಕು. ಏನಮ್ಮ? ತಂದೆ ತಾಯಿ ಮತ್ತು ಅಣ್ಣನ್ ಕರ್ಕೊಂಡ್ ಸರಿನಾ? ನೀನು ನಿನ್ ತಂದೆ ತಾಯಿ ಕರ್ಕೊಂಡ್ ಬರಯ್ಯ. ಆಮೇಲೆ ಸರಿಯಾಗಿ ನಡ್ಕೋ ಮೊದ್ಲಿಗೆ ಹೆಣ್ಮಕ್ಳ ಜೊತೆ. ಏನು ಅವ್ರ ಜೊತೆ ಹೆಂಡತಿ ಮಕ್ಳ ಜೊತೆ ಗುಂಡಾಯಿಸಮ್ ಮಾಡ್ತಾರನ? ಅಷ್ಟು ತಿಳಿಯಲ್ವಾ ನಿನ್ಗೆ? ಕಾಲ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 19 19 ಕರಿಬೋದಾ ಅಥವಾ ಇನ್ನೊಂದು ಸ್ವಲ್ಪ ಟೈಮ್ ಬೇಕಾ? ಇನ್ನೊಂದು ಸ್ವಲ್ಪ ಟೈಮ್ ಬೇಕಾ? 24ನೇ ತಾರೀಕು ಕರ್ಕೊಂಡ್ ಬರ್ಬೇಕು. ತಾಯಿನ ಅಣ್ಣನ್ನ ಕರ್ಕೊಂಡ್ ಬರ್ಬೇಕು. ನಿನ್ಗೆ ಯಾರಿದ್ದಾರೆ? ಅವ್ವ ಅಣ್ಣ. ಎಷ್ಟು ಜನ ಅಣ್ಣಂದ್ರಿದ್ದಾರೆ? ಒಬ್ಬನೇ. ಅಣ್ಣನ ಕರ್ಕೊಂಡ್ ಬರ್ಬೇಕು ನೀನು. Parties assure their personal presence on the next date of hearing along with their parents stroke elders for working out an amicable settlement. Full stop. This is appreciable. Full stop. The appellant has spent happy times with the ward. In ಹೆಸರು? ಚಿರಂಜೀವಿ ಭರತ್. ಏಜೆಡ್ ಎಷ್ಟು ವಯಸ್ಸು? 1.5. ಏಜೆಡ್ about 1.5 years. ಫಸ್ಟ್ ಸ್ಟಾಪ್. ವಾಪಸ್ ಕೊಡು ಮಗುನ. ಮತ್ತೆ ಬರಿಬೇಕಲ್ಲ ನಾವಿಲ್ಲಿ. ಮತ್ತೆ ನಾವು ಕಳ್ಸೇವಿ ಅಂತ ಅಷ್ಟ ಆಗ್ತದೆ. ಹೊರಗೆ
Serial number 43, Lordship. My lords have heard this matter.
Interim order.
Day after tomorrow.
Tomorrow. ನಿಮ್ 4 weeks ಟೈಮ್ ಕೊಟ್ಟಿವಿ ನೋಡಿ.
ಅಲ್ಲ ಮೈ ಲಾರ್ಡ್ಶಿಪ್ 23 ಅಲ್ಲಿ ರೂಲ್ 23 ಅಲ್ಲಿ ಟ್ರಾನ್ಸ್ಲೇಷನ್ ಏನ್ ಬೇಕಿಲ್ಲ, ಎವಿಡೆನ್ಸ್ ಟೈಮ್ ಅಲ್ಲಿ ಬೇಕು ಅಂತಿದೆ. Lordship.
ಯಾವ್ದು?
Rule 23 of election petitions procedure rules, Karnataka, my Lordship.
ಸೀರಿಯಲ್ ಅಂದ್ರೆ ಡಾಕ್ಯುಮೆಂಟ್ಸ್
23 rule, my Lordship. ಅದನ್ನ I beg to submit that rule, my Lordship.
ಏನ್ ಬೆಗ್ ಮಾಡೋದೇನ್ ಬೇಡ, ನಿಮ್ಮ ಅಧಿಕಾರ ಅದು, ನಿಮ್ಮ ಹಕ್ಕದು.
Where any document in any language other than English is tendered and admitted in evidence, the party tendering the same shall file an English translation which shall either be the official translation or a translation the accuracy of which is certified by an advocate of the High Court. Cause of translation shall be at the discretion of the court, my lordship.
ಅಂದ್ರೆ ಆಫ್ಟರ್ ಎವಿಡೆನ್ಸ್ ಆದ್ಮೇಲೆ ಹಾಕ್ಬೇಕಾಗತ್ತೆ.
During the evidence ಅಲ್ಲಿ ಇದು ಟೆಂಡರ್ ಆದಾಗ ಅದನ್ನ ಬೇಕು ಅಂತ ಹೇಳುತ್ತೆ. ಅದಕ್ಕೆ
ಬೇರೆ ಆಯ್ತು, ಟ್ರಾನ್ಸ್ಲೇಷನ್ ಬೇರೆ ಕಾಪೀಸ್
ಅವು ಅಷ್ಟೇ, ಟ್ರಾನ್ಸ್ಲೇಷನ್ ಮೇಜರ್ ಇರೋದು
ಅಲ್ಲ.
ಅದು ಇದು ಮೆಮೊ ಹಾಕಿದ್ದೀನಿ, ಅಡ್ರೆಸ್ ಕೇಳಿದ್ರು ಮೈ ಲಾರ್ಡ್ಶಿಪ್, ಬೆಂಗಳೂರದ ಅಡ್ರೆಸ್ ಪಿಟಿಷನರ್ದು, ಅದನ್ನ ಅಡ್ರೆಸ್ ಮೆಮೊ ಹಾಕಿದ್ದೀನಿ ಮೈ ಲಾರ್ಡ್ಶಿಪ್, ಎಲ್ಲಾನು ಕಂಪ್ಲೈ ಮಾಡಿದ್ದೀನಿ ಮೈ ಲಾರ್ಡ್ಶಿಪ್.
ಅಯ್ಯ ಅಲೋ ಮಾಡ್ಬೇಕಾಗ್ತದೆ.
ದಟ್ ಈಸ್ ಡಿಸ್ಕ್ರಿಪ್ಷನ್ ಆಫ್ ದಿ ಲಾರ್ಡ್ಶಿಪ್ ಮೈ ಲಾರ್ಡ್ಶಿಪ್.
ಯಾವ ರೂಲ್ ಅದು? ರೂಲ್ ಏನದು?
Rule 23 my lordship.
23 of election.
The election petitions procedure rules Karnataka ಅಂತ ಇದೆ my lordship. Dated 28 March 19.
ಕಾಪಿ ಇದೆನಾ?
ನನ್ನ ಹತ್ರ ಆನ್ಲೈನ್ ಕಾಪಿ ಇಲ್ಲ.
Number 28, may I have it tomorrow, demolition matter.
Demolition 28 ಕೊಡಿ, ನೋಡಿ ಕೊಡಿ.
ಸೀನಿಯರ್ ಮಾಡ್ತಿದ್ರು ಅವ್ರು ಮಿನಿಸ್ಟರ್ ಒಂದೇ ಅಂತ ಶಿಲ್ವಂತ್ ಅವ್ರು ಮಾಡ್ತಾರೆ.
ಇಲ್ಲೊಂದು ಇದ್ರಲ್ಲ ಮತ್ತೆ
ಇಲ್ಲ ಅಲ್ಲಿ ಕೆಳಗಡೆ ಇತ್ತು
ನೋಡ್ರಿ ಕೊಡಿ.
ನಾಳೆ
ಏನ್ ಅಂತ ಇದ್ರು ತಗೊಂಡು ಇಲ್ದೆ ಕೊಡಿ ನೋಡೋಣ. ಡೆಮಾಲಿಷನ್ ಬಂದಾರ?
Demolition notice is been given. My lords, kindly come to my lords page number 110, which is the my lords map. This is the map. 110. And my lords may find the forest, my lords, boundaries represented by my lords square in blue color. Blue color square. They are the
encroachment in the river bed of Kali.
Idu blue color addu, this is the forest boundary surrounding this revenue land. Now the forest, the encroachment is shown after the forest my lords boundary. This my lords survey was conducted after my lords interim order by this honorable court.
ಅಲ್ಲಿ ಅಷ್ಟೇ ಕೆನೋಪಿ ಇದೆ, ಅಷ್ಟೇ ಜಾಗ ಈಗ ಎನ್ಕ್ರೋಚ್ಮೆಂಟ್ ಆಗಿದೆ ಇಲ್ಲ.
Encroachment beyond the forest area.
ಇರ್ಲಿ, ಗವರ್ಮೆಂಟ್ ಲ್ಯಾಂಡ್ ನಾಗ ಎನ್ಕ್ರೋಚ್ ಆಗಿದೆ.
Government land beyond forest land. The forest department wants to demolish it. Temporary my lords, some breathing space.
ಆಯ್ತು, ನಾಳೆ ಅಲ್ಲ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ತೊಳ್ತೇವೆ, ಅಲ್ಲಿ ತನಕ ಏನು ಮಾಡಬಾರ್ದು.
With my lords.
ಮಾಡಿಬಿಟ್ಟು ನಾಳೆ ಸಪೋಸ್ ಇಫ್ ಈ ಸಕ್ಸೆಸ್ ಇನ್ ಅಪೀಲ್ ವಾಟ್ ಶುಡ್ ಹ್ಯಾಪನ್? ಇರಿ ಒಂದು ಎಷ್ಟು ದಿವಸದಿಂದ ಇದೆ ಈಗ?
My lords,
ಎಷ್ಟು ದಿವಸದಿಂದ ಈ ಸ್ಟ್ರಕ್ಚರ್ ಇದೆ?
6-7 years my lords.
ಏನಾಗ
ಮೋರ್ ದನ್ ಯುವರ್ ಲ್ಯಾಂಡ್ ಓನರ್ಶಿಪ್ ಇದ್ದಕ್ಕಿಂತ ಜಾಸ್ತಿ ಕಟ್ಟಿದ್ದೀರಾ ಅಂತ ಹೇಳ್ತಾರೆ.
ಜಾಸ್ತಿನೇ ಇದೆ.
ಬೇರೆ ಸರ್ವೆ ನಂಬರ್ ದಲ್ಲಿ ಕಟ್ಟಿದ್ದೀರಾ ಅಂತ ಹೇಳ್ತಾರೆ.
ಅಲ್ಲ, ಅದು ಪಕ್ಕದ ಸರ್ವೆ
ಫಾರೆಸ್ಟ್ ಇರ್ಲಿ ಬಿಡ್ಲಿ, ನಿಮ್ ಲ್ಯಾಂಡ್ ಅಲ್ಲ ಅದು.
Which is not concerned to us. ಪಕ್ಕದ್ದು it is not concerned to even forest. ನಮ್ದು ಒಂದೇ ಅಂತಂದ್ರೆ it is beyond forest area.
That is no answer.
Of course. But demolition ಬೇಡ.
ಸ್ಟೇಟಸ್ ಕೋ ಮೇಂಟೈನ್ ಮಾಡ್ರಿ, ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ನಾವು ಮಾಡೋಣ.
Please.
Parties are directed to maintain status quo in respect of encroached portion of land.
Please.
Till the next date of hearing, call this matter on 18 or 19 or 21st, 25th.
Great. Great.
My lord, one merciful indulgence, my lord. Serial number 27. The respondent number 1 and 2, along with the respondent number 3 and 5 in this petition, wanting to evict the daughter-in-law from the shared household, my lord. So the matter may be kindly posted tomorrow, my lord.
ನಾಳೆ ಹಾಕ್ಕೊಡಿ.
My lord, serial number 39, my lord. Settlement refer ಆಗಿತ್ತು, ಆಗಿಲ್ಲ. It is absenteeism case, 2011 case, humbly postponed. KSRTC absenteeism dismissed case, Your Honor.
39, my lordship have
39.
directed me to get settled the matter. In fact, my lord, he is retired last June only. They were ready to reinstate him without back wages. Now,
That corporation.
corporation,
you
that
had
approval,
told
approval.
you to look into the matter and
Yes,
advise your
yes,
client,
my
na?
lord. They were ready to reinstate him, but my lord, he retired last June itself.
ಯಾವ ಡೇಟಿಗೆ reinstatement, notional reinstatement ಯಾವ ಡೇಟಿಗೆ ಆಗ್ತದೆ?
Notional ಅಂತಂದ್ರೆ we have to pay him salary. They were ready to extract work from him and pay whatever it is there and continuity of service. Now
Pensionable,
he
no?
retired, pensionary benefits means all monetary benefits we have to give him. For which my lord, he has not worked for my lord long pain, now 10, 15 years.
My
from the
lord, I
date
have
of
the good case
dismissal.
on the merit, my lord.
29.
Humble submission, my lord.
ಅಕ್ಟೋಬರ್ನೇ ಹಾಕಿ.
Humble submission, my lord. Kindly keep it tomorrow, my lord.
Great.
Sriram sir, 45, interim order. 45.